Hello, hello. Let's see here. I think I can be heard. Perfect. Hey, Vicky. What's going on? Victoria. Let's go. What's happening? Hello, hello. How are we? How are we doing? We have a big day today. I think we should probably chat. I'm ready to stream. I am so ready to stream. I think we should chat about some things before we get into it though. I'm good. I'm good. I'm a little sleepy. I'm a little tired, but I'm good. I'm a little tired, but I'm good. Other than that, allergies have not been terrible. Staying up on my Claritin, which I forgot today. Oops, just jinxed myself. My ass is ready. Oh, we have some things. So we just finished yesterday, in a half day. We finished the Commonwealth's case in chief. Got to have that Claritin. I'm telling you, it was rough there for a minute. I was like, I feel like everything is just like exploding out of my body. Like my sinuses, my jaw joints, my nose, like everything was just, we hate it here. But with that Claritin, I would love a Claritin sponsor because that shit's expensive. We have the Commonwealth case in chief has completed. They have rested, and it is now on to, well, before it's on to the defense. They have to do a little arguing, and we're going to watch that today. We can eventually, if more people pop in and want to chat about the final witness, Dr. Welcher, we can. It was an absolute nightmare. It was something that I think Alessi is going to look back on and say, not my best. Not my best. Yesterday, so Dr. Welcher was on the stand for I think like 2.5 days. So yesterday was a half day. It was like a full day of cross before that. It was a full day of direct before that. And so I think, and the Alessi's day of cross was tough. It was tough. It was something that would make me, if I was a juror sitting there, go, can we be done? I need lunch. um it was really tough. It was pull your calculator out and let's do some calculations type shit. And it was not the vibe. There was not winning. The witness himself was tough. He was not letting Alessi get away with anything. And then when it came to yesterday, his half day, Alessi said, I am the captain now. I ask the questions, you answer them, and put your computer away. This expert witness was an absolute nightmare, in my opinion. Was he a successful nightmare? I think for the Commonwealth, there was a little success. I think the half day that the jurors had with the final bits of cross, redirect, recross, I think there was some good solid wins for the defense. But I don't think Alessi is going to go home and say, wow, that was really good. I don't want to say that he shouldn't be proud of it, but I think that he might feel not proud of that cross. It was tough. And I don't think he expected it to be that tough. It even started the very first interaction that Alessi and Dr. Welcher had on the stand was Dr. Welcher saying, oh, I don't think I've had a chance to, properly introduce myself. What's your name? And that's Alessi's job. That's Alessi's job. We've seen that very often. And I mentioned it a couple of times when we see Alessi cross these experts. He starts and goes, hi, congratulations on the fantastic career. It's nice to meet you, like da 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 da. Like he's ready. He's like, hey, you're here, I'm here. Let's do this. And this is my job. And I love doing this. And I respect you and your career and your lifelong goals and etc. So I think that I think that was a clear indication that this witness was not going to be any sort of kind to Alessi. But today we're going to start with some argument. So the defense the Commonwealth have to sort of fight over the, and by fight, I mean argue over the motion to dismiss. Essentially, I call it something a little different in Massachusetts. But in between each Commonwealth, in between the prosecution's case in chief and the defense's case in chief, there is a moment to argue for a motion to dismiss, as if there is not enough evidence for a jury to successfully find guilt. It will always, the decision and the consideration will always lean towards the Commonwealth prosecution. That's just how it goes. It's a slightly different moment when it comes to argument within a trial, that it will always sort of lean towards, inhabit more, consider more of the prosecution, in this case the Commonwealth's argument, case in chief, evidence, thoughts, etc., to continue forward. Will it be denied? Absolutely. Will we hear some things from Jackson that will hopefully show us what he is going to prove in sort of like midterm style during their case in chief? Yes. They will be the ones, the defense will be the ones now calling the witnesses. So their form of question will be open-ended. They will not be able to ask solid yes or no questions, just like Brennan should not have been able to ask solid yes or no questions, except when it comes to like foundation and those types of things. And then Brennan, the Commonwealth, will have time to cross, just like the defense did. So if you are new to sort of like a trial process, that is what is going to be happening. We are on day, I think, like 24. We skipped a few witnesses, we skipped a few stuff. If you have the time and the energy, then I'd say go watch it. There's some stuff, there's some good stuff, there's some really terrible stuff. But yeah, we're gonna get Boot Scootin' and Boogie in. Jury time. What's going on, Ronnie? How are you? Oh man. Let's get going. So we're gonna start with argument. Basically the motion to dismiss between the two cases in chief, and then we are going to hop right into the defense's case in chief. I want to know how the jury's feeling right now. I want to know how the jury went home after that half day. So they had a half day yesterday due to a juror conflict. So someone needed to be somewhere sometime in the afternoon. So they needed to make it a half day. And if Judge Canoni says, hey, it's a half day because this juror needs to be able to do this, this is a 6-7 week trial. Life still needs to happen for these people. They're allowed to be able to do things just like Karen Reed is allowed to have a sick day. Jurors need to have appointments. Don't even get me started on the healthcare system in the United States of America. If you have an appointment 6 months out, and if you cancel it, you're not going to have another one for another year, and you need this appointment. A court judge should be able to accommodate that. Has this jury has some issues? Yes, this jury has had some issues. There's been grumblings. There has been one-on-one meetings with each juror and the judge, due to the possibility of communication between folks, seeing things, watching things, that type of thing. There has been shifting of seats. There's been under breath comments made while entering and exiting the courtroom. This has not been an easy jury. And I think that is a moment to sort of really ingest for the defense. Like, hey, take that into account. This jury is not done asking questions. They have thoughts. They are getting antsy. They want the information now. So yeah, TGIF. I know. It's been a week. How are you? I'm okay. I'm okay. Um, I'm a little tired. I'm a little tired. I'm feeling good because the Knicks won last night when they needed to win. Now they have to win the next 2 games as well. So, but boy, that Knicks game last night was fantastic. I don't know if anyone watched it. Oh my God, it was so good. It was so good. I'm like, finally, they are fighting. They haven't fought. They haven't fought. Oh, the plays that they were, I mean, oh my gosh, the Knicks really showed up and showed out last night, which was definitely necessary because I don't really want my state to completely just disintegrate, because if they lost, I have a feeling that it probably would have just completely disintegrated into mass chaos. So the Knicks making it to the last 2 games of the Eastern Conference Finals is record breaking, and I hope they keep it up. And I hope that I hope they don't get injured. Hope Brunson doesn't get injured. I hope Towns doesn't get injured. I need them. I need them to stay strong. We need to take this. We need to take this. So let's get started into court. I need to set one thing up. I have a muffin, and that's all I have. I will need to, I'm sure we'll be here all day because we get chatting. I will need to get lunch later, but won't we all? We'll need to get lunch. We'll need to take some breaks. It is okay. But now is a great time for like catching up on sort of a rounded moment. So we're watching pretty much live court. We're only like an hour behind, maybe even that. So let's get going. Let's get into it. Let's listen to what Jackson has to say. I'm going to be sort of flip-flopping my sides because no one's on the stand. Jackson will be at the podium. So let's, oh boy. Boot Scoot and Boogie. If we want to know, this is Karen Reed's mother and father. That is them there. And then they're going to go to John O'Keefe's mother there and brother sitting behind him. Next to him back here in the brunette is his wife. So let's see. Get moving forward a little bit. They're at sidebar currently. And when I did my big jug of water.
So I'll hear you whenever you're ready, Mr. Jackson.
Sure. Mr. Jackson is going to be.
Thank you, Your Honor. We filed this morning a motion for required finding of not guilty.
Motion for required finding of not guilty is just a fancy way of saying motion to dismiss. And of course, Massachusetts is fancy. Motion for required finding not guilty. And they do this every trial, and 99.97% of the time it is denied. But it's a great moment to argue.
Procedure 25A. I think that's before the court. My comments will be relatively brief, but it's important, and the points that I'm going to make in the next couple of seconds or next couple of minutes are equally important. It comes down to the following. The Commonwealth has simply not proven, even in a light most favorable to them, that there was a collision on January 29th, 2022 at 34 Fairview in Canton, Massachusetts. There was no collision proven to have occurred. There was no eyewitness presented. There was no video evidence, no audio evidence, no evidence in the form of physical evidence at the scene by searches that were done by officers on the morning of January 29th, 2022. The Commonwealth, through suspect experts, based on circumstantial technical data, only sought to prove a backing event, and that's important. They sought to prove that at 34 Fairview, the SUV went backward. They did not prove, and every single one of their experts was asked this question, they did not prove that there was actually a collision associated with that backing event. The Commonwealth experts said at best that the car went in reverse, and it was suspect whether it went in reverse at 34 Fairview or some other place, time, or date. The Commonwealth also put on an expert who said that she found no injuries, none, mind you, indicative of a vehicle strike on John O'Keefe's body. And she, Dr. Irini Scordibello, was arguably their most important witness. The Commonwealth cannot and did not say or prove a collision at a particular time, a collision at a particular place, a collision with a particular person, or that a collision even occurred on January 29th, 2022 at or around or at or after 12:30 in the morning. Their own expert, I think it was yesterday, if not the day before yesterday, was asked on examination
So many days
by Mr. Alessi, can you tell us the particulars of the collision, pardon me, as you suggested in your testimony? And his answer was, there's simply not enough evidence. He was asked specifically, why didn't you try to recreate the circumstances, the force impact? That's what you do, sir. You're a biomechanic expert. Recreate it for us. And he said, there's not enough evidence. There is evidence, however, that Brian Higgins and Brian Albert were sparring at 34 Fairview. There is evidence, however, that was just minutes, not hours, not days, minutes before John O'Keefe ultimately met his fate at 34 Fairview.
Let's go back. There's evidence that they were sparring at 34. No, they were sparring at Waterfall. Come on, Jackson. We got to get it all
There's
right.
evidence, however, that Brian Higgins and Brian Albert were sparring at 34 Fairview. There is evidence, however, that was just minutes, not hours, not days, minutes before John O'Keefe ultimately met his fate at 34 Fairview. There is evidence that Brian Higgins was love struck.
Those Northeast allergies are they're gonna get these Californians. I'm telling you. If you ain't from here, all that pollen, whew.
That he was jealous, that he was aggressively coaxing John O'Keefe out of the waterfall, that he was passively aggressively coaxing Miss Reed to engage with him rather than John O'Keefe. Again, there's not a single eyewitness to a collision. There was not even a single eyewitness to a backing event at 34 Fairview. The court will recall Jennifer McCabe testified that she basically watched the SUV the entirety of the time it was in front of the location at 34 Fairview with Miss Reed in the driver's seat. She saw it pull up once. She saw it pull up twice.
Yeah, I'm telling you, they're the best. And people who say no, they don't get it. They dissolve. You don't have to swallow a pill. They dissolve. And Ibotta, I should send you a link. I don't know if you use Ibotta. Ibotta is like a coupon app, and they sometimes have fantastic coupons for Claritin, and they always like include the Dissolvey ones. Sometimes you can get like $5-10 back. I'm telling you, the Dissolvey Claritins will save your life if you are struggling with allergies. I am not a medical professional. I am just someone who has struggled with allergies my entire life, and as I get older, they get worse. Slight minty, it's almost a mint. It's almost a mint, and it dissolves right on your tongue, and you're like, oh my God, I didn't even realize I didn't have to suffer. Like I didn't even realize I didn't have to. Yes, I love it. I love it. That makes me so happy. I'm glad you have found some allergy relief and the Dissolve Claritins. I love them so much. I tell everybody, get those Dissolve Claritins. There's something so special about it. There's something so, I don't know what it is. I don't know the science. I don't know the math. And I don't care to know. Just give me my Dissolve Claritin. I'm telling you. I am telling you.
She saw it pull up a third time, and then she saw it was gone. And at no time, did she ever see the car go in reverse. She certainly didn't see the SUV go in reverse at a high speed. And she darn sure didn't see the car go in reverse at a high speed and strike a pedestrian. Her focus was defined enough to see thin tire tracks in a dusting of snow, thin enough, I think the phrase was,
that would be so
to track
sweet.
a cat. That's how detailed she was.
Like a straight up like New York care package. Like, here's some vitamin water, some smart water, some Claritin, and like a Nature Valley granola bar. Like super New York. Oh, that'd be so funny. Here's some Saratoga Sparkling. Yeah. Saratoga Sparkling, by the way, is like the water of the universe. Like, they drink it at like UN meetings. It's like, it is like the chosen water everywhere. Like, I can't tell you, like, I went down like a rabbit hole of looking at these, like, a Stewart's eggnog. Girl. I can't with you in the eggnog. Vicky loves the eggnog. Vicky loves the Stewart's eggnog. Vicky loves it. You know what? My mom loves like the Stewart's like egg salad and like tunas and stuff like that. Loves it. There's something so special about Stewart's. I love a Stewart's. I stand by my man. Go stand by your man. Is this your man? Yeah, that would be really great. That'd be really great to send him a package like, here, we support you. Like a Halls. Just a red bag of Halls. That's so funny. So funny. I went down a rabbit hole of like looking at all these like high level government people, like photos of them and like them drinking water. And it is always Saratoga Sparkling. Always. Your man, eggnog.
She was in her observations, yet she did not see John O'Keefe hit by an SUV. She did not see John O'Keefe's body in the snow, in the yard, laying prostrate, a 216-pound, 6'1" man in the snow, directly in front of the SUV she was tracking the entire time. There are two other witnesses, Ryan Nagel, Heather Maxson. They both noted that John O'Keefe, not that they didn't see him, Your Honor, that John O'Keefe was not in the vehicle when they were behind him. The dome light was on. They could see inside the interior of the vehicle. Miss Reed was sitting there with her hands at 10 and 2, and the passenger seat, notably and markedly, was empty. He was not outside the vehicle. He wasn't standing. He wasn't sitting. He wasn't lying down. There's only one place he could be: inside the curtilage of the home, inside the house, or inside the garage.
Yeah, following that line of thought, yes. Or in the basement or the backyard or in the side yard within the tree line, that type of thing. But I don't think that the Ryan Nagel, and the girl, his ex-girlfriend, which, like, come on, why? Specifically said, we saw the empty seat. We just didn't see if he was in there or not. How crazy would it be if Cannoli was like, you know what, case dismissed? That would literally set the internet ablaze. There would be an immediate parade. But it's not going to happen. But what we did not hear from is Julie Nagel this trial. We did not see Julie Nagel, who was the actual human being who left the house to approach the truck and said, just kidding, I'm not getting in. We're going to stay, and then go back into the house. We did not hear from Julie Nagel. We also did not hear from Ricky. Ricky, when I catch you, Ricky, we did not hear from. Ricky was not called. The human who was actually driving the truck that met Karen and what's his name? John at the intersection, let them go first. The person who was actually driving the truck. And what we did hear from Ryan and Heather was that there was nothing in between them. So it was just them. It was just the truck and it was just the SUV. So where the ever living God fucking hell was the Jeep? Where was Brian Higgins' Jeep? That's something that I want to do. Okay. So can someone write this down for me? I have a pen in my hand. I'm going to also try to remember. I want to go back and watch the Brian Higgins videos of when he went to Canton PD, what like the timestamp of that. BH at Canton timestamp. Because I want to know the times. The ever living God fucking hell was the Jeep. I want to know where the Jeep was. Where was the Jeep? Why was there no Jeep there? Because the Jeep was there. And then poof, magically it has disappeared. And I know that at least one juror is saying, where the fuck is the Jeep? Where's the Jeep? Where's the Jeep, guys? But where is the Jeep? Where's the Jeep?
Not one witness
y'all brought it up.
that was inside the house, not one passerby, not one neighbor, not one plow driver ever saw John O'Keefe's body laying prostrate in the snow that morning. Not one. Not until Karen Reed found Mr. O'Keefe at about 6:03. And again, the Commonwealth's chief medical expert, Dr. Scortibello, their medical examiner, who's the only person that the court heard from or will ever hear from who actually investigated John O'Keefe's physical body. The only person to have physical access to John O'Keefe testified he did not have any injuries consistent with being struck by a vehicle. But she did indicate that the injuries, as did the firefighters, the first responders, indicate that he had injuries consistent with a physical altercation. And certainly, as to counts 1 and 3, no evidence has been presented or proffered whatsoever by the Commonwealth that Karen Reed intended to run over and harm John O'Keefe in any way, shape, form, or fashion. Hearken to the video at C.F. McCarthy's. Hearken to the video at the waterfall. Every witness confirmed what our eyes could see. That night, John O'Keefe, Karen Reed were loving, caring, affectionate. There's absolutely no evidence that Karen Reed had an intent to harm John O'Keefe, or that she that after the fact, that she intended to leave him for dead, because there was no fact to be after. There was no collision in the first place. The Commonwealth's case, certainly on counts 1 and 3, taken separate from count 2, because of the mens rea associated with counts 1 and 3, fails miserably. The Commonwealth, at the end of the day, has presented their best case. They've done their best. Some would say they've done their worst.
Ooh!
And their case has failed. No reasonable jury, hearkening back to...
That was... That was definitely just a jab at Brennan. Again, Brennan had a little bit of a jab at the defense team and Alessi when they were arguing in a voir dire, after a voir dire of this witness, Dr. Welcher, and there was mention to, so Alessi mentioned like their loss or the defense's win last trial, and then Brennan tried to battle it out again when he was talking. It was just like a whole mess. And I think the personal jabs go go a little too strong sometimes, but like honestly, I don't care. I like it. The jury's not here. It doesn't matter. AJ is he is feeling a little bit of the pressure, but he is also fighting. He is still fighting. He is the Knicks right now. The pressure is on. If you don't win this game, you lose. Like, if you need to win this game now, there's no next game. And he's feeling it, and he's fighting. He's in fight mode. He's in fight, right? He's feeling bold. I'm going to move this up to 1.25 speed only because we can.
The standard under Rule 25, no reasonable jury could find Karen Reed guilty of count 1, count 2, or count 3. But taking count 1 and 3 aside, those are separate counts because of the mens rea required and the high burden that's required, even taken in the light most favorable to the Commonwealth. What evidence have they proven that Karen Reed intended to kill or harm John O'Keefe, or that she intended to leave him for dead in the snow?
Where was the intent?
The answer is none, 0. No reasonable jury could find Karen Reed guilty. This case never should have been brought in the first place.
Oop.
There are reasons that I won't go into here. The court knows those reasons, or knows our position on those reasons.
Yes.
This was a vindictive prosecution.
Yes, it
and I believe
was.
that the court is duty bound pursuant to the precepts of Rule 25A, as well as the principles of justice, to dismiss all 3 counts. And certainly, taking count 1 and count 3 aside, the court is duty bound to dismiss those 2 counts. Thank you.
Okay, very good. And when it comes to the vindictive prosecution, first of all, Miss Little got a haircut, and I want to take a moment to fully appreciate that. And I think we should. She got a haircut. I think there's bangs. I think there's a bangs situation. Oh my God, what is wrong with me?
Thank you.
So Miss Little got a haircut. She also has her hair in a clip. You can see some sort of shorter, wispier. We fucking stand. I just can't. Like, I cannot handle. It's like, it's not fair, you know?
In a light most favorable to the Commonwealth.
Like, God really does have his favorites. The swoop bangs, like the curtain bangs. I love it. Let's talk before we hear Brennan. So cute. I love her. I love her. I want more Miss Little always. I want more Miss Little. She is so on top of everything. It got to the point where Judge Cannoni said, while asking attorneys on the defense team, do you have this? She would stop herself. She would interrupt herself and say, Miss Little. And she's like, I got it. I got it. Here you go. I'm going to have it for you in 2 minutes. I know exactly where it is. It's actually on this page. Like, Miss Little is so on top of everything. And I need her to know that everyone loves her. Everyone loves you. There's so much fighting. There's so much arguing. There was so much contemplation. And I've never heard a bad word about Miss Little. I got to drive work and I'm dataless. So I'll be back in 15. Okay. Be good. Drive safe. So let's talk for a quick second about the vindictive prosecution. So when it comes to the prosecution, 1, this is the second trial. 2, Mr. Brennan himself is being paid chunks of money to prosecute this trial as a special prosecutor working for the Commonwealth. He himself is a defense attorney, IRL, at his own law firm, et cetera, et cetera. He is not a prosecutor. He does not work for the DA's office, but he is being paid to do so for this trial. On top of something that we heard from the last expert, Dr. Welcher, we have heard you may not know, but experts get paid. Experts, they get paid. Normal civilian witnesses, they don't get paid. They just get a subpoena and you have to show up now, and they might have a meeting with the prosecution. Experts get paid for their time and their work. That's all up to them. Like, it's all up to whatever company they work for, the contracts that they sign, and the deals that they make, like whatever. Like, the payment there's nothing set in stone. Like, hey, you get paid this much according to law. It's according to the company, and it's according to what the prosecution is willing to agree on. Dr. Welcher, we found out first in his testimony that there was a $44,500 contract. Was that a retainer? I'm sure it was. When it comes to Aperture. So Aperture was the company that Dr. Welcher and Burgess both work for. Dr. Welcher turns out to be, I think, like the vice president of Aperture. And then a little later on in his testimony, we hear that there was a second contract or an amended contract, something of the sorts. There was another time a signature needed to be signed, and that the number raised up or raised, or the new number, or there was also a number. The specifics are kind of unknown because we don't know the contract. If it was an amendment to the contract, in addition to the contract, a completely separate contract referring back to the 44.5, whatever that was. $325,000 being paid to Aperture for their work since September of 2024, for the work, for the testimony, the days in court, the flights, etc., etc. There is at least $325,000 going from the state of Massachusetts to Aperture. Does that include the 44.5? Maybe. Does it? Is it in addition to the 44.5? Maybe. I need to see the contracts. I honestly, I don't care. I think $325,000 itself is a big chunk of money, and it made the jurors go, "Whoa, they must be really good at their job to be making that much money." Because ARCA in no way got anywhere near that amount of money. So there is a discussion when it comes to the amount of money that experts are paid and the optics when it comes to the jury. So some jurors will say, hey, I listened to your testimony and you got paid $325,000. Oh my God, like you got way overpaid, my guy. Like that's crazy. Like your company got that much money and you're sitting here saying, I don't know, we don't have enough information and I don't know. But also on the flip side, jurors are going to sit there and say, okay, so this is really important testimony because they got paid $325,000 for this. They are really good at their job. They are top tier expert witnesses. They know exactly what they're doing. They get the big bucks. And they're going to hear ARCA come on up, a company that the Federal Bureau of Investigation used when it came to investigating this case in particular, and have used in the past and will most likely use again. But for when it comes to this case, the FBI used ARCA and they said, we're done with ARCA. EU, either the Commonwealth or the defense, has access to ARCA and all of the information and all of the data and all of the findings that they have already produced because we needed them to produce the findings, but you can use them. You're able to use them, defense and or prosecution. And the defense said, we will scoop that bad boy up. Thank you. The Commonwealth did not. So ARCA got nowhere near that amount of money. We're going to hear from ARCA. What is the jury going to think when they hear you got $40,000 compared to $325,000? But also, if we take into account $325,000 plus $250,000 for Brennan, we're sitting over we're sitting at 3, 4, 5, we're sitting at $600,000. Just that alone, just those two experts and Brennan. There are plenty of other experts. There are plenty of other expert witnesses. There's plenty of other money coming out. This is a vindictive prosecution. And I think that's the moment that Jackson really wanted to get across to the court, is that the vindictive aspect of this prosecution is strong. You have so much money trying to put this woman in jail, but yet you cannot sit here and say she had a reason. She intentionally did this. This is how she did this. This is when she did this. This is why she did this. She did this and no one else could have. You didn't get there. You didn't get there. You can't get there. There's too many wishy-washy moments. There's too much unknown. It's not gonna happen. And so to do it again, spend more money, spend more time, take this person out of their life for longer and longer and longer to add fuel to the fire that you know is existing within social media and on the internet, within the community. it is vindictive. And I think that's a fantastic underlying statement for Judge Cannoni to hear as they go into the defense's case in chief. I assumed that when it came to the SUV, the Lexus that Aperture bought, they would eventually sell once the case is over, and then the Commonwealth would sort of, if they sold it for under the value, they would supply the rest of the money so that there was no money loss. And that is exactly what is happening. There were a lot of questions, a lot of concerns about Aperture having enough money to just go out and buy a 2022 Lexus, the exact same version as Karen Reed's, and it was the Commonwealth paying for that. Who's going to take that Lexus home? Is it just going to sit there? They're just going to throw it away. So they're going to sell it, and then whatever money that they didn't make up from selling it from the purchase, the Commonwealth will supply to Aperture as well. So that's another chunk of cash to Aperture as well. All right, let's listen to what Brendan has to say, and then we have to get.
Well, the first issue the court should look to is intoxication. A reasonable fact finder would find that the defendant was in fact intoxicated.
That's fine. Everyone was.
Based on the serum conversion and based on Karen Reed's statements herself, you've heard many, many admissions by the defendant about her level of intoxication, which far surpassed the statutory mandate that she consumed alcohol in a way that would affect her ability to operate safely. Those are just two of the cornerstone pieces of intoxication, which are clear, like most favorable to the Commonwealth, a reasonable fact finder could find beyond a reasonable doubt. The evidence of collision is abundant. I do not want to go through an entire closing argument or rhetoric, but suffice to say there are taillight fragments from the defendant's own Lexus from her shattered right taillight that are found in Mr. O'Keefe's
and many
clothes.
other fragments of
Mr.
many other
O'Keefe
things.
Is left at the very spot where she expects to find him, according to her statements, where her car does a backing maneuver at least 24 miles per hour.
Are you sure about that? I don't think
He's
that.
left
I
with
don't.
injuries.
That never really came out as definitive. That never really came out as a definitive. I had so many problems with Dr. Welcher, down to the fact that Dr. Welcher dressed as John O'Keefe, literally down to the matching shoes, jeans, shirts, and hat, and then pretended to get hit by the SUV that they purchased. So, problem with the way Dr. Welcher does his science.
Injuries on his arm consistent with the damage to her Lexus right rear taillight. The scientific data.
Whoa. Did you just say they're consistent? Because I don't think we ever got that definitively. They may be consistent and they very well may not be.
He is left with injuries on his arm consistent with the damage to her Lexus right rear taillight.
I don't think that's fair to say.
The scientific data is substantial. Telestream data, Apple Healthcare data, battery temperature data. And again, Ms. Reed's statements herself about clipping, hitting. The evidence of a collision in this case is overwhelming. It is a public way. Lieutenant Gallagher told us about Fairview as being a public way.
Yeah, anyone has
And
access.
so as to the operating under the influence of alcohol manslaughter, the conduct of driving in that forward and backing maneuver after being intoxicated meets clearly the standard for OUI manslaughter.
Then press charges on everyone that left that bar after having 4 drinks. Then press charges on everyone. Everyone needs to has charges pressed against them if they were driving. Who drove? Follow the cameras. Who drove?
Regarding second-degree murder, as highlighted in my opening statement, the defendant engaged in intentional conduct. That was her maneuver of driving forward, stopping, and then driving back to Mr. O'Keefe on January 29, 2022. Under the conditions that night, after being intoxicated, that conduct was intentional. And any reasonable person could find that her conduct that night created a plain and strong likelihood of death. There is no predicate of intending to kill or even intending to hit. There is clearly a plain and strong likelihood of death driving a 6,000-pound SUV forward and then back. In addition to state of mind, again, the defendant tells us herself. Through firefighter Becker, they're arguing, they're upset. We see the text messages, evidence of attempted breakup, and we hear the words of Karen Reed when she leaves numerous voicemails that night, and you can hear her voice. There are statements, I do not want to go through a summary of all of them, but statements from the defendant herself where she acknowledges an injury to Mr. O'Keefe. She's the last one with him, where to find him, and her hypothesis is about hitting and clipping him. As to leaving the scene, again, the defendant tells us that when she leaves, he doesn't look mortally wounded. She leaves him, makes dozens and dozens of calls, but never goes back to help him and leaves him to die. And we heard from Dr. Wolf about the life-saving procedures that could have been initiated. The chance of survival was never given to John O'Keefe. All of those facts suffice under Lattimore, a light most favorable to the government, that a reasonable fact finder would find beyond a reasonable doubt, or could find beyond a reasonable doubt, each and every element of each and every one of these charges.
All right, thank you. So the motion is denied as to all three indictments. On the other topic that we were discussing at sidebar, I don't need to hear argument on that right now, Mr. Giannetti. I'd prefer to get started. I would like you and Mr. Brennan to talk to see about proposal. So are we ready to bring the jury in? I did not ask you at sidebar. Are you ready for this witness, Mr. Brennan?
I'm ready.
Okay, so,
Thank you.
all right, so we'll bring the jury in. That will take 5 minutes, Paul. All right, so we'll take a recess.
All right, please.
All right. Like I said, there was no chance it was going to be anything but dismissed. It, of course, is being dismissed or denied, excuse me. They have to do that. It's just how it is. That's just the way court works. You gotta keep fighting. In between case in chief of the prosecution, the defense always goes up with a motion to dismiss, and there was no way in hell it was going to be anything but denied. Are there moments that a jury could say, all right, look, she did it? Sure. Is that
Were you all
jury,
able to follow my instructions?
would that make me happy if they were just like guilty, guilty, guilty? I would say I would love to see your work. Like some damn math assignment. What questions did you ask? What questions did you avoid? What information did you ignore?
Then refrain from able to. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or arrested, put on a case? But I hear that you are. So your first witness, please, Mr. Jackson.
Thank you, Your Honor.
First witness,
The court commission would ask Matthew DeSober join us.
Okay.
Matthew DeSobra, not Proctor. Not Proctor, not Higgins, not Trooper Joe Paul. Is it Joe Paul? Trooper Paul?
You show me the evidence you give the court and jury in case down here, the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Thank you.
All right, Mr. Jackson, whenever you're ready.
Thank you, Mr. DeSober. Could you please state your full name and spell your last name for the jurors, please?
Sure. Matthew DeSogra, last name Disogra.
What do you do for a living, sir?
I am a licensed professional engineer. I practice in the field of accident reconstruction. And within that field, I specialize in analysis, interpretation, and accessing all types of vehicle data.
How are you currently employed?
So we just had the Commonwealth accident reconstructionist, Dr. Welcher, who was on the stand for like 2.5 days. And so the defense says, hey, look, we're going to start our case in chief, and we are going to directly, one-to-one say, you're wrong. And here's our guy. Here's our guy telling the jury, look, ask the questions. What was missed? What did they not do? What did they not consider? What did they not take into consideration while doing their science? Ask the questions. Here we go. Here we go. I'm so pumped.
I'm employed by Delta V Forensic Engineering, which is an engineering firm that specializes in accident reconstruction, all parts of accident reconstruction.
Tell us a little bit more about Delta V. What is it? What kind of company is it? But other than that specialty, what else does it do?
So accident reconstruction is a broad field. There are a lot of subspecialties within that. So accident reconstruction is everything from the initial investigation phases of a crash all the way through testimony, like here today. Some of the specialties within that could be things like biomechanics, could be human factors, and my specialty is data, vehicle data, and event data recorders.
Staying on that topic, what is your current title or position with Delta V?
I am the Director of Engineering for our EDR services line.
What does EDR services mean?
So, event data recorders. So EDR is a general term we can use to talk about all types of data from all types of vehicles.
And how would you describe your role as the Director of Engineering for EDR services for Delta V?
I wear a couple of different hats. First and foremost, I'm still a practicing engineer. I still conduct investigations. I still perform analyses, and I testify. On top of that, in the director role, I oversee a group. It's not just me doing this kind of work. I have 3 other engineers that work with me, all specializing in EDRs. So I oversee that group and focus on kind of the day-to-day operations as well as the direction we're going. With things like autonomous vehicles coming, the role of data is growing. So we're kind of looking to the future in a lot of those ways.
As a consulting engineer, you've indicated what your specialization is. Do you specialize in motor vehicle accident reconstruction as well as vehicle system analyses?
I began my career at Delta V doing traditional accident reconstruction in the broadest sense. And as I have progressed, I have sort of narrowed myself down and now specialize in that. But I still consider myself an expert in accident reconstruction because ultimately,
No, please finish.
Ultimately, anytime we're doing EDR or data analysis, it is in support of an accident reconstruction.
You talked about event data recorders. Do you also engage in the specialty of advanced data recovery methods? In other words, methods of pulling the data. It's one thing to have it sitting in a car. It's another thing to pull it out and make it useful, correct?
That's right. There are a lot of different ways data can be accessed, all the way from just plugging into a port on a working vehicle, all the way through when a vehicle is catastrophically damaged and even the modules themselves are damaged, accessing the data at the chip level. So no matter what condition a vehicle or the remnants of a vehicle are in, generally we can still get the data from that.
Do you have any specific knowledge about Toyota data?
I do.
Describe that for us.
Beyond Toyota being a common vehicle in general, so we run into that data quite.
Toyota is Lexus. So if you're thinking about, oh, I need to go get a Lexus, or what are the fancy versions of cars, like the high end, like I guess it like the mid end, not a commoner like Toyota or Chevy and that type of thing. Lexus is just a Toyota. A Lexus is just a Toyota. It's just in a different exterior package. It's all Toyota. Toyota. It's a Toyota. When you drive a Lexus, you're driving a Toyota. So, and the more people that know that, I think, if the more people that knew that, I think it would really change like the car game. Like, I wish more people were like, oh, but isn't a Lexus just a Toyota? So I should just get a Camry instead of the Lexus and spend, $30, $40, $50, $60,000 less, because I'm literally paying for the name and a symbol. So that's stupid. I think it's also dumb. I think it's all so dumb. I think it's all about image, sadly. It is all about image. And I have a friend who is very, very well off, and she does not drive a fancy car. She does not have a fancy house. She does not shop at fancy grocery stores and eat, the $80 kale or whatever rich people eat. And I love that. I love it so much. And she's like, okay, so I have money. Why would I spend more than I need to have a car? Like, it all goes the same. She's like, I like having money. I don't want to spend it. It's like, I want to spend it on the things that I want. Like, I want to go on a vacation. I want to go do this. And it's like, okay, that's awesome. I don't have to show people that I have it. Like, I don't want to get robbed.
Quite frequently. Just this year, we published a paper specifically studying some of the behaviors of the additional data recorder that's in Toyota vehicles.
Does Toyota make another sub-brand, for lack of a better phrase?
Lexus, I believe.
So Lexus is a Toyota brand. Right?
Correct.
Okay. What is infotainment? It's kind of a combination of a couple of words, information and entertainment. What is infotainment data as it relates to vehicles, modern vehicles?
So it's a generic term.
I want to know what car brand. I don't need to know the license plate. What kind of car does Judge Canoni drive? Do you think she drives a Lexus?
which more or less means the thing that's in the middle of the dashboard with the screen on it. A lot
I think
of
she drives like
manufacturers implement that a little bit differently, so they all look different, but it's a general term we use in the industry to describe that system.
And what about, I'm going to change gears a little bit. What about your experience with regard to GPS as it relates to vehicles on the road, on the common roadways of the country?
GPS is a pretty fundamental part of vehicle data as a whole at this point, and we run into it in a lot of different places. We see GPS data from infotainment systems, so we're analyzing that data. Most of that's GPS based. I do a lot of heavy truck work, and almost every heavy truck has some kind of GPS system in it for the fleets to track them. So we're analyzing that as part of data. And then the last area would be when we conduct testing, any kind of research, we're generally going to put our own GPS systems on vehicles so we can study that data. So
I just know Victoria's going to love this, man. Look at that salt and pepper.
analyzing GPS is a regular part of my job.
GPS, global, I'm going by memory, global positioning satellites?
Global positioning system.
Got it. GPS is a mechanism to figure out where on Earth a certain item might be, whether it's this pin or an 18-wheel tractor trailer, correct?
That's correct.
Is there any difference inherently in the GPS mechanism that's installed in an infotainment center in a Toyota/Lexus, versus a heavy truck or heavy vehicle that's on the road?
The core technology behind how it works is fundamentally the same.
What is instrumented testing as it relates to Toyotas and VCH testing and things of that nature? Can you explain that for the jurors?
Sure. What instrumented testing means is, let's say we want to study, let's say how accurate some data is that comes out of one of these vehicles. So we need an independent source of that information. So what we'll do is we'll equip a vehicle with one of these GPS data acquisition systems. Basically, we can drive the vehicle around and we know exactly where it is, how fast it's going, all these parameters. We can do some maneuvers with the vehicle. Then we can download the data that the vehicle stored, and now we can compare the two and say, okay, well, if we have really high confidence in our system, how accurate is the vehicle system? Because the reality is there's always some small errors in these vehicle systems. And in a lot of cases, what's important is quantifying that error.
So you're obviously familiar with GPS systems in many different platforms.
That's correct.
Okay. How many cases have you been a part of in terms of investigating and or analyzing infotainment center or infotainment system data?
Infotainment specifically, probably around 30.
And are you also familiar with engaging in some sort of analysis that's referred to as clock alignment?
Yes.
What is clock alignment?
Clock alignment would mean that anytime we have a timestamp in any set of data, a singular clock value, there's a good likelihood that that's not 100% accurate. So clock alignment would mean finding an independent source of time to compare that to, preferably one that's more reliable, and then making the necessary adjustments so that time can be considered real time.
How many cases have you been involved in that deal with clock alignment?
I want
specifically?
to hear him say that again.
We have a
and
timestamp in any set of data.
If you watched any of Burgess or I guess maybe even some of Dr. Welcher, the complete difference of like being able to explain is like the clarity is immensely improved.
Clock alignment.
Clock alignment would mean that anytime we have a timestamp in any set of data, a singular clock value, there's a good likelihood that that's not 100% accurate. So clock alignment would mean finding an independent source of time to compare that to, preferably one that's more reliable, and then making the necessary adjustments so that time can be considered real time.
How many cases have you been involved in that deal with clock alignment specifically?
Thousands, over 1,000. That's a regular part of data analysis. Any data set that has a timestamp, it's normal. It's part of the analysis. It's really the first step is let's get that clock aligned. So it's something I'm doing regularly.
And how long have you worked for Delta V?
It'll be my 13-year anniversary next month, actually.
Okay.
Aww.
These things that you've just described that we've talked about for the last few minutes, these are all duties that you perform within the rubric of your employment as the director of engineering at Delta V, correct?
Correct.
Now let's shift gears real quick and talk about your education, training, and background that qualifies you to perform these duties that you just talked about. Go ahead. The road is open and it's yours.
Certainly.
No,
So
ask him the question.
Began my academic career. I got an undergraduate degree in mechanical engineering from the University of North Carolina at Charlotte. I then went on and got a master's degree also in mechanical engineering from
Jackson, ask him the question. Oh, let's shift gears and talk about your background. Okay, well, ask him a question. or tell them to start from your first degree. That was so awkward.
Same school. And then when I came out of school, I immediately started working for Delta V Forensic Engineering. In order to get a professional engineer license, I then needed to acquire 4 additional years of work directly under the supervision of another licensed engineer. So then I completed that phase of work. And then in order to maintain my license, I have to complete continuing education every year in the field that I practice.
So you got both a Bachelor of Science, correct?
Correct, Bachelor of
Did
Science.
did you mention the year that you got your Bachelor of Science?
2011,
And you have a Master's
correct.
in engineering.
That is correct.
And when did you secure that degree?
2013.
You just mentioned engaging in continuing education. What is continuing education in terms of the engineering field or the reconstruction field in your world?
So in the state that I'm licensed in North Carolina, they define that really as any activity you're participating in that's keeping you abreast with the field, keeping you up to date with what's going on. So taking formal classes counts for continuing education, but also some of the other work that I do, like publishing research in peer-reviewed journals, also counts as continuing education.
Do you
Already, the jury is going, oh, shoot. This guy's really well educated. He has been doing this. I mean, he got his bachelor's of science in 2011, got his master's. He was 4 years. My brain keeps saying understudy, but I think it's not intern. It's what is the word? What is the word? Study under master. I'm gonna find the word. Apprentice. That was embarrassing. Sort of like apprenticing. He needs 4 years of like working under someone and like being monitored and that stuff. So that's, I think right here is when the jury is going to go, he knows what he's talking about. And they're immediately going, Burgess, education, no degree, year of degree. Interesting. $325,000.
regularly attend symposiums or symposia, I guess is the right
Yes.
word. Have you attended symposia related to EDR research and training?
Yes.
How about advanced applications of heavy vehicle EDR data?
Correct. Yeah, I attend. There's a couple of regular conferences in our industry specifically tailored to EDRs as a whole for passenger vehicles and heavy trucks. I'm a regular attendee of those. I'm also a regular speaker at most of those. And I'm usually presenting some of the new research that we have for that year.
So not only do you attend, you actually teach.
Correct.
Have you attended data? I'm sorry, have you attended data? Have you attended events that deal with data, event data recording systems and event data recording system extraction?
Yes.
What about vehicle crash reconstruction?
Yes.
What about electronic control module imaging?
Yes.
What about electronic control model analysis?
Yes.
Applying automotive EDR data to traffic reconstruction?
Yes.
These are samples of the type of continuing education that you routinely engage in, correct?
All that's accurate.
You talked about additional licenses and professional registrations. You're a licensed professional.
He's nailing it home to the jury. This man knows. Burgess didn't. This man knows what he's talking about. Burgess did not. Don't listen to Burgess. Don't listen to Burgess. Listen to my guy. He's smart. He's educated. He teaches the things that Burgess wants to pretend to know about. He teaches him. So don't listen to him. Don't listen to Burgess. Listen to him.
Professional engineer, correct?
That's correct.
In North Carolina?
Correct.
You're also a certified IPC specialist?
Yes.
What is an IPC specialist?
IPC is an organization that offers certifications in basically soldering. I could say it in more technical ways, but it boils down to soldering. So as it relates to what I do, when we are recovering data from damaged EDRs at the chip level, that involves some really precise soldering work. And so IPC offers courses in how to do that at basically the highest level, and then they offer certifications for that.
Are you a member of the Society of Automotive Engineers?
I am active member.
When you say an active member, is that a nationally recognized society for academic engineers?
Yes.
The teaching roles that you've held within organizations, have you been an instructor concerning accessing and interpreting heavy vehicle data event recorders?
I'm currently an instructor of that course, which is offered through the Society of Automotive Engineers.
As a matter of fact, next week, are you going someplace to teach?
I will be in Wisconsin next week teaching that very course.
Are you a member of any subcommittees within
Like,
that
come and say
organization,
hi.
within the organization of the Society for Automotive Engineers?
I am a voting member in the J2728 subcommittee, which is a subcommittee for event data recorders on trucks and buses.
Are you also a member of the National Association of Professional Reconstruction Specialists?
I am.
Does that require a certain level of education?
It does, and it requires, as far as I know, when I joined, sort of proof that you are active within the field of accident reconstruction.
That was my next question. It requires you to stay current on accident reconstruction issues, correct?
Correct.
Have you also authored peer-reviewed articles on within your field and
Yes.
subfield? Is it fair to say that you've authored or co-authored a number of peer-reviewed papers in the field of accident reconstruction specifically, as well as EDR data retrieval?
That's correct.
Have any of your peer-reviewed articles that you've either authored or co-authored specifically focused on Toyota vehicles?
Yes.
Can you name one, please?
Specifically, this year published a paper where we studied the effects of collision-induced power loss on the way data is recorded in Toyota systems. And that would include Lexus systems. Fundamentally, they're the same components, it's just a different brand on top.
In January 2025, did you co-author a publication entitled Simulation of Vehicle Speed Sensor Data for Use in Heavy Vehicle Event Data Recording Testing? Of course. Sorry. In January 2025, did you co-author a publication entitled Simulation of Vehicle Speed Sensor Data for Use in Heavy Vehicle Event Data Recorder Testing?
Yes, I was the lead author on that paper.
When you're dealing with retrieving data from a vehicle, an
Facts.
EDR, an event data recorder,
Facts.
Toyota paper, whatever it might be, and that's a term of art, Toyota paper, correct?
Sure.
Does it matter if the vehicle is a heavy vehicle, a small vehicle, a passenger vehicle, a moped, or a skateboard if they happen to have an infotainment center on it?
There are differences, of course, between the data that comes out of passenger vehicles and the data that comes out of heavy trucks, but there are also a lot of fundamental similarities to those. Like, for example, they all record vehicle speed. They all have accelerator pedals. They all have brake pedals. So a lot of the core data we're analyzing is very similar.
In January 2020, did you co-author a publication entitled Chip and Board Level Digital Forensics of Cummins Heavy Vehicle Data Event Recorders?
Yes, I did.
Okay. And what was the fundamental, without getting into the granular details, the fundamental aspect of that paper?
In that research, we introduced a new technique for getting data out of damaged modules. So, they're either burned, they've been submerged in the water, they're crushed physically from impact. We demonstrated a new method to be able to get data less invasively, but still at the chip level. And we also demonstrated that we could translate that data from the chips outside of the software that was provided. So you could use the software and get the data that way. We demonstrated we could basically do it ourselves if we wanted to.
Mr. DeSogra, have you been qualified in other courts to testify as an expert in the area of accident reconstruction, EDR data retrieval? And recovery?
Yes,
How many times?
once
When was that?
in New York.
You were deemed qualified as an expert in that court in this field that you're talking about today.
Specifically with as it relates to data, yes.
I want to talk a little bit about what you were asked to do in this case. We asked to undertake a review of certain work performed by a person by the name of Shannon Burgess with Aperture LLC.
Yes,
Are you
Shannon
familiar
with
with
an
Aperture?
N.
yes,
Before you were asked to undertake that review, were you familiar with Aperture?
yes,
Were you familiar specifically with Shannon Burgess?
yes.
Were
Oh,
you asked to engage in any original analysis in this case?
All of
how familiar are you with Shannon Burgess? It's clearly a small career. Like there's not a lot of members comparatively. So how familiar? Like, are y'all friends? Have y'all gotten meals together? Do you email? Do you text? Do you follow each other on Instagram? How about LinkedIn? Do you follow each other on LinkedIn?
all of my analysis is fundamentally based on all of the data and the numbers provided in the Aperture reports. So,
Okay, sorry, let me just go back.
Were you
with this
familiar
question.
specifically with Shannon Burgess?
yes,
Were you asked to engage in any original analysis in this case?
all of my analysis is fundamentally based on all of the data and the numbers provided in the Aperture reports. So, more or less the answer to your question is no.
So you were asked specifically to give the court and the jurors clarity on data that Shannon Burgess had analyzed and provided a report about, correct?
Correct.
And that dealt with data obtained from Ms. Reed's SUV, Karen Reed's SUV, correct?
Correct.
Did you in fact review Shannon Burgess's report summarizing his findings and conclusions regarding clock drift? That report was dated in January of 2025.
Yes.
And what did you do in that regard?
I analyzed the methods that Mr. Burgess proposed for aligning the clocks in that report.
Were you also asked at some point to review Judson Welcher's report and PowerPoint presentation regarding the timing of the text stream event known as 1162-2?
Yes.
Did you determine whether Dr. Welcher had based his report on Shannon Burgess's analysis?
Yes.
Before we get into that, I want to ask you a couple of questions about text stream events so we're all talking sort of with the same vocabulary if we could. When I say text stream event, have you ever heard that called a trigger event?
Yes.
Are those sort of synonymous?
The event, in order to be generated, has to be triggered by something. So, yes.
You became aware in your analysis, I'm assuming, that Dr. Welcher reported a trigger event at a particular time or span of time, correct?
Correct.
What span of time was that? I should say, what time was that?
Which one?
For which event? Just so
For
I'm
the
clear.
1162-2 event, sorry.
Do you mind if I reference the slide? Because I don't have the number committed.
With the court's
to my-
permission.
Go ahead.
Do you have a copy of it in front of you?
I do, Your Honor. So,
This man has only testified as an expert. I don't know if he's ever testified before in court, but he's only testified as an expert once before this. And already he has proven to be a better witness, more professional witness than Dr. Welcher, who sat there with his computer open and looking at it the entire time. And so much so, Judge Beverly Canoni said, shut your computer. Because it's one thing. So what you're not supposed to do is read directly from the thing. You are supposed to refresh your recollection and then proceed on. There are situations where when it comes to the pieces of the taillight and how there's 10 million of them and which ones taped together, et cetera, that is a situation and a scenario where there's no way a normal person or anyone above a normal person in IQ would even be expected to remember that. So when you see an expert witness like the ones who did sort of the recreation of the things or the testing of the things, being able to go through looking at their PowerPoint or what have you, saying this, and this, and they're looking at their paper, it's because there's no way that could be remembered. But this situation, he said, may I, to the judge? Of course. Yes, of course. Yes. Thank you for asking. I appreciate it. I'm interested to see how he continues with his notes. So yeah, there's also a lot of words: text stream, collision, data, EDR, Shannon Burgess, Dr. Welcher, all of these. Like, there's so many things. Like, there's a lot of things. This is a very complicated issue that the jury, I don't think, I'm going to go out on a limb and say, have never had to deal with, and they've never had to like pay attention to. It's quite difficult. So making sure the least amount of jumbled words possible is extremely helpful.
the original analysis places event 1162-2 ending at 12:31:43 a.m.
Now, Dr. Welcher, this is what I want to talk about for just a quick second. Dr. Welcher indicated that the trigger event began at 12:31:38, correct?
I believe so.
That would suggest that a trigger event lasts 5 seconds, 12:31:38 to 12:31:43, correct?
Objection.
Sustained is to form.
Let me ask you this. Does a trigger event or does a text stream event
Summertime traffic
last 5
nightmare.
seconds or 10 seconds?
The trigger is a singular point in time.
That's my question. All right, so if we're thinking about a trigger event, it's like that clap, snap, right? It's a point in time, not a series of not a time span, correct?
It's a singular point, correct?
Okay. Does a trigger event or a text stream event cause a recording to bookend the trigger event itself?
Yes.
Explain that for the juror so that we're very clear about that.
Sure. So when an event is triggered, what we end up with is some data from before the event was triggered and some data from after the event was triggered. The way it does that is it's kind of always recording. And as soon as it sees a trigger, it says, aha, and it goes and it grabs the previous 5 seconds. That number can vary. It can be more or less than 5, but for the specific trigger we're talking about, it grabs the previous 5 seconds of data, and then it keeps recording for an additional 5 seconds, and that completes its recording phase.
Right. So if Dr. Wells,
That right there was so much more clear for the jury. It was more clear for me. Hit me with the tea, Crystal Lynn. How are you? That right there, him saying trigger event. Text stream is the data before and after, including the during. So you have a text stream. So it's hard to like physically demonstrate, but I like to. So trigger event is he clapped. So trigger event, but you're going to have text stream, which is the data of the before and the after. So all the way from before the event and after, so you're getting more information, even though the trigger event is just the clap. So you're gonna hear, say you're listening to a show, right? And there's nope, I'm not gonna even try. I'm not even gonna try. Anywho, we get it. He made it very clear. This is why he made it very clear. And I think we're gonna go back and listen to it again. Crystal and hi Lily, what did I miss? Anything juicy? Hit me with the tea. So juiciness is here. We are officially in the defense's case in chief. So the Commonwealth has rested their case yesterday. We are in our first witness, Matthew something DeGrassi, Matthew DeSogra, who is a professional event data recorder. He works for Delta V forensic engineering, a vehicle data and event data recorder. So he is basically in direct reference to Shannon Burgess with one N, the guy who did not ever finish a degree, even though said on LinkedIn and his CVs that he did, but then said on some CVs that he didn't finish a degree. And then Dr. Welcher, who was their final witness, who was a reconstructionist who was on the stand for like 2.5 days. So this is the defense's direct combat to that. And this witness here took Shannon Burgess, the guy who who was very red, who was having a hard time on the stand, Shannon Burgess's report about the event data from the car, the text stream data, and then also Dr. Welcher's report, and said, let me look at all this. Let me analyze your math. Let me analyze your science. How did you come to these conclusions? Let me see if y'all did this right. So that's really what he's doing. And so he is just simply now before he gets into all the wild shit, he is explaining to the jury what even all this stuff is, because it was never cleanly explained to the jury. So they're hearing all these words: trigger event, collision, text stream data, time variance, clock variance, this and that. They're hearing all these things. And I don't think it ever really was made specifically, like layman's term, EDR for dummies, clear what it is. And that's what I need. Like, explain it to me like I'm 5, bro. Please and thank you. And then let's get deeper. Let's get bigger. Let's get down into the nitty gritty, but start me off like I'm 5. And then we'll move to 10. Then we'll move to 15. Then we'll move to 20. Then we'll move to a fully formed brain. Let's get deeper and deeper and deeper into it. But explain it to me like I'm 5. And I think that's what the jury needs, because if it's something that you have never dealt with, it's a science. You don't know. I don't know. And I want to know. I'm here. I want to know. I don't want to feel like I'm missing anything. I want to reach that jury deliberation room and say, I understand this. So yeah.
The trigger event itself.
Okay.
We're thinking about a trigger event. It's
Trigger
like that
event.
clap, snap, right? It's a point in time, not a series of, not a time span, correct?
It's a singular point, correct?
Okay. Does a trigger event or a text stream event cause a recording to bookend the trigger event itself?
Yes.
Explain that for the juror so that we're very clear about that.
Sure. So when an event is triggered, what we end up with is some data from before the event was triggered and some data from after the event was triggered. The way it does that is it's kind of always recording. And as soon as it sees a trigger, it says, aha, and it goes and it grabs the previous 5 seconds. That number can vary. It can be more or less than 5, but for the specific trigger we're talking about, it grabs the previous 5 seconds of data, and then it keeps recording for an additional 5 seconds, and that completes its recording phase.
Right. So
It's like a police body cam. When you hit the turn on button, like to start recording, it is going to pick up the last, 1 minute, 90 seconds, 2 minutes on there as well in like video. Like we've heard a lot about that, how the video will pick up. And then once you hit the record button, the audio will come in, but you'll still have like the video of before. Some have video and audio as well. But if you hit the record button, it's not going to start recording right there. It's going to pick up from before. So when a trigger event happens, you're getting the before and the after because it's going to continue to record. And I think that has been made very, very clear. And I am so thankful. I am so thankful.
if Dr. Welcher indicated that the text stream event, the trigger, was at 12:31:38, would it be accurate if he said that trigger ended at 12:31:43?
Sustained is to full.
That's fair.
Is there any,
You're no longer in cross.
if a trigger event is one point in
It
time,
ended.
one snap in time, would it be accurate to
Snap
say
is
that the
Mike.
trigger event itself lasted 5 seconds and ended 5 seconds later?
It wouldn't be accurate to say the trigger lasted that
That's
long.
my question.
The event lasts that long, but the trigger is only one point within the event.
The recording lasts that long,
Right.
correct?
Correct.
So in other words, it captures, or does it? Let me ask you this. Does it capture 5 seconds before and 5 seconds after? But the trigger event is the singular point right in the middle.
That's correct.
Okay. If we were to calculate the window between the trigger event or the text stream event and a lock event on John O'Keefe's phone, you analyzed both, correct? Or you reviewed both, correct?
Correct.
You
Would you
reviewed the
calculate
data.
from
You
the
didn't
point of the
analyze
trigger?
the
Would you
phone, right?
calculate from 12:31:38, that point in time? I'm using the tip of my pen to represent the point at 12:31:38, or would you calculate it from 12:31:43?
Customarily, when we're doing any analysis, we're referencing everything off of the trigger. That's the normal way. Everything in the aperture reports was referenced off of the end of the event. So
Of the recording event.
of the recording event.
Not
so
the trigger.
Ooh,
correct. And I
Ooh.
didn't correct that. I just went with that convention for all of the analysis I did.
But you noted it, correct?
Correct.
holy shit. We got to go back. We got to go back. We got to go back.
From 12:31:43.
Customarily,
That
We have-
point in
sorry,
time,
sorry.
I'm
Oh
using
my
the
God,
tip of my
stop.
pen
Oh my God.
to
Oh my God.
represent the point at 12:31:38, or would you calculate it from 12:31:43?
customarily, when we're doing any analysis, we're referencing everything off of the trigger. That's the normal way. Everything in the aperture reports was referenced off of the end of the event. So
Of the recording event,
of the recording event.
not
so,
the trigger.
Correct. And I didn't correct that. I just went with that convention for all of the analysis I did.
But you noted it, correct?
Correct.
And you noted that that would be 5 seconds inaccurate. I'll withdraw it. I'll ask it a different way. What would be the effect of
Right.
timing?
So this man who has a bachelor's, a master's, had 4 years of my brain keeps saying fucking understudying. 4 years of apprenticeship essentially, plus continued education. This man has been working in this field, has been working towards getting in this field since 2011 when he received his bachelor's. He has done nothing. He's going to be celebrating his 13-year anniversary working with this specific company doing this thing. And he says, usually, customarily, we base things off of, I don't know, the trigger, which is the event that makes the car start recording before and after. Pick up the recording and then continue after. It's the trigger, the event, the thing that happens. So is the car turning on? Is the car turning off? Is the car like gas pedal being slammed to over 30% immediately? The trigger event. Why should the car start saving this information? He says customarily we could base everything off of, I don't know, the trigger, because that's when the thing happened. But Aperture, the overpaid, uneducated, essentially. So Aperture had one contract for $325,000 payment to them. Aperture put Shannon Burgess on the stand, has no degree. Look, you don't need to have a degree, but don't say you have it if you don't. Has no degree, had a hard time. And Dr. Welcher, who is such a weird guy. Did I mention that Dr. Welcher, when he was experimenting with the Lexus that they purchased, he bought the clothing. He found the clothing that matched John O'Keefe, what he was wearing that night. And he said, well, I'm about the same height. I'm about the same weight. So let's back the car up into me and see how I move. In John O'Keefe's clothing. All right. I wonder if he went all the way down to the boxers. So anywho, this man is sitting here and telling the jury it's weird because they went off of the end event of the recording, the end time, not the trigger. The well, it's not necessarily 5. Let's just say 5. It doesn't always have to be 5 seconds. The 1, 2, 3, 4, 5 seconds after the trigger event. So Jackson is sitting there going, so what does that do about the time? Because if the trigger event is already off, say 20 to 29 seconds from real time, and now we're going off of the end event, the end of the recording, how was that adjusted? What happens to the time when you adjust for the clock variance? Because there is going to be a clock variance. The clock being told, so the car being told what time it is may not be the true time. It may be that it clicks to 11:18 13 seconds after your phone clicks to 11:18. That type of stuff. Oh, brother.
If you were to start at the trigger event, 12:31:38, versus timing the event if you were to start at 12:31:43.
There'd be approximately 5-second difference in every subsequent calculation.
And if, in fact, there was a lock event, which you reviewed, at 12:30.
CBS 6 pretty much.
Oh, yeah.
The fence is starting today.
Yeah, the fence is starting today. They're on their first witness now.
That's absurd. Like, was it 23 days for?
Yeah. Well, they said it was going to be about 23 days.
That's
I know.
I like the peacock.
Thank you.
Welcome.
I have new Lego sets. Oh, man. All right.
30. If you were to start at the trigger event, 12:31:38, versus timing the event if you were to start at 12:31:43.
There'd be approximately 5-second difference in every subsequent calculation.
And if, in fact, there was a...
Not necessarily, because some of the calculations that Burgess did, there was a bigger variance, a higher time variance, and a lower time variance. So not every calculation was the same number of a variance. So like a trigger event happened that there could be a 17-second variance, and a trigger event happened, or let's say, excuse me, let me start over. A trigger event happened and there's a 21-second variance, and another trigger event happened and there's a 28-second variance. So there wasn't always like the same variance. So it could even be bigger. Like he had a 21 to 29-second variance between the clocks, between the car event trigger and what they scientifically discovered to be true time. There was a 21 to 29-second variance. There was a range. It wasn't everything that the car records is this amount of time off. So we can just very simply go shoot, 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 and shift everything back or forwards.
Lock event, which you reviewed at 12:32:09, how long would the actual window be from the trigger event to 12:32:09?
It would be larger by 5 seconds, approximately.
So it would actually be 31 seconds, correct? Did I do my math right?
You did.
How dare you?
Let's get back, if we can,
How dare
to
you?
the offsets
So rude.
that you identified in Shannon Burgess's, the time offsets that you identified in.
Mike, tell me why. Mike, tell me why. Tell me why. Tell me why. I love this. I don't understand what this is. This is the dumbest Twitch chat. I'm going to show it. Hello, my headphones aren't working right now. Can you chat instead? By the way, which game do you stream the most? As I'm actively not playing a game. Right? As I'm actively not playing a game. No. What is that? I don't understand what that is. Why is that a thing? It's almost like on almost every stream I get some sort of variance of that. Like my headphones aren't working right now. I don't what does that even mean? Okay. Oh, so you want me to type every word I'm saying into chat? Is that so? I don't understand. I don't get it. Dude, Steve says not guilty. Fight it out. Fight. Mike, were you waiting in line for the new Pokemon cards?
In Shannon Burgess's report. When you applied the potential offsets identified by Mr. Burgess to the text stream event at 1162-2, what opinions or conclusions did you come to with regard to that analysis or that question?
Sustained, ask it to.
Did you apply the potential offsets identified by Mr. Burgess in his January 2025 report to the text stream event 1162-2?
Yes.
Did you also apply Dr. Welcher's analysis based on that same Shannon Burgess analysis to reach an opinion or a conclusion?
Yes.
And what was your opinion or conclusion with regard to that event and the timing following that event?
Based on all the data in those two original reports, regardless of what adjustment is made or which 2 points are used to try to correct the clock, the phone lock event always occurs after the end of the event, using their convention of referencing off the end of the event, not the trigger, but it always occurs after.
And that was based on Shannon Burgess's January 2025 report, correct?
Correct.
Sustained.
What was that based on? Which report? We're dealing with two different reports, May and January. I want to make sure.
Of course they're waiting for Pokemon cards and not games. Yes, the new Pokemon cards dropped. I don't know what it is, but I Googled it. There's a new Pokemon, like a new set is being released today. I seen on Reddit that people have been like waiting for like days. Like it's Black Friday in the 90s again. So we just heard from this witness the 1162-2 text stream data. This is his opinion. This is his conclusion. Regardless of any time adjustment, the phone lock event of John O'Keefe's phone, where it is manually locked by pressing the lock button on the iPhone with most likely your thumb, because I know he had thumbs, happens always after the end of the event. So the end of the 1162.2 text stream data, and then time exists between the end and when John O'Keefe locks his phone physically with his hand. That's when it happens. That's when it happens. So a friend of mine tried the GameStop, and she tried the Target and Walmart there, then Target and Best Buy down here. That's crazy. She found 50-cent spinach. So there is time and space existing there. There it is.
Should we differentiate? Which
Mary,
report
I
are
don't.
you just
Mary,
now
I don't
talking
know
about?
how to help you.
You're talking about the
You got to
January
find
report.
some
Now,
headphones that work.
Did Mr. Burgess, were you supplied with a supplemental report by Mr. Burgess?
Yes, I was.
When was that?
Slightly after he issued it, but I don't know the exact date.
Say that again?
It was issued on, his report was dated May 8th, and I think I was provided it a couple days after that. I don't
Okay.
remember the exact date.
So after, well, do you know when this trial started?
No, I don't know the exact date.
I know you're not watching the trial, but it was in the middle of this trial, correct?
Sustained.
I'll ask a different question. With regard to the original report, the January 2025 report, was there any circumstance in which Mr. Burgess and Mr. Welcher could conclude that the lock event on John O'Keefe's phone, that lock event, occurred before the trigger event?
Sustained. Ask it differently, Mr. Johnson.
Okay, so here's the thing. Brennan is going to object every leading question from Jackson. From the defense, he is going to be on top of it because that's all he has. When in reality, the defense could have objected way more often, right? But that is a choice that the defense made. Brennan, he's not letting down. He's not letting down. He will object to every leading question. He will. He will. We are going to be so annoyed at Brennan. And what he is risking is the jury being annoyed at him because the jury, I feel, already has a sense of things are being missed for the jury. We're not getting everything. They are holding out on us. There's so many sidebars. We don't know why things are being objected to. There's so many times we're sent out of the room when something wild and juicy and crazy is happening. We are being held out on. We are not getting enough information. So with Brennan objecting, I think it's just going to piss off the jury at Brennan. Let Jackson ask the questions, even though they are not proper. That's not for the jury to know or care about. The jury wants the answers, right? And so I think Brennan is putting himself at risk of pissing off the jury and subsequently suffering when it comes to deliberations for the Commonwealth because you pissed off the jury because you objected to every single leading question when the defense team lets you lead constantly. They let you lead always. So that's a risk. That's a risk. That's a risk, Brennan. And I get it.
What is your opinion about
it's not
whether or not-
proper. But Brennan, I'm gonna say at least 50% of your shit was improper too, bro. And it was not objected to. So a little here or there, a little leading here or there. Is it proper? No. Can he not object? Of course. Of course. But just like Brennan, Jackson is doing a great job of putting the answer in the question and giving the jury, you can't put the shit back in the horse. You can't put the toothpaste back in the tube, you know? So, it's like the infighting is crazy. The subliminal messaging is wild.
There was any analysis done by Mr. Burgess or Mr. Welcher that put the lock event occurring before the trigger?
Sustained.
May we approach, Your Honor?
Yes.
And they're going to sidebar. And I think that was a great move for Jackson because he just told the jury, I can't move forward because Brennan is making it impossible for me to move forward. And you keep siding with him, right? It's about the optics for the jury. They don't know why it was objected to. They don't know why, because we don't even get legal grounds when it comes to an objection. And which I don't think is fair because they can be like, oh, objection relevance. And it's like, no, overruled. It's if you objected for form of the question or leading, then sure, I'd sustain it. But she gets to decide. Judge Canoni gets to decide the legal grounds for the objection. All they have to do is say objection.
May I, Your Honor?
Yes.
Thank you. Back to my question. Was there any
You won.
circumstance, based on your review, that if the text stream event occurred at 12:31:38, that there was any circumstance that the lock event occurred before that trigger event?
There was not.
Did you create a PowerPoint?
He just said there's no way that the lock event of the phone, the notated, this is the time his phone was locked, that is in no way could have happened. No way could have happened before the trigger event of the car, which is the 1162-2.
For clarity's sake, in
Which the lock event is pretty much the last thing that happens on John O'Keefe's phone. So they're kind of making like the lock event a pretty key moment when it comes to John O'Keefe's phone and his life, you know, other things happening to him being alive. So there's no way that he locked his phone before the trigger event.
in March of 2025.
Yes,
Did you provide that to us?
I did.
What was the purpose of creating the PowerPoint?
The purpose of the PowerPoint was really to take a bunch of different data elements that were kind of placed throughout Mr. Burgess's report and Dr. Welcher's report in PowerPoint and compile them into a single source, a single table, essentially, to show as clearly as possible what the conclusions would be if we look at the data as a whole.
When you created that PowerPoint presentation, did you create it with the intention of providing it to the defense, which would then be provided to the Commonwealth?
Yes.
Are you aware of whether or not that was disclosed to the Commonwealth as part of the normal discovery process?
No.
So the answer is no, the answer is no.
It's not up to him.
Following
It's
your
up to you guys.
presentation of the PowerPoint to us, at some point, did you receive from Mr. Burgess an amended report, an amended PowerPoint?
I received an amended PowerPoint by Mr. Burgess, not from him, though, from you.
Fair enough, fair enough. Did that report, or did that PowerPoint, however you want to put it, markedly, was it any different than his January 2025 report?
Yes.
Did you note any conclusions? Did you note the conclusions that he came to in January 2025? Going back to the original report?
Yes.
Did you note conclusions and opinions that he came to in May of 2025?
Yes.
Were those two things different?
Sustain.
Were the conclusions, not his opinions, were his conclusions different?
Sustain.
Was there any difference in the two reports?
There was.
Tell me the differences.
The exasperation on Jackson is he's like, shit, I can't lead. Right. He's like, I'm a defense attorney. It's hard. It's hard. The switch up is hard. It goes hard. But I told you, Brennan is not going to let down. He is going to object to every leading question there can be. And I think he's going to cause more problems for himself than he is for the defense team. So we have something very interesting coming up. I'm really excited to hear what he says. So he made note of Burgess's first report. He made note of Burgess's amended report, which was delivered to the prosecution during the trial. And now we're going to hear about this professional, this expert witness, and his conclusion when it comes to comparing both of them.
In
The
first report, Mr. Burgess did some of the calculations that are necessary to correct or adjust the times based on certain approaches, but never went through the final step of applying those calculations to the times and coming up with the final time. In the supplemental report, he then essentially took that analysis to the end. He approached it in a new way, a different way than he had previously laid out in the first report, but then he also took it all the way to the end by applying those calculations to the times.
what were the main differences? Explain for the court and for the jurors, what were the main differences that he changed in the May 2025 report?
Contrasting it with the original
Correct.
report. In
Right.
the original report, he laid out some methodologies for correcting the clock using phone calls that were shared between the vehicle and Mr. O'Keefe's phone. And in the supplemental report, he moved away from the phone call analysis and moved to attempting to align the clocks using a shared maneuver between the vehicle and the phone.
What was the shared maneuver?
It was a 3-point turn.
Was that the same analysis that he had in January 2025?
He did not have that analysis in the January 2025 report.
Thank you. Based on the new information in the May 2025 report, what was the effect, as you see it, regarding the possible scenarios?
So I did the exact same process I did using the supplemental report as I did on the first report. And when I ran all those numbers and those calculations, it turned out there are now some scenarios in which the phone lock occurs after the end of the event. There's some scenarios where the phone lock occurs simultaneously, like literally at the same second. And there are some scenarios where it occurs before. So now there's a range.
So Mr. Burgess's report, his new report, his amended report, widened that gap to allow him to opine that there were scenarios that occurred after the phone lock event, correct?
Objection.
The objection is sustained.
Did you prepare a PowerPoint presentation in furtherance of clarifying Mr. Burgess's analysis?
Objection.
Sustained.
Did you seek to clarify Mr. Burgess's analysis?
Objection.
Sustained.
Your Honor, may we approach?
Yes.
I've said it like 3 times right now. One, it's difficult to not ask leading questions when you are professional at asking leading questions. We saw some of this difficulty last trial as well between Alan Jackson. In particular, he just wants to get to the point, right? Yannetti, not so much. He kind of is able to adjust a little more.
This for your PowerPoint presentation. May I?
But I think, okay, going off of if I'm sitting there, I think I want to keep asking. If I was Jackson, I think I'd want to keep asking, may we approach? May we approach? May we approach? May we approach? Every time Brennan gets carried away with his objection. I think that's what I would want to do, because I would want the jury to be like, what does Brennan not want us to hear? Because Jackson's out there asking away. He's asking the questions. I think that's a great. He did win last time. Yeah. I think he probably made a good argument on I need to lay the foundation for him getting to his opinions. So when you're asking foundational questions, you can be a little more leading. They don't follow like the same rule. Now when it comes to foundation, it's, did you go to college? Great. Can you explain all of your education? You can be a little leading. If he argued that like, oh, I need to ask these foundational questions when it comes to his PowerPoint, I need to ask these foundational questions when it comes to his conclusion, his opinion, then maybe, he might be able to get a little by, but he also adjusted his question. He found it as well. So there's things, I don't know. It's tough. It's really hard. It's not easy. Look at Lally. Wait, let me move myself. Wait, look at this pause goes hard. Look at Lally. Just there. Man. Is that a printer in front of him? What is in front of him? All right, let's get
Yes.
moving.
Did you prepare a PowerPoint presentation in furtherance of your analysis?
Yes.
What was the reason? What was the purpose for your?
He won on that. It probably won on like, look, I need to build foundation for his PowerPoint. And he lallying. He probably like jabbed Brennan in the ribs, like, leave me alone.
For
Leave
your
me alone.
PowerPoint presentation.
I needed to include in my analysis the approach and the conclusions from the supplemental report by Mr. Burgess.
May I have a moment, Your Honor?
Yes.
May I have a moment, Your Honor?
If you wouldn't mind taking a look at that document, it's a multi-page document I just handed you, and just flip through it and let me know once you've familiarized yourself with it. What is that document?
This is a printout of the PowerPoint presentation that I prepared.
Is it true and accurate?
Yes,
And it's complete?
it appears to be.
Your Honor, I would move for its admission, please.
I have no objection.
May I have that back from you? Just a quick second.
208.
Presentation. Lights off, sufficient to see what's on the screen and what's in front of you?
Yes.
Okay.
I was
Do
like,
you
yes,
recognize
eyes
what's on the
work
screen?
fine.
Yes,
What is that?
that is the title page of the PowerPoint that I prepared.
And what is the how would you describe the PowerPoint?
So this PowerPoint is largely identical to the first PowerPoint I prepared in that it seeks to take all of the different approaches between the initial Burgess report, the supplemental Burgess report, and Dr. Welcher's report, lay out all of those approaches in one kind of coherent fashion so we can look at what conclusions we can draw from all of that data.
With court's permission, can we go to slide 2?
Yes. Mr. Jackson, you can just use this PowerPoint. It's in evidence. You don't have to ask slide to slide.
Thank you, Your Honor. Taking a look at this next slide, what is this? What are we looking at?
This is a slide from Dr. Welcher's presentation that I was provided. Specifically, this is his slide number 33.
And what does it show?
This is where he introduces the first, acknowledgement that there's a difference between the time that Aperture calculated for the end of event
Stop moving the
1162-2
camera.
and the lock event on Mr. O'Keefe's cell phone.
Is there anything in this slide that you disagree with in Mr. Welcher's presentation that you disagree with? It's up on the...
I added the 2 green boxes and the text, the word after. That's not Dr. Welcher.
Whoever is controlling the camera keeps moving it. Like it's like moving with their breathing or something. They need to stop because I'm going to get seasick. I'm going to get seasick immediately.
Cultures. And I added that because it's stated here that the event occurred within 26 seconds. But if we do the math, and he actually does the math, he really means after. It means the phone lock event occurred 26 seconds after the end of the vehicle event as calculated.
That's right.
No, I'm going to allow it.
Thank you. Thank you.
The phone interaction
Thank
happened
you.
how many seconds after the text stream event?
Based on this slide, 26 seconds.
Thank you. And the text stream event that we're talking about is what number?
1162-2.
And this slide, other than the green, is this slide or the portion of the slide that we're looking at, other than what you've described, is this directly from Mr. Welcher's own analysis or his PowerPoint?
Right. I added the green box around within, the dash green box around the whole paragraph, the line, and the words after. Those are my additions.
Let's go to the next slide. Can you tell us what this is?
This is more or less a repeat of what's on the first slide, but just shown with a little more focus. The first slide is a little busy. So
Yes, it is very busy.
Did you, I'm sorry, Mr. DeSoga, did you create this or is this from Dr. Welcher's report?
I created everything on this slide apart from in the top right. That came from Dr. Welcher's slide 33.
Although you created the slide, where's the data coming from for this slide?
All of the data on this slide and all of my subsequent slides comes from the Aperture reports collectively, either Dr. Welcher's report or slides or Mr. Burgess's first and second reports.
What did their analysis reveal in terms of the time, the exact time of the lock event for Mr. O'Keefe's phone?
So in their analysis, in Aperture's analysis, they report the Lexus event 1162-2 ends at 12:31:43. And they also report there's a phone lock at 12:32:09. So if we just simply take the difference in those two times, we get 26 seconds.
If you were to add the 5 seconds back to 12:31:38, which is the actual trigger event, what would you come up with?
31 seconds.
Which of the two, in your expert opinion, which of those two numbers is more accurate as it relates to the trigger event?
If we wanted to conduct the analysis relative to the trigger, it would be better to use the actual trigger time. However, as long as we're consistent through the analysis, it's not entirely wrong to use the end. It would be wrong if I suddenly switched up and started talking about this relative to the trigger event, but they present it as the end of the event. So I conduct the rest of my analysis using that convention.
Is another word for the end of the event the end of the recording?
End of the recording. Yeah. When I say event, what I mean by that is the data event, the data recording event.
But the trigger event itself, 12/31/38.
Correct.
Did you put a name on this gap, if you will, this time frame?
Yes, I did. For the sake of the rest of the analysis that I'm going to do, I thought it would be helpful to just refer to this difference in time as John's interaction window.
And that refers directly to the interaction with the phone, the human interaction of locking the phone.
The 12/32/09 lock.
Okay, let's go to the next slide, please. What does this slide show us?
So this here, what I'm doing is I'm kind of laying out the bounds of what I mean in John's interaction window, which should make, we have a lot of numbers to go through here. And so this should give us a very easy metric for kind of determining whether we have an event before or after. So what I mean by that is when we calculate John's interaction window, if that number comes out and is positive, that means the phone interaction occurs after the end of the vehicle event. And if we calculate John's interaction window and that number becomes a negative value, then that means the phone interaction occurs before. So now we have just a convention we can use really quickly to say, is it positive or is it negative? And we can maybe spare ourselves some of the math with 1,000 numbers.
So positive means what? One more time.
No,
Positive, John's interaction window positive means the phone lock occurs after the end of vehicle event 1162-2.
Got it. Let's go to the next slide, please. What does this slide show us?
So what I'm saying here, I'm kind of laying the foundation for why we're going to even do this. Why do we need to start doing math on these clocks? So fundamentally, the phone, Mr. O'Keefe's phone, and the vehicle, Ms. Reed's vehicle, they're separate clocks. And it's very unlikely that they're going to be aligned perfectly in time. Right? If I compared my watch to your watch, it would probably be off. And that's the same case for any two independent clock sources. So Aperture, in their collective reports, propose a number of different ways in which that can be corrected. So I'm going to go through all of those ways that Aperture has proposed and show if we align the clocks based on how they laid out, does John's interaction window stay positive or does it ever become negative?
Hold on, sorry. I'm like deep in it.
Negative. Where does it end up when we run
Sorry,
all those
let me go
analyses? Or another
Let
way
me
to
go back.
go,
Let me go back.
different within clock sources. So Aperture, in their collective reports, propose a number of different ways in which that can be corrected. So I'm going to go through all of those ways that Aperture has proposed and show if we align the clocks based on how they laid out, does John's interaction window stay positive or does it ever become negative? Where does it end up when we run all those analyses? Or another way to put it is, does the phone interaction always occur after the end of the vehicle event?
And what did you determine?
Based on the initial reports,
Yes.
the phone interaction always occurs after the end of the vehicle event.
Did all of the information that's on this slide come from the same source or multiple sources, meaning Mr. Burgess and Dr. Welcher?
In the PowerPoint as a whole, all the information comes from the Aperture reports collectively,
Okay.
from Dr. Welcher and Mr. Burgess.
Did Mr. Burgess make any adjustments from his original report to his subsequent report in May of 2025?
Yes.
Let's go to slide 6, please. Tell me about this slide.
Yeah. So this is the first adjustment we're going to talk about. And this one comes from Mr. Burgess's original report.
Can I see this
To
slide?
summarize this adjustment, this is a key on timing adjustment, and we're going to show that the key on, the actual turning of the vehicle on, occurs about 3 seconds before that time gets registered in the infotainment. So the time we see is basically stale by 3 seconds.
We're all familiar with how computers turn on.
Could I see the slide?
A physical key, or could it be the push
Hello?
button to turn the car on?
In this case, it's a button. I refer to key on because generally that event is considered the key on in vehicle parlance, regardless of whether there's a physical key or it's a push button.
So those 3 seconds mean what? What's the difference between pushing that button and the 3 seconds later that you just described?
It means that when we're trying to use the timestamps that were recovered from the infotainment system that show when the vehicle was keyed on or turned on, that the vehicle was actually or likely turned on 3 seconds before that.
Do you know where the 3-second conclusion came from in Mr. Burgess's report?
That came from the testing that Aperture conducted with the exemplar Lexus that they purchased.
Was there anything in the report that indicated testing, this type of exact testing on Ms. Reed's actual Lexus?
No.
Do you have an opinion as to whether or not all Lexuses, at least of this make and model and year, would have the exact same 3-second delay? Or could that be different?
It could be different in their testing. In their testing, they only tested one exemplar vehicle. So I think there was a solid foundation that the exemplar that was used exhibited this 3-second delay. It was a very close match in terms of part numbers and software versions to Ms. Reed's Lexus. But without any kind of testing of, let's say, a second vehicle, a second exemplar, we wouldn't know. We wouldn't have any basis to say it must be 3. We could test a second vehicle and it could be 5. So we say, well, there's a delay, but it varies vehicle to vehicle. They could have tested a second vehicle and found it's also 3. And then you start to build some confidence that maybe it is 3 across every vehicle. But with only testing one and not testing the subject vehicle, it is difficult to say with absolute certainty it would be 3 seconds.
What is your opinion about best practices?
That is
with regard to
fantastic
concrete?
for the jury to hear. They only tested the exemplar vehicle that they purchased to do this test. They did not even test Karen Reed's vehicle for the key on timestamp and the possible time variance between the timestamp and the actual keying on event. That is fantastic for the jury to hear.
This gap for purposes of coming to an opinion or an analysis.
So because we don't know whether or not this specifically would apply to Ms. Reed's vehicle, the best way to conduct that analysis would be to do the entire thing with the key switch adjustment at 3 seconds. Because if we're going to use a value, 3 is the most reasonable one because that's the one shown in testing. But we should also do the entire analysis without it in case we feel that that's the most appropriate. So in fact, that's what I do and will show is I ran the analysis both ways, with and without, to be as conservative as possible.
Did your review of Mr. Burgess's report indicate that he ran the analysis both ways?
He did not.
Let's go to slide 7.
Damn.
What are we looking at here?
This is an excerpt from Mr. Burgess's original report. His page
thank you.
28
I'm
and his
so
page,
happy I get to see the
there's a
slide.
screenshot also from his page 30 at the bottom. And this is where he states in
They did not show, he did not even move the camera to show us slide 6. I know it was probably just a couple of words typed out, but like, golly, I would love to see it. Whoever is running the camera, please. Are you tired? I'm sorry, but
that report
please.
that when they were doing the testing with the exemplar, they observed across 4 different key on cycles this 3-second difference. So what I mean by that is they had a video camera in the car that had a timer on it. And so in the video, you can see the button pressed. So in their testing, for example, they pressed the button at 21:48:05, and that's sort of nailed down. When they went back and downloaded the data from the infotainment, the key on was logged in the infotainment as 21:48:08. So there's the 3 seconds. That's where they're getting that from. And that's what he states highlighted in red there. It's a little hard to read, but it basically says the average across 4 runs was 3 seconds.
The 3-second delay, was that actually in his report?
This is the only point in the report it's mentioned.
And I guess what I'm asking, it was an inartful question. The portion to the left, is that his report or your report?
That is his report. Everything on the left-hand side of the slide comes from Mr. Burgess's report.
So the 3-second delay was noted in his report.
It was noted.
Did he apply the 3 seconds in his analysis?
He did not.
Did he indicate in his report why he ignored that 3-second delay?
He did not.
Sustained as to that question.
I'll rephrase it.
Strike the answer.
Did he indicate in his report the reason that he did not apply the 3-second correction?
He did not.
When you do apply the 3-second correction, what do you come up with as it relates to the 26 seconds from the end of the recording?
So the positive 26-second window, if we only apply the 3-second key on, grows to positive 29 seconds.
If you apply the same 3 seconds to the trigger event time, now what does the gap?
That gap would grow to a positive 34 seconds.
Between the trigger event and what?
The phone lock.
Wow.
In your opinion, was
Like,
it
this is so dumb.
best practice to,
This guy's face is giving, I don't want to be here, but his words are giving clarity and clean and concise and knowledge and expertise, but his face is giving, oh my God. Are we being close to done and I'm going to be cross-examined by this fool over here? He's giving, I don't want to be here, but his words are so important. His words and his knowledge are so, so important to this case. Like, I don't even know if he understands how important this is to Karen Reed, to her defense, to the case overall. This is important.
not account for that 3-second delay between the on switch and the data coming on?
Sustained activity.
What, in your opinion, would be the best practice in terms of this 3 seconds that was noted in the exemplar vehicle?
The best practice would be to run the analysis with that adjustment included and without that adjustment included. Because like
Which
I
is what he
stated,
did.
without testing of an additional vehicle, we really don't know if 3 seconds is just a specific behavior of that exemplar or if it's representative of all Lexuses of this type.
Let's go to slide 8, please. Tell us what we're looking at in this slide.
So now we're going to get into the next adjustments. That first adjustment we just talked about was really a vehicle-to-vehicle adjustment. We haven't talked about the phone yet. We're going to get into the phone now and talk about aligning that. But we had to get through the internal adjustment that has to get done first. Now we're going to look on the subsequent slides here at all of the different ways the aperture reports compared the vehicle to Mr. O'Keefe's phone.
Is there any additional adjustment that you believe should be made?
The aperture reports lay out 2 methodologies for adjusting. There is a methodology based on phone calls, and there's a methodology based on the 3-point turn
And where did you get that information from?
from the aperture reports.
In Mr. Burgess's original report on differentiating, the January report, which did he use to determine his determination of the clock skew?
In his
He
initial
used phone
January
calls.
report, he never actually takes the calculation to the end by applying the differences in times to the calculated time for 1162-2, but he does do the math, which I'll show, for the differences on these phone calls.
In terms of Dr. Welcher's report, did he identify a GPS point of 154 at all?
Yes.
How did he describe that GPS data point?
He describes in his initial PowerPoint slides as 0.154 aligning with the end of vehicle event 1162-1, talking about a different event now. This is the 3-point turn event. So he uses that as an anchor point.
And that anchor point you said was the end of the text stream event, or the end of the recording of that text stream event.
Correct. The aperture reports consistently reference everything from the end of the events.
Let's go to slide 9, please. What are we looking at here?
On the left is an excerpt of page 33 from Mr. Burgess's initial report. And what he shows here is he has identified 7 call logs that exist both in the infotainment from Ms. Reed's Lexus and in Mr. O'Keefe's phone. He puts them in a table form. Then he actually goes on and calculates the difference between those 2 times. So that's what I meant by he sort of does the math. He makes my job a little easier, and the numbers are already there. He just never applies these to any of the times. So that's where I step in and say, if I take that 3rd column that he lays out, those are in seconds. If I apply those seconds, that adjustment to 12:31:43, where do we end up with John's interaction window in those times?
What did you conclude in terms of finishing the work?
Sure, I did all of them. And so I highlight on this particular slide, I just highlighted the very first one he has in here. In that case, he identified that Mr. O'Keefe's phone was 2 seconds slow relative to the infotainment system. So if we apply only that adjustment, then John's interaction window becomes positive 28 seconds.
Did Mr. Burgess apply all of the potential offsets?
He didn't apply any of the offsets. He calculated all of them, but he didn't apply any of them.
Did you ultimately apply all of the offsets?
Yes, I did.
And what did you determine?
Regardless of which offset you apply, John's interaction window remains positive. The number changes, but it remains positive.
Let's take a look at
Burgess did some work, not all of it. And he got a little jab into Burgess. He said he made my life a little easier by at least calculating it. That was cool. But he didn't apply it. Like, you started, but you didn't finish. You started, but you didn't finish. It's incredible. This is incredible. This is incredible.
take a look at those one at a time if we can. Let's have the next slide.
Thank you.
So in this slide, I just took the other end of the spectrum. There's a large range in values in this table. He doesn't actually, Mr. Burgess doesn't show the sign conventions on here, but actually
Sign conventions.
sign conventions, he doesn't show when he calculates the difference, whether it's positive or negative. All the numbers in the table don't have a sign, don't have a plus or minus in front of them, but there's an implication. Some of them are plus, some of them are minus. So the first one that we just looked at showed we had 2 seconds slow. There's another value in here that's on the other end of that. It shows that Mr. O'Keefe's phone is 21 seconds fast now relative to the infotainment. So that's the largest value in the table we could take that would bring John's interaction window down now. And so if we apply just that adjustment, John's interaction window becomes a positive 5.
Take a look at slide 11, if we could, please. What are we looking at here?
So I've shifted now from the phone calls, and now we're going to talk about the 3-point turn alignment. And the 3-point turn alignment is first presented in Dr. Welcher's slide from his presentation here. And in this, he doesn't say it explicitly, but he provides some math on the screen, which is a little hard to read. But he puts some math on the screen that shows he's aligning this 0.154 from Mr. O'Keefe's phone to the end of event 1162-1. This is the prior event. This is a 3-point turn. And so he aligns, he says this is basically how you align it. And he doesn't do the math. Again, he lays out that he says a 19.2 second difference. I actually just adjusted that to 20, which is the most conservative way to interpret that. I don't think we have the accuracy here to talk about tenths of a second. Nevertheless, I just rounded that up to 20. And when we apply that 20 seconds to our event 1162-2, then John's interaction window becomes positive 6. That's just applying this. We're not combining anything. We're just applying the difference shown in this slide.
And that positive interaction window, is that calculated based on information directly from Dr. Welcher's report?
Yes.
Let's go to slide 12. What are we looking at here? What is this table?
This is a table I
Infotainment
made.
is so fucking fake.
We talked about a lot of different approaches to how these clocks can be aligned and a lot of different variables. So I tried to summarize them in one table, put them all together, because some of them we can combine. We can combine the key on with either a phone call or a 3-point turn, but we can't combine, for example, a 3-point turn and a phone call. That's not valid. So I put all the possible combinations, all of them, with, without key switch, phone calls, and 0.154 on one table. And I calculated John's interaction window for all valid combinations from the Aperture reports. And when we do that, the result is that regardless of what adjustment we make, all of the numbers are positive, meaning regardless of what adjustment we make, the phone lock event always occurs after the end of event 1162-2.
Did Mr. Burgess, in your review of his report in January 2025, did he ever undertake all possible offset calculations?
No.
In his May 2025 report, did he undertake all possible offset calculations?
No.
What is your opinion in terms of best practices regarding calculations of this sort?
I think if there's sufficient data, if there's testing or research or literature that in a specific case supports there is a best path or a best method, then we should use that. In this case, I don't think there is a best practice. There isn't any literature I'm aware of that would specify exactly the best path to align all of these. So in the absence of any external data to support one path, the most valid approach is look at all of them as a whole and then draw the conclusion from the totality of that data rather than cherry picking a single point.
Can you testify to a reasonable degree of scientific certainty whether all potential offsets that were described in Aperture's original report, January 2025, result in a positive interaction window?
Yes.
And what is that opinion?
Regardless of what adjustment or combination of adjustments we make from the original reports, John's interaction window remains positive.
Does the positive interaction window mean the lock event occurred after or before the text stream event?
It means the lock event occurs after the end of the text stream event, 1162-2.
What's up?
You've already
What's
indicated that you
up?
received a
What's
second
going on?
report, May of 2025, correct?
That's correct.
In that report, is there the same clock skew alignment or a different clock skew alignment that Mr. Burgess now undertakes?
Mr. Burgess undertakes a different alignment in that report.
Let's go to slide 13.
Now he's basing things off of the 3-point turn GPS
Describe what we're
data.
looking at in this slide.
So what I have here on the left is a screenshot of page 42 from Mr. Burgess's supplemental report. And so now he's done two things new here. He's identified a new method for aligning the data based on the 3-point turn. So now he's kind of following where Dr. Welcher started, but he's approaching it a little differently. And secondly, he is now calculating the actual time. He's doing the difference calculation and he's applying that to the time. So now he's taking the calculation all the way through, which is a little different from the prior reports. And so when he does that, he makes my job really easy because I didn't have to do really any math now. He comes up that there's a range now. So prior to this point, the original report by Mr. Burgess and Dr. Welcher reports all used discrete points in time, right? They sought to find an event that occurs at a singular second and another event at a singular second and align based on that. This is a little bit of a departure from that approach. Mr. Burgess is now using a range of times, a range of uncertainty. He basically assesses that the 3-point turn data from the phone and the 3-point turn data in 1162-1 cannot be precisely aligned down to a single point. Rather, they overlap in this range of seconds. And so he then says that that range must be applied. So now we have to apply a range. And what we end up with is 9 possible values. So it kind of looks like one conclusion, but really there's 9 conclusions on this slide. And so if we just applying the math he has in the supplemental report, John's interaction window now has a range of 9 possible values. And that range spans from +5 now to -3. So we have 5 positive values. We have 1 value that's 0, and the 0 would mean it's simultaneous. And then we have 3 negative values.
Does Mr. Burgess indicate in his report that any one of those?
So that means that there's 5 positive values where the lock event on John O'Keefe's phone at 12:32, whatever, happens after the finality of the text stream. There's one where it happens at the exact same time. And then I think there was 3, he said, where it would happen before. So like 1 second, 2 seconds, 3 seconds before the end of that text stream.
One of those values is more likely than any of the other values.
He does not provide any data or analysis to support 1 point being preferential over the other 8.
And are there more or fewer positive results in his analysis than negative?
There are more positive numbers in that range of 9 than there are negative numbers.
Does Mr. Burgess's new data indicate anything about Dr. Welcher's analysis about the GPS data point 154 being at the end of the 3-point turn?
What are you having
opines
for
in
lunch?
that aligning
I
the
wanna know.
3-point turn on a singular point is not, and I'm paraphrasing because I don't know the exact way he states it, but not the preferred method.
Is Mr. Burgess's analysis consistent or inconsistent with Mr. Welcher's determination that GPS point 154 was at the end of the text stream event?
Objection.
Sustain.
Does Mr. Burgess in his report indicate whether he agrees or disagrees with Dr. Welcher's analysis?
I don't remember specifically.
In your opinion, I asked you about Mr. Burgess's report. Now I'm going to ask you about your opinion. In your opinion, is this new offset any more likely or reasonable than any other offsets previously proposed by Mr. Burgess?
I don't think it is more or less likely. I think it is a valid approach, certainly. And so I think the results from the additional analysis should be included with the analysis of all of the results so far.
And none of those results are more or less likely than any of the others, correct?
Sustain.
Are any of the results, in your opinion, to a reasonable degree of scientific certainty, are any of the results any more or less likely than any of the others?
In my opinion, they're all equally weighted.
Did Mr. Burgess account for the 3-second offset that we talked about earlier in his May 2025 report, his new report?
I did not see any mention of that in his supplemental report, and certainly the 3 seconds isn't present in his math. I don't see it there.
Let's go on to slide 14, please. Describe what we're looking at here in this table.
This is very similar to the table we looked at previously, where I look at all possible combinations. Now, however, I just have a lot more data points to show, so I've had to break the table into 2 tables. So we're going to look at this, and then we'll look at slide 15 next, which is the second table. I just couldn't cram 30 lines onto one slide.
Let's move to the next slide then. Is this a
So there's
continuation of the
second half. So think of these as a singular table. I just had to split them up. If we head back to slide 14, we'll start there. So this slide, I'm not accounting for the key on, and that's the main difference between my 2 tables. Table 1, I'm not accounting for the 3-second key on. In table 2, I am.
When you say key on, you're talking about that 3-second delay.
Correct.
Okay, go ahead.
But again, I want to make sure we're thinking about this as
Yeah,
a singular
we're
table because that's
behind
where
a
we'll
little
draw our
bit, but yeah.
conclusions from. So the first lines of the table, we've already seen those. Those were in my original table. I haven't changed those. That's the
But this
same
is
math that's
today.
been there. All I did was I added the 9 points now from Mr. Burgess's supplemental report using the range he shows. And so now we can see if we include that, now we get some positive numbers for John's interaction window. We get that 0. And again, the 0 would imply that the end of event 1162-2 is happening exactly at the same second as the phone lock. So it's kind of not on one side or the other. So I think it should be thought of as separate. And then we have 3 negative values, which would imply that phone lock
You're
occurs before the
welcome.
end of 1162-2.
And did you already mention the one that was simultaneous?
When John's interaction window is 0, correct?
0.
That would imply simultaneity.
All right, is this 14 or 15? This 14, let's move to 15. Now, this is
Same.
a continuation of that. Mentally, we'll just continue that same table?
Correct.
Okay.
Just a continuation. Imagine in your mind is just row 16 to 30.
Okay,
And it's the same thing, same format, except for now we're just adding in that key on adjustment because again, I think the analysis should be run with and without it. And so now when we run this with the key on adjustment, we get 14 of these 15 are John's interaction window is positive to various degrees. And one of them, it's 0, again, simultaneous. And there are no negative values with this adjustment.
can we go to the next slide, 16, please? What are we looking at here?
This is the summary then of that table, kind of a verbal summary of the giant 30-line table now. And if we look at all of the possibilities from all of the Aperture reports collectively, then we can draw some pretty straightforward conclusions. 25 of those 30 possibilities result in interaction with the O'Keefe phone after the end of event 1162-2. Looking at all the possibilities, 2 of the 30 result in interaction where it's simultaneous. That's the zeros, they're present in both tables. And then looking at all 30, 3 of the 30 result in interaction with the phone before the end of event 1162-2.
Do you have an opinion as to which of these particular offsets that you've described, these 30 possibilities, should be applied in this case?
No.
Why is that?
Each of the approaches have their own individual strengths, and each of them have their own individual weaknesses. And there is not really any published literature, any research, or any testing done that I'm aware of that would suggest one really stands head and shoulders above another one of the methods. So I think the most fair way to present it is to look at, again, if we combine everything together, then we can draw some conclusions like this in terms of how many of the total result in one outcome or another.
Is every data point that we're looking at and that you've been talking about, are these all drawn directly from Aperture's reports?
That's correct. I have not proposed any methods for aligning the clocks myself. All of the methods that comprise these 30 are from the Aperture reports themselves.
Based on your analysis of the Aperture, or your review of the Aperture analysis, is there any ability to say to a reasonable degree of scientific certainty that the tech stream event occurred after the last physical interaction with John O'Keefe's phone?
Yes, there would be three out of the 30 possibilities would result in that.
Do you have an opinion to a reasonable degree of scientific certainty that it did happen after the tech stream event?
Sustain.
Of the 30, what's the percentage of possible events that occurred, possible scenarios, I should say, wherein the tech stream event occurred after the
Sorry, I
last
had to
interaction
pee.
with Jackson? What's the percentage?
So that's sustained.
I was
You
listening.
said it's 3 out of 30, correct?
Yes,
Is that 10%?
that is 10%.
Yeah, they're sustained and then it's stricken.
What percentage is 3? Just do basic math for me. What is the percentage between 3 and 30?
Sustained.
If I told you hypothetically,
I'm going to see you sidebar for a second.
Brennan really does not want this witness to say there's really like no way that the phone lock happened before the end of the text stream. I mean, he really does not. He is fighting Jackson when it comes to the final opinions, conclusions from this witness, and he's also fighting Jackson and getting a little too flying a little too close to the sun when it comes to his questions. It's very interesting. We've had so many sidebars just today, and I think that is how unless you could still get it. I think this is how this entire case in chief was going to go, and I don't think the jury is going to like it. I don't think the jury is going to like it. They're not going to be happy with it. This is not the vibe that they want. They just want the answers to the questions. They just want to hear the testimony, but Brennan is going to make it as difficult as possible. I think that's his goal. I think that's his goal. He's just gonna interrupt as much as, and by interrupt, I mean objecting to everything that he possibly even could. Because that's Brennan.
following your analysis of the totality of the
So many
possible
sidebars.
scenarios, did you come to a conclusion that the vast majority, let me rephrase that, did you come to any conclusion about the numbers as they relate to the positive interactions versus the negative? And when I say positive versus negative, I'm talking about the phraseology that you used. John's phone interaction being in the positive side versus John's phone interaction being in the negative side.
Hashtag go away, Brennan.
Yes.
And what were those?
Of the 30 possibilities, 25 of them, it's a positive. John's interaction window is positive for 25 of them.
And only 3 were negative?
Correct. Only 3 of the 30 were negative.
Okay, we can take that slide down.
That's all he doesn't need to do anymore.
Is there a data recorder on the Toyota SUV that we've been talking about, that 2021 Toyota SUV 570, that's designed to record impact?
Yes.
What is that? What is that mechanism?
That would be the airbag control module,
The ACM?
ACM.
Did you look at that?
I was provided a copy of the download from the ACM.
What did the data recorder indicate, if anything, related to any impact on January 29th, 2022?
There were no recorded events whatsoever on the ACM.
Did the vehicle control history
Sensitive,
record whether there was any history of a collision on that car, ever?
No.
What does the vehicle control history record specifically?
Thank you.
It records a lot of operational parameters about the vehicle. What I mean by that is it records things like what the driver is doing, for example, steering wheel angle, accelerator pedal position, whether the brake is being pressed. It also records what the vehicle is doing, for example, speed or the engine RPM or the accelerations of it.
Does the tech stream data event indicate that there's a, and I'm talking about very specifically the tech stream data, does that indicate whether or not there's a collision in the car?
No.
Does the tech stream data event mean that if you find a tech stream data event or a trigger event, does that mean that the airbags are deployed?
No.
Does it mean that the vehicle impacted with something solid?
No.
Does it mean that the vehicle impacted with a pedestrian?
No.
You reviewed the raw tech stream data associated with the entirety of Ms. Reed's vehicle, did you not?
Yes.
How many tech stream events or triggers were found on Ms. Reed's vehicle during the course of the 8-month period prior to January 29th?
So can you narrow that, Mr. Jackson?
Sure.
I object to the whole line.
Then I need to see you sidebar.
Here goes Brennan. I object to the whole line of inquiry. He says, I need to see you at sidebar. And then I need to see you at sidebar. Can we be seen? Can we be heard? Can we go to sidebar? May we approach? Sidebar, sidebar, sidebar. This entire defense case in chief is going to be in sidebar because Brennan is going to fight tooth and nail. Tooth and sidebar. He's going to fight tooth and nail. Let's see how long this is. Sidebar. No strays. How are you? How are you? Let's see. Just in time for my famous goat impression. So embarrassing. Hey, Lily, what did you do on the internet today? I cackled like a goat. Oh my gosh,
Yeah.
very long sidebar.
Much
Sorry.
longer. I'm just trying to figure out.
I'm wrapping it up, Judge.
Okay.
It's not going to be long. A few more questions.
Did she really ask him?
Okay. Mr. Jackson, how much longer? I'm just trying to figure out.
I'm wrapping it up, Judge.
Okay.
It's not going to be long. A few more questions.
I'm not curbing you in any way. We just
Understand. Respectfully, it won't be very much longer.
That could have been asked at sidebar. Because now the jury is hearing you asking the defense again. How long? How much longer after we just sat through 23 days of Brennan? Yes, it was a lot of cross, but cross is needed. Cross is funny. Hank is up next on Cross. Get your popcorn ready. She better watch it. Take it easy. It's gonna be as long as it takes. I know that right there could have been handled at sidebar. I think that was a question that should have existed at sidebar. I really hate that she continues to ask that. Me too. I know why, because she just wants to know, like, we need to take a break because lunch is going to be here soon, and it's going to, if we go for too long, what's the point of taking a break? But the jurors need a break, the employees need a break, that type of thing. But they were literally just a sidebar. They were literally just there.
You reviewed the text stream data, otherwise known as the triggers, for the entirety of this Reed's vehicle, correct?
Yes.
How many trigger events did you find in the life of the car?
Not counting 1162-2.
Let's stop there. Right.
Prior to 1162-2, there were 19 prior events.
And 19 total events, correct?
Correct.
And how many collisions were clocked by any recorder on that car?
None of the events were triggered by collision.
No collision triggering events.
And
Back to work.
Last question.
Have a good rest of your
do
day,
any
Ray.
Of the text stream events, or
I'll see you in a
any of
little
the
bit.
data that you've reviewed, either yourself through Mr. Burgess's report, through Dr. Welch's report, do any of the data indicate that there was a collision on January 29th, 2022 at any time? Objection.
Ask it differently.
What did you find in terms of, I want to narrow this question to January 29th, 2022. What did you find in terms of any data regarding a collision?
Neither of the events that occurred on that date were triggered by collision.
Thank you. May I have just a moment, Your Honor?
Neither events triggered by collision. I want to know how the jury is feeling right now. Before cross, I want to know how the jury is feeling. I can't know, but I want to know. It's what I want.
That's all I have. Thank you.
Okay. Jurors, we're going to take the morning recess. There's some things that I need to do with the lawyers. We'll have you back at 12.
What do the lawyers need to do?
Can I see counsel at sidebar to save us some time, please?
Yeah. Okay. She's gonna none on the record. That's cool. That's super cool. Oh wow. We're almost like really caught up. We're gonna take a little break too. Hey, I have a question. Before we do, I have a question. Do we like this? Or do you like this? Which one do you like better? The second one. Okay, let's take like a 10-15 minute break. 12:25, 35, 12:40. Let's come back at 12:40 p.m. Eastern Standard Time, because now we got folks on different sides of the countries. And we're gonna be grooving until then. I'll see you in a little bit. I'm back early because for those of you who stayed, I want to show you my new Lego sets. I'm having a pack of Gushers. And by new, I mean I've had them, but I finally built them. We'll pick back up with Court at 12:40, like I said. Look at the little peacock. How cute. Look at his little feet. Look at his little feet. Look at his little feet. I love it. Peacock addition to the Lego world behind me. And also this guy. Hi. I'm for calming and soothing from trial insanity. So, new Lego sets. I've been looking at Lego sets that I want to get. And I don't know what to get. Ooh. 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 Let me show you these. Let me see what you guys think about these. Look at this one. Look at this one. I want that. That's so good. I want it. I want it. Ooh, they're quite large. I'm getting it. I'm getting it. I'm getting it. I love that. What do you guys think? We have 2 more minutes to start. Back. Oh, yes, put them on the wall. Or they can stand. Oh my God. I love that. Look at how cool. Oh my gosh. So that's the set that I want. And I also want this one. I also want this one. Look at how cool. Oh my gosh. Rawr. Rawr. Is that not so cool? Look at the little people. The plaque. I want it so bad. $250 is crazy, but I want it. But I want it. Look at it. Look at it. Would you just look at it? It's so cool. Yes, the plaque. Tyrannosaurus Rex. Name meaning the Tyrant Lizard King. I want that. I want it. 18,518 pounds. All right, let's get back to court. Let's get back to court. Shall we? Shall we? Shall we? All right, back to court time.
All right, Mr. Brennan. And Mr. DeSogra, I'm going to ask that you keep your voice up because we're going to try and keep the air conditioning on. And the fans, it's a little stuffy in here. So if you just speak directly into the microphone, that would be great.
No problem, Your Honor.
Thank you.
Okay, we are officially in cross-examination of Mr. DeSogra. Here comes Brennan on cross. Now, is Brennan going to flourish on cross-examination? I'm sure. He is a defense attorney. He has been doing this for many, many years. And this is where defense attorneys really do flourish because they are asking direct questions. So let's see what Brennan brings to the table for his cross-examination.
May I proceed?
Please.
Good morning, sir. Sir, are you trying to offer an opinion suggesting that Ms. Reed's Lexus never hit John O'Keefe on January 29, 2022?
Is that, I'll allow it. Is that what you're doing?
Is that your opinion?
No, sir.
Are you offering an opinion that Ms. Reed's Lexus never got in a collision before?
The way I stated it was none of the prior events were triggered by a collision.
What I'm asking you, are you offering an opinion that Ms. Reed's Lexus never got into a collision before January 29, 2022 or on that day?
No.
So when you were talking about collisions to the jury, you weren't making any suggestion that that Lexus was not in a collision, are you?
I think you threw a double negative in there. Can you just clarify what you meant? Yeah.
You are not suggesting to this jury that Ms. Reed's Lexus did not ever get in a collision before?
No.
Okay. You're just saying that there's no data on the text string to suggest a collision.
Specifically, none of the events were triggered by a collision. That's
Text stream data can be triggered by a number of different things other than a collision. Isn't that true?
correct.
And in fact, when you talk about text stream data, you know that text stream data does not record a collision. You know that.
A collision is not one of the triggers. That's correct.
Right. So when you were saying it wasn't triggered by a collision, it's never going to be triggered by a collision ever on text stream data.
Not the collision in and of itself. Correct.
Right.
Mhm.
Right. So there's other things that will trigger text stream data,
Correct.
like sudden acceleration.
The only acceleration trigger that I'm aware of on text stream is if there's a large acceleration during what Lexus calls a PCS or a pre-collision safety event. But a large acceleration on its own, I do not believe is one of the triggers.
Are you sure you know a lot about text stream data?
Yes.
Sustained.
Whoa.
About text stream data?
Yes.
And you're saying that if it
Whoa. Brennan came in hot. I know it's it might be a little hard to hear because they have the air conditioning running. I guess it's a little warmer in Massachusetts than it is here.
On its own, I do not believe is one of the triggers.
are you sure you know a lot about text stream data?
Yes.
Sustained.
Do you know a lot about text?
I hope he was prepped. I hope this guy was warned that like Brennan's going to come in hot. Don't take it personally. And that goes for all of the Commonwealth's witnesses as well. When Yanetti, Alessi, or Jackson come in hot, don't take it personally. They're just doing their jobs. Wow, that's rude. I'm going to slow it down back to normal speed. Just because
Text stream data?
Lexus
It
calls a
is
PCS or a pre-collision
hard to hear.
safety event. But a large acceleration on its own, I do not believe is one of the triggers.
Are you sure you know a lot about text stream data?
Yes.
Sustained.
Do you know?
he said, "Are you sure you know a lot about text stream data? You sure? You sure you know what you're talking about?" And in comparison to the direct examination of this witness and the direct examination of Shannon Burgess and the direct examination of Dr. Welcher, this man was clear. I think this man was clearer than the two combined. And I don't know if the jury's going to like it. I don't know if the jury is going to like you pretending at this point as a special prosecutor, as a prosecutor, as the Commonwealth. I don't know if the jury is going to like you pretending, here's some air quotes, pretending to be a defense attorney, to pretending to be Alessi, pretending to be Jackson, that sort of vibe, that sort of I'm going to make personal jabs at you type of energy. I think they are just not quite ready for it. I think maybe work your way up to it.
Do you know a lot about text stream data?
Yes.
And you're saying that if a car accelerates over 30% in and of itself wouldn't initiate a trigger?
I'm not sure I understand.
You just said pre-collision is the only time sudden acceleration, from your perspective, would cause a triggering event. Now, I'm asking you,
I'm allowing this.
if someone accelerated Ms. Reed's Lexus at over 30% acceleration, would that cause a triggering event?
I am not sure what you mean by 30% acceleration.
Accelerator, 30%.
Accelerator pedal.
Yes.
Oh, yeah, there's a lot of triggers there's a number of ways that these VCH events can be triggered based on the accelerator pedal angle. I think, yeah.
And what is the percentage from your experience that would create a triggering event?
There's various. Toyota, Lexus calls it high, medium to high is what they put it.
Do you have a number? Do you know the actual data on what percent of pressing the accelerator on the same Lexus as Ms. Reed's would create a triggering event? Do you know?
Off the top of my head, I don't know the exact percentage down to this percentage point, no.
There is something different than the texturing data. That's the EDR data, correct?
Yes.
You would not expect, it would be abnormal for the EDR to register data based on a side swipe between a 6,000-pound Lexus and a 216-pound person, wouldn't it?
Objection.
I'll allow it.
That would be abnormal to register that data in the EDR, wouldn't it?
I don't know if I would use the word abnormal, but I would state it that there's a minimum threshold to record in the EDR, and a pedestrian impact generally wouldn't meet that.
I'm sorry.
A pedestrian impact generally wouldn't meet that, but I don't want to make a blanket statement as if it's always the
You're
case.
saying it would meet that?
Would not.
Would not. Okay. And a side swipe or a clip has less force and impact than a head-on collision, depending on the speed, correct?
Generally, yes.
He did a quick
When
glance over at the
you
jury.
are discussing,
He did a quick glance over at the jury. He's leaning his head. It looks like he's leaning his head up to try to hear him because this damn air conditioner is loud as sin. I wonder. Let me just go back. He makes a little quick glance at the jury. I wonder if it's because someone made a noise, turned a page, or was like vigorously writing something down. Maybe they did like a shift or something. He has not looked at the jury a lot. He does not have a lot of experience testifying as an expert. I wish he did look at the jury a little more during direct examination to say, hey, this is the truth. So here's the thing, guys. When it comes down to this, point A, point B, point C, point F, G, H, I, they did it, kind of. I'm going to do it all the way type of thing. I wish they had a little more connection with the jury.
collision, depending on the speed, correct?
Generally, yes.
He has a glance over at the jury. Did you see his glance? He glanced over at the jury. I don't know. I want to know why. We'll never know.
When you are discussing the triggering event, that is the moment that something registers to the car to capture data in the text string, correct?
Correct.
So if I was to suggest 30% of depressing the accelerator pedal would cause a triggering event, would the triggering event be when it reaches 30%?
Yes.
The event data captures potentially part of an event, doesn't it?
Dater.
I think we're into semantics a little bit, and I think it depends on what you mean by event. Because previously we'd been talking about an event as the data, but event can mean a lot of other things.
If an event's only 3 seconds long and 10 seconds of data is captured, then the data will capture more than the event, correct?
Correct.
If the event is longer, 15 seconds, 20, 25 seconds, and the data is only captured for 10, the text stream data only captures part of the event.
Correct.
Fair to say?
Very fair.
So when you're looking at the data, it doesn't tell you about the entire event, correct?
The data only tells us about the window of time the data captures. There's no way to know beyond that from the data.
All of your equations and pluses and minuses and graphs you're talking about deal with the 10-second text stream data that was captured, correct?
They deal with event 1162.2, right, and the 10 seconds it's comprised of. Actually, they really just deal with the end of the event. That's what everything in the Aperture reports referenced.
Fair enough. But it doesn't deal with anything that could potentially happen after those 10 seconds, does it?
No.
Or anything before?
No, it does not.
The triggering event is spot in the middle, captures 5 seconds before, 5 seconds after.
Approximately 5 seconds. It's
Yeah,
not exact.
And you would have to look elsewhere for evidence to know what might have happened before. Yes?
Correct.
And you'd have to look elsewhere for evidence to see or determine what happened after.
Yes.
Oh, he's getting annoyed. That was a really slow
Do
blink.
you know at the end of this triggering event, that 10-second window of data, do you know what happened with the defendant's Lexus after that 10-second of data?
No.
You have no idea, right?
I don't.
Do you though, Brennan? Because that's the thing, no one does.
Okay. I want to just ask you some questions about your background and then leading into this case, if I could. You have a bachelor's degree and a master's degree.
Oh,
That's correct.
You've
I-
worked.
I don't know, Brennan. If you are going into this man's education and background, I don't know if that's a good idea due to the issues, the length of issues that Burgess had with his background. I don't know if that's a good idea. I don't know if that's a good idea. I don't know.
For
So I hope that you're not because I don't know. I don't know. Let's see.
you have a bachelor's degree and a master's degree.
That's correct.
You've worked for your company for some time.
Coming up on 13 years next month. Correct.
You've advanced through the company.
Yes.
You presently are the director of engineering.
Yes.
Are you ACTAR certified?
No.
What is ACTAR?
ACTAR is a body that basically offers a certification in accident reconstruction.
Do you offer services as an accident reconstructionist?
Sometimes.
And you have been hired and come into court and offer opinions as an accident reconstructionist?
In the singular time I've testified in court, it was not specifically for accident reconstruction. It was data analysis.
Okay. You continue your education and you go to a number of different trainings and seminars as well as teach, correct?
Regularly.
And when you regularly go to continuing education, you have quite a bit of continuing education that you've been through,
Maybe.
haven't you?
Sorry?
You've
You haven't
been
gotten
through
there yet.
quite a bit of continuing education.
Yes.
You focus as part of your specialty on EDRs, don't you?
That's correct.
Event data recorders.
Correct.
In fact, when you promote your services, that's one of your real specialty, isn't it?
Correct.
And it's something that not only are you schooled on and you go through continuing education, you're well published, aren't you?
That's correct.
And in your publications, you speak primarily about EDR type information.
Yes.
And that's something you are well skilled in, isn't it?
Yes.
Now, forensics or data forensics is a wide field, isn't it?
It is.
And you can do some things or many things in it. But oftentimes people specialize in parts of data forensics, don't they?
Generally, yes.
Well, speaking of you specialize in EDRs, true?
Yes.
There is a difference in different subspecialties, isn't there?
In general,
Yes.
yes.
Okay. Now, are cell phones, is that a subspecialty in digital forensics?
Yes.
Is that something you're a specialist in?
No.
iPhones, are you a specialist in iPhones?
No.
Have you ever taken any specific training on mobile forensics?
No.
Have you ever written any papers on mobile forensics?
No.
Hey, have you ever promoted yourself of having any type of subspecialty as an expert in mobile forensics?
Never.
In any of your continuing education, and you have a vast amount, have you ever taken any classes or seminars in mobile forensics?
No.
Have you ever taken any class or study about variances between infotainment systems and mobile forensics?
Classes? No.
Have you ever attended any seminars on variances relative to mobile forensics?
No.
Have you ever testified about variances in mobile forensics before you testified in this court today?
No.
Have you ever published anything to do with variances in mobile forensics?
No.
In this case,
But Brennan, he used your guys' information. So he used your guys' stuff. So if he's over here asking him all of this, his guys need to be clear in all of the things that they did. So they all need to be these things that Brennan is highlighting that he's not as well. This guy did not do any like data research. He just used anything and all the things that Burgess's report, the first and second one, Welcher's a report and PowerPoint. And then he said, well, okay, you did a good job, but you didn't quite finish it. You started it, but you didn't finish it. Right. And so if Burgess is this mobile phone expert, this mobile phone forensic expert, all these things that Brennan is highlighting that this guy's not going to be all the things, you know, which is fair, which is also fair to highlight. But he didn't do any digging of it, all the things. He used the information and the data from the trusted source of Aperture that Brennan leaned on quite heavily for when it comes down to what this car was doing and how and when and all of the things. So the jury knows that as well because he said it.
case, you had an opportunity to review a number of reports from Dr. Judd Welcher. Yes?
Yes.
And Mr. Shannon Burgess.
Correct.
In reviewing those reports, you've offered your opinions and analysis. Did you ever engage in actually any efforts or study in this case to obtain data?
Could you maybe clarify what specifically you're asking?
Yes. Did you ever yourself, not watch someone else do it, did you ever download or obtain data in this case?
No.
Did you ever test Miss Reed's car?
No.
Did you ever get an exemplar vehicle to run any tests?
I did not.
Nope. He's
Did you
he
ever
used
do
data
any
from your
actual
guys and said
testing in this case?
wasn't quite
No.
right.
And so your role is to look at other people's work and offer opinions and criticisms, basically.
And provide some clarity to the work, but generally, yes.
He is the peer that does the reviewing. So will some jurors say, but he didn't do anything. He didn't do anything. He just marked up the paper. Of course. With the remembrance that the paper was written by the Commonwealth. And the supplemental came in during the trial.
Clarity for who? Who asked you to provide clarity?
My clients in this case?
You what?
Okay, yeah, so you didn't do any testing. No. But the Commonwealth's testing that Brennan is relying on should be good enough where he didn't have to. That's what some jurors are going to say. Okay, he didn't do any testing. Okay, he peer reviewed the testing and the reports. The supplemental report even that he wrote during the trial off of Brennan's testing, off of the Commonwealth's testing, off of Burgess's testing, off of Welcher wearing the same clothes that John O'Keefe passed away in. So that, I think, is a major point and factor. He didn't need to do testing. He just needed to look at the math and see that it was wrong, according to him. I can't say that it was wrong or not. I don't know. I don't do any of that. So
What?
Mr. Jackson,
Okay.
my client.
Did you ever speak to me?
No.
As an expert, when you analyze data, whether you actively got it yourself or not, do you ever give an opinion in paper called a report? You ever write a report?
Yes.
And you've seen
Called a
reports in this
report.
case that you've looked at, correct?
Correct.
A number of reports by Mr. Burgess,
Correct.
report by Dr. Welcher,
Also correct.
reports that you're critiqued.
Dr. Walter, who is the VP of Aperture, by the way, right? VP of Aperture, and the jury's remembering all these things. The level of Welcher, who Burgess is, the $325,000 contract, all those things.
Critiquing, right?
Correct.
Did you see Ian Whiffin's reports?
It did not.
How about Jessica Hyde? Did you see her reports?
I did not.
You were asked to consider information from Mr. Whiffin's report.
No.
Well, you were asked to assume that the last user interaction on John O'Keefe's cell phone was 12/32/09.
That was stated in Dr. Welcher's report. So I started my analysis at that.
Which is based off of Burgess's report, which is used within stuff. So if there are issues within, all this guy was asked to do was say, look at all the Commonwealth information. So seem right? So if it seems off to the guy who doesn't even know all these other reports, didn't even look at all the other information, how much more is he seeing that's incorrect? And again, there's going to be someone for each side. There's going to be someone for each side. The jury could be sitting here and going, then what the fuck did you even do? And some of the jurors could be sitting there and being like, he didn't do anything. He just found all of the errors, according to him.
That level.
So none of the information did you actually personally go and vet or analyze or make any determinations about? You're just critiquing written reports.
Correct.
Well, as an expert coming into court and testifying and having opinions, you put together a PowerPoint, didn't you?
Yes.
Why didn't you ever put together a report to share the basis of your opinions and the process you went through to arrive at your opinions before you came into court?
Primarily, I wasn't asked to, so I didn't do it. I wouldn't commission work without being asked to do it. And number two, the extent of my work beyond building the PowerPoint was just basic addition, just adding numbers together that already existed in the Aperture reports. So there wasn't a tremendous amount of complexity to what I engaged in.
What about your work product and your calculations? Did you do all this in your head, or did you type it out and go through a computer program? How did you do it?
I used a calculator for most of it, and the tables in my PowerPoint were generated in Excel, which has some calculation capabilities.
Were you ever asked not to write a report?
No.
Will the jury not like that he doesn't have a
provided an
report?
initial PowerPoint.
Yeah, they're not going to like it.
Yes.
And then you received information from Mr. Burgess,
Yes.
and then you added new slides to your PowerPoint.
That's correct.
Mr. Burgess's report was May 8th.
Yes.
Yeah.
You provided your PowerPoint on May 25th.
Correct.
Did it take you that long for the calculations between when you got the report and May 25th to put together the new presentation?
No, it didn't.
Why did you wait until May 25th to provide the new information?
That's when I was asked to do it.
What do you mean by that? I just want to see what the date is today. Today's the 30th. When you finished your PowerPoint on May 25th, did you send it to the defense on May 25th?
Yes, I did.
But they had a copy of your PowerPoint on May 25th. Don't be shy.
No, I'm pretty sure it was the 25th.
Whoa.
Sustained.
Whoa. That is too much. And I say it with when the defense does it too. I'm pretty fair. Don't be shy goes crazy in the courtroom. That's wild. That is, he's allowed to take a moment to think about the answer to your question. You're talking slow, right? He's hearing, so when can you give him a damn second to fucking answer the question, and you chime in with don't be shy? That's pretty radical. I don't think that the jury is going to I think the jury is going to get their attention caught because they're probably bored to tears right now. And they're going to say, don't be sure. The fuck? If I heard that, I'd be like, ew. 1, ew. 2, gross. 3, the fuck?
Copy of your PowerPoint on May 25th. Don't be shy.
No, I'm pretty sure it was the 25th.
So it's sustained.
No, give him no, Judge Beverly Cannoni, give him the, hey, jury, please ignore the comments, questions only. Hello? No, but Judge Beverly Cannoni, do the same you do to the defense when they make out-of-pocket comments. Don't be shy, Merch. That's crazy. No. 1, ew. 2, gross. 3, what the fuck? No. Judge Beverly Cannoni, do the same you would for the defense.
25th.
Make it known
Yes, I
that
did.
comment was unnecessary, inappropriate, and to not be regarded. Hello?
They had a copy of your PowerPoint on May 25th. Don't be shy.
No, I'm pretty sure it was the 25th.
So it's sustained.
Yeah, if it wasn't the 25th, it would have been maybe the day after, but it's dated the 25th. I'm almost positive I provided it on the 25th.
There's
Yeah.
no reason for you to hold on to it for a couple of days.
No, I think it was the 25th.
Do you know what was provided to the Commonwealth that report?
No, I don't.
In the
Good
25th
job.
report that you provided to the defense on the 25th, they had new information,
Brennan, speak into the microphone. Brennan, speak into the microphone. You talk too slow. You talk too low. Speak into the microphone. You're pissing the internet viewers off. We need to hear you. We cannot hear you. Hello, Brennan.
It had the information from Mr. Burgess's supplemental report. That was the additions.
Why did you wait until the 25th to put it together?
That's when I was asked to do it.
Who asked
My clients, Mr. Jackson,
you? He said, please have this on the 25th.
we had a phone call on the 25th and discussed Mr. Burgess's supplemental report. During that phone call, he asked me to update the presentation, and I did so, and then provided it.
How did the date of the 25th come about? Why the 25th was the date provided?
That's when he requested it. I think it was a Sunday, actually.
Don't be shy is
When you first got involved in this case, it was last fall,
Correct.
and at that time, you
Come on, Brennan.
received some information that Mr. Burgess wanted to look at the text stream data or the different modules on what you later learned was the defendant's Lexus, correct?
Correct.
There was a proposal from Mr. Burgess. Mr. Burgess wanted to go back to the car and look at the modules to try to download more information from it.
microphone.
Correct.
And you then got involved to look at what his request was, the procedure that you wanted to follow.
Yes.
When you did that, were you given any materials about what had happened before you and Mr. Burgess both got involved?
I don't recall specifically, and I don't think so. I think I was just provided the notice of testing that was to be done.
Well, you ended up drafting an affidavit.
I did.
And in drafting an affidavit, you pointed out some oversights of Mr. Burgess, didn't you?
I did.
Determining the oversights required some study of actually the data and the information that was available, wouldn't it?
It would.
So can we presume that before you wrote the affidavit pointing out the oversights, you had looked at other materials?
If I recall correctly, the notice of additional testing from Mr. Burgess contained attached to it a whole report by him documenting why he thought there was an inadequate initial acquisition, why he thought the sizes were wrong. So I don't remember referencing anything beyond all the information that was contained in that. And whether that was combined by somebody else or not, I don't know. That's how it was provided.
Did you end up looking at the report of Ms. Gaffney and what had happened in the past with the download and search of Ms. Reed's Lexus materials?
If I'm remembering right again, I think Ms. Gaffney's report was also attached to that same singular file.
You learned that the defense expert, Ms. Gaffney, had downloaded data from chips, correct?
Correct.
And Mr. Burgess was asserting that there was information missing and believed that there was missing information from the chips.
Correct.
In that form, it's sustained.
It's
It's stricken.
My apologies. The conclusion Mr. Burgess had is that he believed there was missing information from the chips.
He did. He miscalculated the size of the chips.
Did you do any study to see if there was actually information missing from the original download?
No, I looked at the data sheets for the chips and then immediately realized what the error was. The data sheets specify a size in megabits or gigabits. And Mr. Burgess had written his report in the context of megabytes and gigabytes.
And then you asserted, or you took the position in your affidavit, that there should be no further chip off, no further study of those chips, other than to ensure the amount of memory was sufficient.
It's not how I recall specifically what I said.
Well, let me read it because I don't want to try to malign your words.
Please.
Mr. Burgess proposed protocol labeled reattempt chip-off acquisition is unnecessary because the file size of the acquisition performed by Ms. Gaffney already matches the expected memory storage capacity of the components.
That sounds accurate.
If you want to see this, I don't want to read from the document. If you need to see it for action, just let me know.
That's fine. I trust your reading.
However, an acquisition may be conducted for the sole purpose.
I would never trust a lawyer's reading. I'm on this is probably the only time I'd say I'm on Buchanan's side. I would never trust a lawyer's reading. Even if I was a defense witness, I want the defense to bring me the document and say, here's these words, these your words. I don't want them to read it. And of course my internet's being wonky. So a good time to pause. I don't want them to read it. I want to read it. I want to read it and make sure when you read it, if I read it, whoever reads it, it's correct. And that's just because lawyers make mistakes too.
Purposes of ensuring the contents of the memory chips have not been altered since the last testing by recording the checksum.
Yes.
Did it cross your mind at that point that there was important data in those modules that was not seen or recovered or obtained by Ms. Gaffney?
No.
If it was so important, why was it not in discovery before the first trial? Also a question that I constantly have throughout this case. Adding weight to the importance of things that were not even discovered until after the first trial makes me want to climb up a wall and then jump.
Did you want to know when Mr. Burgess was looking for more data, more information, what he thought was missing?
He stated, I think in his report or affidavit, I'm not sure what it was, but he stated what he thought was missing was there was a physical size difference. So he thought there was not corrupt data, but just missing chunks of data.
Log line information, you've heard of that. Ignition on, ignition off information
Yes.
in an infotainment system. That's important information when you're reconstructing an accident, isn't it?
It could be.
Well, you read information in this case. Pretty important in this case, what you said.
Yes.
And so you would not want to engage in that process without this pretty important information, would you?
Which process?
Of an accident reconstruction?
Sorry. So can you restate it, the whole question?
I'll
Yeah.
ask it again.
Yeah.
You said you have some experience in accident reconstructions.
Yes.
Don't you want all the data available? More data, the better?
Generally, yes.
You wouldn't want to ignore data on purpose, would you?
No.
I mean, the data analyst, the more data, the more you get to look at.
Yes.
And so the power log on information that actually has date and time, that's critical in an accident reconstruction, isn't it?
In some accident reconstructions, in some, there's no debate about when a vehicle was on or off, but if there is, then yes.
Not just on and off. The power log on and off gives you the date and time that you can match with the text stream data, correct?
Yes, it
Because
does.
you know text stream data itself doesn't have date and time.
It can, this vehicle didn't. It can, but this vehicle did not.
And this had a running time instead, like a
That's
stopwatch.
Correct.
So this data that was not found during the initial process, that was critical data at the time.
I don't think prior to the process, anyone knew that this particular Lexus infotainment system stored those key on and key off times.
Right, the only person that found this out was Shannon Burgess.
He found it in the process, but I don't think anybody knew in advance of this case. There was nothing out there about it. So to my knowledge, this is the first time that this specific data has ever been released into the wild.
But it was on the board there, if someone knew what to look for or got creative, they could maybe find it.
Yes, more so to your if got creative, because I don't think anyone would have been able to have the foreknowledge that there would have definitely been that.
Shannon Burgess did.
I knew I wanted to pause before he got to it. He's getting to the point where, well, you didn't do any testing, and guess who did? Shannon Burgess. And he found this awesome, cool. Like, he also had major mistakes on his professional profiles and CV that is up to the jury to decide if he is reliable. I'm cool. Great. We have this data, and it makes things more difficult now, essentially, when it comes to trial. Awesome. Cool. No one's taking that away from him, but two things can be true at once. He was an absolute mess on the stand. The man was in full panic mode. He was in fight or flight, and he chose freeze, which is the third one that no one ever talks about. The man was frozen on the stand, right? But at the same time, you still have these things that he discovered, which is more data, which people who look at data have more data to now look at and make conclusions from. Cool. Two things can be true at the same time. And the jurors are real people, and they're going to see that, and they heard him. Yeah, no one's taking that away from him, but you cannot negate what the jurors saw on that stand as well and had the conversation of. You can, like I just said, two things can be true at the same time, and these are all humans taking it in. They can say, we don't give a damn about the education, and he found this cool thing. Awesome. He found this thing. There's more data. But this guy, and I think it's important to remember, he wasn't hired to test anything. So it's like slapping the wrist of a puppy who peed outside because you saw a puddle in the house, but it's actually water. But he peed outside. He didn't pee inside. The dog didn't pee inside. He peed outside. He did what he was supposed to do. This guy was not hired to test anything. And I think it's important to remember what they are there to do. You know, it's like, we can say, hey, the medical examiner could maybe get, if you're slapping the wrist of a puppy, you could slap the wrist of the medical examiner saying, maybe we should have x-rayed parts of the body that had injuries on it to see if there were any little hairline fractures in there. That's a great moment for contention. Absolutely. And does Brennan have the full capacity and the full right to be like, oh, Mr. Burgess did it? Sure. Is it coming off a little arrogant? Sure. Is the jury going to like that? I don't know. Maybe they will. Maybe they'll be like, oh my gosh, Brennan was right the whole time. Everything he said has been so good. Which is really, it's really hard for me to say, because it really hasn't. The defense has come up and asked a lot of questions, and in my opinion, there is a lot of doubt already. There's a lot of little holes that with furthering, because this is witness number one. We just sat through how many witnesses? 23 days of witnesses from the Commonwealth. So adjusting the brains, is Brennan trying to adjust the jury's brains, like snap your fingers? And now we're in the lies. Yes, that's exactly what he's trying to do, because that's what he wants. But cool, you found a thing, but you also didn't, according to this witness, you didn't apply some of your calculations for the first one. And then in the middle of trial, you have this thing. So we have a response to this supplemental report in the middle of trial as well. So I think the taking it all in is good. I think taking it all
I don't think anyone would have been able to have the foreknowledge that there would have definitely been that.
Shannon Burgess did.
Objection.
Sustained.
Sure. And this is a moment. I think this is a moment where the jury's going to go, why is she not telling us that these comments are not to be regarded, right? Like these comments are not necessary, because almost every single comment, the Judge Beverly Cannoni said, the comments, da, 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 don't, ignore the comments, then ask questions only. She hasn't done it twice for big moments, big times. Brennan has done it. She hasn't done that twice. Is the jury going to notice that? Is the jury going to notice that? The very first witness, Brennan has already made 2 unnecessary, inappropriate comments. And Judge Beverly Cannoni has not done the little speech that she does when the lawyers make comments instead of ask questions. Is the jury going to notice that? We do, because we nitpick literally everything. And we can...
Burgess did.
Because I don't think anyone would have been able to have the foreknowledge that there would have definitely been that.
Shannon Burgess did.
Sustained. I'll strike it.
And when Shannon Burgess went to obtain that data that everybody else overlooked or didn't know about, you went with him.
Yes.
So you had a process where he was going to now control the data.
The timing of it was
and take the information that
Did
was
it
left
land
behind
for the
and
jury?
remove it from the infotainment board, correct?
Maybe a couple. I'm sure a couple.
He
people were like,
actually never specified anything about the SD card in that initial notice. So it was a departure from his protocol, and it was a little surprising to me when I got there that the protocol was written with a specific focus on a number of other chips. And it became very apparent to me very quickly that the focus was not on those chips, and the focus was on this SD card that had previously been unmentioned. There was nothing in there about that prior to that.
Did it offend you, or were you impressed that he had found that?
I was a little confused because I went into it with an expectation. Generally, if we write a protocol, we adhere to the protocol. If we're going to deviate, we have a discussion about deviations. So I was just surprised. It's not customary to sort of shift out of nowhere. But other than that, I did not know what to think of it because I'd never heard of that.
Did you give any input? Did you have any knowledge about the SD card and how it worked?
No.
So when you watched Mr. Burgess remove the SD card, did you appreciate he'd have to engage in what you call reverse engineering?
He did not elaborate to me exactly what his whole process was at first. It sort of came out as time progressed through the first day in his office in Texas. And then I learned more as we moved to the second testing in Massachusetts. But he didn't explain it to me in one go.
Did you, at that point, understand or appreciate the relevance of the SD card relative to the infotainment system and what it could do as far as the amount of information that could then be available?
He never spoke throughout the 3 days at all about what kind of data he expected from the card or would be on the card or could be. He made no mention of the data.
Not what he said to you, but given your expertise, did it ever dawn on you the significance or importance of this SD card that was sitting in plain sight? Objection.
Sustained. You can ask it to.
Did it ever dawn on you that as Mr. Burgess was recovering this information left behind, that there was something important or significant about it?
At the time, I thought it was a possibility. If you reference the initial work, a number of different memory components were identified in this infotainment. There isn't a singular memory chip. So if we're looking for data, it could be in any of them. So we found a new source of data storage, and there could be something there. There could be nothing there. It was unknown to me.
But it turned out there was.
There was.
Now,
that wasn't a question, though.
when you were watching Mr. Burgess work as an expert, if you felt like there was something inappropriate or he had some great oversight, you could
Brennan
write
is
a
a
report
defense
about
attorney.
that, couldn't you?
I could.
Did you ever write any
I told you at the
report in
beginning,
this
this
case?
is where he will
No.
thrive.
So you never wrote a report
He's been waiting
for
for
your
this.
preparation of coming in and your data and the PowerPoint presentation?
He has been waiting for this moment for 23 days since this trial started. He has been waiting for this moment to actually be a defense attorney again. He is a defense attorney. He is being paid a good chunk of money to pretend to not be for a little bit, but he is a defense attorney. So,
Right?
Correct.
this is where Jackson, Alessi, Miss Little, Yannetti, and the secret attorney that is also on the team, who is from somewhere I can't remember, who was a juror. last trial, who has joined the team, which I'm sure might. I'm guessing that the newest member of the team might even do the closing, and come and be like, I sat through this whole trial type of moment. I have a feeling that might happen. But Brennan, they're up against Brennan, who is also a defense attorney. Now, Matt, bigger team, and Lally's cross-examinations last trial they were bad. They were bad. You gotta be fair. You gotta, call a spade a spade. They were not great. But Brennan, he's going to have much, much, much better crosses than Lally because he is a defense attorney.
Correct.
You never wrote a report regarding any of your
This is bread and
observations,
butter.
Mr. Burgess.
Correct.
You said that he didn't say anything. He spoke to you quite a bit during the process, didn't he?
He did.
He showed you what he was doing.
He did.
He explained to you what he was doing.
He explained the process. I think you had asked me earlier about whether he explained the data, and he didn't.
He demonstrated great proficiency, wouldn't you say?
He ended up with a successful acquisition of the card at the end of the process.
When you are considering all your
I don't think this witness is attempting to be difficult. I don't think he's attempting to be difficult like Wolf was attempting to be difficult during cross-examination, like yesterday and the day before. I don't think he's attempting to be difficult. He's just choosing his words carefully. He's using the brain. Did I say Wolf? Welcher. I meant Welcher if I said Wolf. Welcher, I think, was attempting to be difficult for Alessi and was quite successful. I said it earlier in the stream, the cross-examination of Welcher, the first day, I think the second day, the half day went way better. Not great, not ideal. But I think the cross-examination, the long day of cross-examination with Welcher was something that Alessi probably is not too proud of.
your equations,
It was
did you
tough.
consider
It was a hard sell. It was a hard
the
sell.
timing information taken from the SD card that Mr. Burgess found regarding power on and power off of that car?
Yes, to the extent that he considered it in his own report. Again, I'm referencing his report.
But how about you? You're coming in here giving an opinion saying what's better or best practice or right. How about you? Did you consider, you personally, the one who's giving the opinions, did you consider the significance of the power on, power off data as it relates to all these times?
Yes.
Yes? Are you sure?
Yeah.
Okay.
I mean, I considered it. If that's the question is, did I consider it? I considered it.
Did you do any study yourself?
No.
Now, we agree, or you agree, that there
I really thought his next question was, did you bill Karen Reed to buy an exemplar SUV yourself? Because I really thought that was the next question. Really thought that was going to be the next question.
are variances between different devices.
Yes.
So a Lexus clock that comes from the infotainment system is very common that it would be different than a different device like an iPhone.
Specifically this Lexus, I don't know if we can make the statement that it's common or not, because again, this is the only time that I know of that this specific data has been analyzed. So I don't know the answer to that question.
Did you say on direct examination that variances between devices are common?
Variance between devices are common.
In a variance of 45 seconds, that wouldn't be remarkable on
No.
different devices. It's common in the industry.
Correct.
And in your business, that's an accepted amount.
I'm not sure what you mean by accepted. The amounts are what they are, and we have to correct for them. I've done analyses of clocks that are anywhere from completely correct, 1 second off. I've done analyses of clocks that are 25 years apart. So it's a wide range of
I
possibilities.
understand your point.
Yeah.
If you see as an analyst a 45-second variance or 30-second variance, that wouldn't shock you, would it?
No amount of variance would shock me, is the answer.
I want to ask you questions and go through your PowerPoint. And I want to ask you your specific opinions and how you arrived at certain claims that you've made.
Sure.
Okay?
I'm going
We
to
can
put
put
it
up,
to 1.25.
Mr. DeSorga's new PowerPoint 52525.
Back in the microphone. New PowerPoint. Okay. Well, your new report.
You've made a
And so
modification to your PowerPoint.
Yes.
You've made an amendment to your PowerPoint.
Yes.
So there was something that happened. You received new information or new data, and you updated or changed your PowerPoint.
I did.
And that's an appropriate thing to do when you receive new information, isn't it?
Yes.
If you have new data, you don't want to leave it behind. You want to make the best presentation with the best data you can.
I'd want my presentation of the data to be as accurate as possible. So I included all the data.
And you would expect that from any expert, wouldn't you, if they receive new information or analyze new?
these questions are not for him. These questions are for the jury to be like, see, there's no issue with the May 8th supplemental report. There's no issue. Yes, it's the first time. Doesn't mean he'll never do it again. That's for the jury. So the jury gets back on his side because he might have read the room a little bit and been like, the juries might be feeling a little tense. Okay, so when we talk about the jury, we are like, let's take last jury for the first trial. We heard that the jurors took Commonwealth as truth and that the defense was just trying to basically like bully them into believing lies, right? So they're like the defense is coming with all these lies and they're trying to bully them and make us not believe the truth of the Commonwealth. And I think that's a very common, it's like a very standard view. Like you're not, the majority of people are not going to sit there and be like, oh my gosh, the police are lying to me. The district attorney's office is lying to me. The judge is lying to me. The bailiff is lying to me. You know, all these cop witnesses, they can't be lying to me. They must be telling the truth because cops don't lie, right? Which is in fact not always correct. So the jury had that sort of mindset going into deliberations. Now, if this jury is similar to last jury, I don't know if Brennan coming in hot and being now defense attorney Brennan is going to make them sit in that feeling of the Commonwealth is giving me truth and the defense team is giving me lies, when you could draw very similar characteristics for the lines between the defense attorneys and Brennan now being a defense attorney in essence, you know, in tone and in sassiness and rudeness and sharpness, now being a defense attorney. I don't know if the jury's going to be like, wait, why is he acting like that? But he's the good guy. He's supposed to be like not mean and he's not supposed to be the defense attorney who's the defense is bringing in the lies. These are all air quotes if you're not seeing my face. So I don't know if the jury is going to be able to appreciate that Brennan is a defense attorney. They don't know that. You know, they weren't like sat down and be like, he's actually a defense attorney. We're paying him $250,000 to pretend air quotes to play as district attorneys. He's working with the district attorney's office to try this case as a special prosecutor. They don't know that. So we have to keep in mind, Brennan is locking in the time variance and supplement reports. It's new data. Brilliant. Yeah, no, I don't think there was any question on the new data. And like I said, these questions are for the jury to be like, they threw a fit about my May 8th supplemental report from Burgess. So I'm going to throw a fit about the May 25th PowerPoint from this guy. If that's wrong, then this is wrong, but that was right. So this has to be right. That's unfortunately the correlation as well. Well, that was right. That was new data. And then you got new data. So there's nothing wrong. There's nothing wrong with this. Right? So it can't be the supplemental report to Brennan is right, but this is wrong. It has to be both. Like it can't be, we had the report, supplemental report during trial, that was right, he got new data, but then you somehow took the right. So you're allowed to do this. So we're allowed to do this. So we're allowed to have the supplemental reports no matter what time they came in. It could have come in 2 days before Burgess took the stand. Which when did he take the stand? Not 2 days after May 8th, you know, so you have to draw that circle. So that's where we're at. So let's see where he's going.
It's new data and it was important. It would be an appropriate best practice to update the PowerPoint or information they're providing, wouldn't it?
Yes.
I'm going to allow that.
I don't know if I would tell other experts what their best practices are. I would say generally as experts, we do work that our clients ask us to do. So if we're asked to do it, we do it. If our clients say, hey, don't do that, we don't do it.
Well, you like the phrase best practice on direct, so I'm just wondering if I can borrow that phrase.
Sustain.
Give him okay. This is a moment of fairness that we are not seeing equality in. We are not seeing equality in it. Judge Beverly Cannoni is not vocalizing the disinterest of these comments. She did it very often with the defense. So she's not doing it with Brennan. And that is what, the third, maybe the fourth time. There's one time he took a comment as a question. Judge Beverly Cannoni, if you are going to put your foot down and vocalize that lawyers are not to make comments, they're just to ask questions, please ignore the comments. Please do that with Brennan as well. Especially since this is his first witness that he's crossing. I think you should, Judge Beverly Cannoni. And I think I would like to see Jackson say, may we approach and have a conversation about it. This is the fourth comment. I think it's only fair. I mean, if she's going to put her foot down and have those conversations with the jury about the comments from the defense, she should do it with Brennan as well. Plus, it's just mean. You don't just get to be I don't like it when the defense does it either. Just outwardly being mean to someone is it's not a good. And it comes down to the optics of what the jury is feeling, they're vibing with, they're seeing, they're hearing, they're taking notes of, they're remembering, all of those things. It comes down to the jury. Doesn't matter our thoughts do not matter in any way, shape, or form. Our thoughts, there's not an ounce of the universe where our thoughts and opinions matter at all when it comes down to this case. It is down to the specific 12 people that will be deliberating this case. That's it. But I think it's absolutely fair for Judge Beverly Cannoni to have that conversation of, hey, please disregard comments, please, ask questions, continue, those types of things, because she's not doing it with Brennan. But she did it a lot. To be fair, the defense made a lot of comments. She did a lot. But I mean, I think 4 comments between the morning break and lunch is also quite a bit. I mean, we haven't even gotten to the lunch break.
Turn to page 2. Now, this is taken from Dr. Welcher's report.
Yes.
And again, you did no testing whatsoever. You just read
I did
the report. Did you read all of Dr. Welcher's data, the gigabytes and gigabytes of data? Did you go through it all?
Not every slide, no.
Not just the PowerPoint. I mean the actual massive amount of data in his study. Did you go through the data?
Oh, no, I didn't look at any of the data.
Did you ever speak to Dr. Welcher?
No.
And so when you are making assumptions on what he thought or how he analyzed, you're just guessing.
I am looking at what Dr. Welcher put in his trial presentation, and my assumption that's baked in there is that he's going to stand behind the things he says in a presentation. So I'm taking them at face value, but as being correct.
It's not a matter
I'm
of
not guessing.
It's not a matter if he's going to stand behind it. You don't know why he put something in here. You just see it on the paper. You don't know what his thought process was, did you?
To an extent, yes, because I understand how the exemplar testing by Aperture laid the foundation to align the key-on events in the infotainment to the Lexus VCH events.
When Dr. Welcher made his PowerPoint, do you know whether or not he was relying on 154 on Mr. O'Keefe's phone, stamp 154, as the end of the event as opposed to the beginning of the 3-point turn, 1162-1?
Based on the math he uses, that's the implication. He puts a number on the screen that the only way you could reach that number is by making that assumption. So when I looked at the math, yes, that assumption seems baked into the math he did.
So this seems like it's baked in that he was assuming 154 on John O'Keefe's phone was the end of the 3-point turn.
Not on this slide, on a later slide, but yes.
Okay. And you said that variances, 30 seconds, 45 seconds, they're very common when you're comparing 2 different devices, right?
Yes.
Okay. Turn to the next page, please. You point out 2 times for the jury, the Lexus event 1162-2 ends 12:31:43, right?
Yes.
And that's based on the clock in the infotainment system.
That time is based on 2 things, the clock in the infotainment unit and the cumulative key-on timer in the text stream data. So it's a combination of 2 values.
Which is the running clock.
Correct.
Right. And that is compared or contrasted or coordinated with the log on off time that was found on the SD card. Yes?
Yes.
And without that SD card, we wouldn't have that time now, would we?
Correct.
Okay. 12:32:09 isn't something you analyzed, but you just read in the report that is information from Ian Whiffen suggesting or taking the position that was the last user interaction John O'Keefe had with his cell phone, 12:32:09.
That's how I understand it. There was a phone lock at 12:32:09. I did not look into the underlying reports from where that came.
And you know those are two different devices, two different clocks that will have a variance.
Yes.
You mentioned trigger event, and you said that your preference is to, when you're doing times, to point it from the actual trigger event, and there was a little slap for emphasis to target you on that, right? The trigger event. That's not a standard practice or a protocol that is supported by any type of literature, is it?
It's the methodology I teach, especially in the class I teach on the analysis of heavy vehicle data. We have the exact same problem with heavy vehicles. They all have clocks on them. And so, in fact, I do a lot of clock adjustment on heavy vehicles relative to other sources. And the way I teach it, I'm not the only instructor. Collectively, the way we all teach it is we generally start the analysis at the trigger, which is not to suggest you have to do that. It's not wrong to do it a different way, but that would be let's call it the default methodology.
The default methodology, do you have any professional literature that says that is the best time to start the analysis?
Not literature. I mean, that's sort of my opinion, because that introduces the least amount of variables. Once you start trying to align events off of subsequent times, you just introduce more addition, subtraction, or math you have to do. So it's easiest to do T0 and align everything from there.
If you're lining up the end of one event with the end of another event, it's more coordinated than if you take it from different spots, isn't it?
That could be a scenario where then you wouldn't use it. Right. Like I said, it's not the only way, but it's the default way.
I don't disrespect your method, but there are other ways to do it that are just as legitimate as the trigger time.
Absolutely. And that's why I didn't change the convention here. I used their convention,
So you're not
apertures.
suggesting that Mr. Burgess was being misleading by choosing the endpoint when he pronounced that's exactly the point he was considering, are you?
No.
And so the word cherry picking, you're not saying he was cherry picking, are you?
I don't remember the context in which I used the word cherry picking, but I don't think it was with respect to a trigger alignment.
So there's no legitimate professional basis of suggesting your way is better or worse than going from the front or the end of the event?
No.
You're not offering criticism on that, so just so I understand.
Not criticism. I pointed out that it's not typical, and I pointed out not even to say specifically that it's not typical, because even that, to your point, might sound critical. I just want to be clear that I adopted their convention. It's not the way I would have done it, but I kept that convention consistent in my analysis. So I wasn't changing in the middle, trying to obfuscate what I'm saying.
I appreciate that. So if someone's looking end to end, you're not going to add 5 seconds. It's if someone went from middle to end.
Could you give me that?
Yeah, you were
a little
suggesting
different?
those questions about, well, since you're looking at the end instead of the middle, then you got to add another 5 seconds on. That's not really an accurate analysis if you're looking at a comparison from end to end. You wouldn't then add the 5 seconds to the time to trigger because you're starting at the end from both devices.
I swear to God, if you don't speak into the microphone.
I'm going to allow it if you can answer it in that form.
It's going to depend on if you're doing an alignment with something that is a range of values, then you have to be consistent on where you're doing it. If you're doing discrete points, then that's just a single point in time. There's no beginning or end. It's just a single second. So the best answer I can kind of give is it depends on what you're doing.
Well, in this case, you're basing it off the end of the event, the end, not trigger, the end, comparing it comparatively to the end of different devices. So you wouldn't just add 5 seconds just for the heck of it.
You would not add 5 seconds for the heck of it.
You see 12:32:09 minus 12:31:43, the middle line, equals 26 seconds. Isn't that in Dr. Welcher's slides before, let me phrase it more cleanly. Before Shannon Burgess analyzed the data more closely on May 8th, in his May 8th report, isn't this the exact difference in time that Dr. Welcher cites in his PowerPoint, 26 seconds?
I'll sustain it in that form.
Did you see when you reviewed reports that Dr. Welcher uses this exact number plus 26 seconds in his report?
I got the number from the PowerPoint,
I'm sorry,
not the
PowerPoint.
report, but that is all of the numbers here on this slide are from Dr. Welcher's PowerPoint. And on the previous slide, I show that. So these are all just copied straight from that.
And you've labeled this John's interaction window.
I did.
Interaction window. Do you think it might be confusing when you use interaction window to make it seem like the event is limited to 10 seconds?
No, and that's not the implication there at all.
That's not what you're trying to say.
That's not what I'm trying to say.
Fair enough.
If I can clarify what I mean by interaction window is that there's
Please do.
a range of times that we end up with when we start running these adjustments. So we never land on a singular point of alignment. We end up, like I showed at the end, with 30 points. That's the window that I'm talking about. That's the window that I mean.
So if we could put up page 33 from Dr. Welcher's PowerPoint, just to illustrate the point you're trying to help us with. Do I have a little for it? So this represents, right, you've seen this, right?
The fact that he's standing so far away from the microphone is making me upset. Like it makes me mad. I don't care. I don't care about the trial right now. I care about where you are actually physically standing right now. I care about the microphone and I care about where your mouth is. No, never mind.
It looks familiar, like it's from one of his slides. And if I've seen it, I did not spend a lot of time digging into it.
Does this look like the 10 seconds of data that we capture from a triggering event in a texting data?
Objection.
I want to see you at sidebar.
All right, let's skedaddle through the sidebar. Oh. What was that? A bailiff said something to him. What did he say? Can anyone read lips? Is he speaking to the person running the camera or the jury? Can anyone read lips? This is normal speed. I think he said like lunch will be here in 5 minutes or something like that. I think he said something about lunch. Oh, really long sidebar. I don't know if you can hear the opera they are rehearsing again. Their shows are starting soon. I'm going to have to go see it because that's a massive iPad, sir. Is that an iPad? That's got to be an iPad. Where do you get iPads that big? I didn't know they made iPads that big. That's a big ass iPad. No, yesterday was a half day with no lunch break because they ended. I think today's a full day. I think today should be a full day.
For the
Advice of the jury.
so that we could give you a nice full hour lunch break. So we'll see you back here in an hour.
Advice of the jury.
Court will resume at 1:55. Oh, so they're still on break. Yeah, no problem. The half day nonsense is a lot. Yesterday they had a juror who needed the afternoon probably for like an appointment or something. So it was a juror conflict. And I am up to live. We are up to live and there is no court. There is no court. I've kind of in and out talked about like the last few days of court with the Commonwealth. So my opinions are pretty much, I think the jury is exhausted at this point from everything, and that maybe a little change up, a little switcheroo would be good. Nope. Good for them and their energy. Court does not resume, I guess, for another 5-6 minutes. So I guess it's weird. I guess we'll go over like my schedule of when I can do court. So coming up, I will probably do a Monday afternoon, like at a 3 p.m. thing, to do Monday court. And then I have some things happening. So let's see. I know we did skip a couple of days. So we did miss a couple of witnesses. But I definitely suggest if you guys have the time to go back and watch them, even if it's just sort of catching the most viewed moments type of thing. I was going to do that, but I wanted to actually do court. Like, let's just do a day of court. And today was like the perfect day. Defense starts. So I will be here today, obviously. I will not be here Sunday because I have to work. Monday, I will do an afternoon situation. So we'll catch up on Monday court. And then I have some commitments. It probably won't be until the Monday after that I will be back. And I don't Monday afternoon and then Friday. So there's a lot of things sort of happening. And so I think that might be it. I'm going to try to weasel my way into doing stuff. But I have some things happening next weekend that I cannot change. Changing doesn't work. Can't change it. It's impossible to. So yeah, so that's that. I might maybe do like film and upload some shorts. So I would say turn on notifications and subscribe. For sort of like maybe my like unedited like and maybe like shorts or list like a 15-minute video or something of maybe like my unedited, hey, I can't believe this happened in court type of vibe. But then once I have time, I will be doing as much as I can to either catch up or if verdict watch takes a couple of days type of thing, depending on the days. It's so hard. It's so hard to stay up to date because I have a job. But yeah, so that's what we're gonna do. So yes, if you are new here, hi, my name is Lily. I never played my intro. God damn it. And we're talking all things Karen Reed. And they are still not in. This is completely up to date. Court will be starting in a couple of minutes. Allegedly, they never start on time. So that's where we're at right now. So maybe I'll do like some short videos. It won't be live. Maybe just to be like, hey, this is my opinion on what just happened, because I have the ability to listen, which is still good. I have the ability to listen, especially next weekend. I'll be able to listen. I'll be able to listen, but I can't stream. I regret it. I regret signing up for the thing that I signed up for next weekend. I regret it. I regret it so much. Like big time, like thinking about it, I don't want to do it. So anywho, let's take a little break. Go pee, go get some snacks, go get a lunch. Let's take a little break. They're still out of court. And then when they do come back in court, we can at least put it on 1.25 speed, but we will be completely caught up. Also, please subscribe. Thank you. Please subscribe, follow. I feel like those are the rules. Those are the rules. Court. Still no court. Completely caught up. Let's take a little break. Be right back in just a few minutes. I'll do this one. We're back. We're back. We're back. All right. Court is still on lunch. Still on break. Let's listen to what are they even playing? No music. No music. Oh well. All right. Man. Oh man. We are still in cross-examination of this witness. I'm sure this will probably be the only witness of the day. What was his name? Matthew DeSogra with a G. I thought it was a B the entire time they were talking about DeSobra. I thought they were saying DeSobra. What's DeSogra? DeSogra. Shoo-doo-doo-doo-doo-doo. Look at this. Look at this. We're still on lunch. Come on, court. Come on, court. I want to court. I want to court. We are still on lunch break. But yeah, so I was doing some thinking just now. I think that I'm going to do some videos when I am busy. I think I could probably do maybe one or two to kind of get through, because a lot's going to happen. And I really don't want to miss if they do call like Proctor. Because one of the things that I'm concerned about is that the jury who does not know, which is all of them hopefully, is that Proctor might be dead. Is Proctor dead to some of these jurors? Like, if you didn't know and you were listening and he wasn't called by the Commonwealth, is it because he's dead? I know he's not. We know he's not. But do some jurors think that? Could they? Quite possibly. Because it seems strange. And I know why that the Commonwealth did not call Michael Proctor. I know why. But do we think the jury might not quite understand it? We are back. So I don't want to miss when the defense calls Michael Proctor. Karen Reed said it was still TBD.
If we could turn to page
But I think it's a little more.
Mr. DeSorga's amended PowerPoint presentation.
I think it's a little more definitive that they will than they won't. I think there's a better chance that they will than they won't. And I really do think that if the defense calls Michael Proctor, it's going to be a shock and awe moment for the jury. Like, we might even hear sharp inhales. Your internet keeps kicking you off. Tell the internet to suck it.
Sir, I want to ask you about your opinions, and inevitably some of the slides that you've presented to this jury regarding adjusting the clock in a time period of 3 seconds. You have given an opinion that there's a difference that you see in the reports between when the defendant's Lexus is powered on and the infotainment system begins, correct?
Yes.
There's a 3-second difference on the exemplar vehicle between when the power is turned on and then the screen lights up, the ignition, the infotainment system.
The 3 seconds I'm referring to is the timestamp in the data from the SD card. So I'm referring to the timestamp in the SD card. It seems that that's coupled to the screen, but I just want to make it clear I'm referencing the data from the SD card.
The data from the SD card correlates directly to the infotainment system itself.
The date does, yes.
Because the SD card is with the other chips part of the board that makes up the infotainment system.
Yes,
That infotainment system powers the screen that goes on after a user presses the button to start the vehicle.
yes,
So the time that the infotainment system is registering is when the infotainment system goes on, not the power on event.
correct.
So that 3 seconds that was tested with the exemplar vehicle between pressing the button to turn the car on and the time the infotainment system turns on, the infotainment system clock does not accommodate that 3 seconds.
Correct.
So when we're talking about time on infotainment system, we're talking about after the 3 seconds when the screen comes on.
Yes,
Okay. Now you've made some slides and you've made some assumptions suggesting that that 3 seconds should be added to your
He didn't like
analysis.
that.
And I want to ask you,
Look at that. Look at that hard blink. He didn't like that. He didn't like Brennan saying that.
okay, now
His
you've made
assumptions.
some slides and you've made some assumptions suggesting that that 3 seconds should be added to your analysis. And I want to ask you about your analysis regarding the 3 seconds.
It's slight, but the jurors are looking at you and they will notice things. I noticed it. I'm able to go back. They might have not noticed it. They might be feeling the same way. They might be like, dude, what are you doing? Like, calm down to this witness. Like, chill. Like, you just said assumptions, like, whatever. But this is not an experienced expert witness. Is he carrying himself better than a good chunk of the expert witnesses that we've seen in this very specific trial? Yes.
If we could turn to page 7, please. If you could zoom in on the left side. Sir, you told us that you didn't do any testing or data vetting yourself. You simply relied on reading and reviewing Mr. Burgess's report and Mr. Welcher's report.
correct.
And really, the information you're reviewing is Mr. Burgess's report. There's only a few references in Mr. Welcher's report where he cites Mr. Burgess's findings, correct?
Most of it is from Mr. Burgess's reports.
There's really nothing in any of Dr. Welcher's reports that you are considering that is not in Mr. Burgess's report.
The .154 alignment methodology, I think exclusively is in Dr. Welcher's and is not present in Mr. Burgess's.
Did you read both of Mr. Burgess's reports?
Yes,
You're not aware that Mr. Burgess talks about that timestamp in his reports?
he mentions it in the second report to say that he doesn't think, basically, he doesn't think Dr. Welcher should have aligned it on that.
That is exactly not what he said. Where in the report,
Sustained.
where in his report does he say that Dr. Welcher should not have relied on 154? Where does it say that in his report? I have it here. If you can give me the page, we will take a look at it.
I don't know the page, and I'm paraphrasing. By no means am I conveying that as I'm directly quoting it, but I remember that as something I read in there.
Well, I was careful in your affidavit not to paraphrase you, right?
Sustained.
So when you just made that assumption or that suggestion characterizing Dr. Welcher's state of mind or thought process, is there anywhere in the report you can cite or show me where Dr. Welcher said that?
No.
Okay. When you read Mr. Burgess's report and you learned that he and others obtained an exemplar vehicle and did this testing, you have no other independent information to suggest that the power on, power off event and 3-second delay is inaccurate, do you?
I just want to make sure I heard you. Did you say accurate or inaccurate?
Inaccurate. I'm sorry, the fan's on. I'm trying to
I know
shout.
that's the only reason I couldn't hear that. So can you state it one more time?
I'll rephrase it. When you reviewed Mr. Burgess's report and reviewed the information about his exemplar testing regarding the 3-second difference between turning on the car and the infotainment system going on, You have no other information that you looked at or studied that changes that analysis, do you?
No.
Now, when you are suggesting, could we shrink that and zoom on the right side, please? When you are suggesting that 3 seconds should be added to the time because of that 3-second gap, do you think maybe you made a mistake in considering it that way?
No.
The time that you're adding 3 seconds to is the infotainment time, the infotainment clock, correct?
Yes.
The infotainment clock begins when the infotainment system goes on. We just spoke about that, correct?
Right.
Which is 3 seconds after the power on event.
Correct.
So you're essentially double dipping. You're adding 3 seconds that has already been
Back to the
separated
witness.
because
I
it
want to
is
know what the
reflected
witness
on the infotainment
is
system.
doing.
Isn't that true?
That's incorrect.
You believe that 3 seconds between the power on and the infotainment system going on should be accommodated extra on top of it.
It's not that it's extra. It's because when we're talking about times here, we're pulling a time from the infotainment and we're marrying that with a key on timer from the vehicle control history. Those are separate systems. So if the vehicle control history had its own time, then what you're saying would be correct. We wouldn't account for any delays because then it's already baked into those numbers. But this is a very unique analysis. This is not something I've ever.
No, there was a specific moment that Brendan stopped speaking for a reason, and he was waiting, and I wanted to see, but the camera's on Brendan for some reason, even though the witness is talking. I don't think he's sweating bullets anywhere near the way Burgess was sweating bullets. That man was nearly imploding. To be fair, I think Burgess was sweating bullets way more than this witness. I don't think this witness gives a goddamn anything. I think Burgess was sweating way more bullets. He might be sweating a little bit, but which is fair. It's not easy to have your entire career put on a stage in front of a court, let alone one that's being streamed to millions of people. But I think Burgess was sweating a little more.
Seen this type of analysis here where we're comparing a timestamp from an infotainment SD card to a VCH total time. And so the only way to reconcile those two is we have to align them. And the 3 seconds is the alignment between those because the VCH key on timer is going to start as soon as the vehicle is turned on. And that's the 3 seconds.
You've never seen this before.
I've never seen the approach taken here in this analysis by Aperture. That's what I meant by this. I'll clarify. I have not seen a timestamp from a key on event in a Lexus infotainment used in addition to the key on timer from that same Lexus.
You know, Mr. Burgess actually looked at the data, not just the timestamp. You looked at the data. You understand that, don't you?
Sure.
You did not, did you?
Which data?
The data for the timestamp on the text stream data.
There is no timestamp on the text stream data, is my point. It's a derived value from the key on time, and then added to that is the elapsed time from the text stream. So they're separate.
Did you look at the data to make that determination that you're claiming right now? Did you actually look at the data?
Yes. Yeah.
You looked at the raw data?
I looked at, yes, the raw text stream data.
The raw text stream data from infotainment, did you look at it?
I just don't want to mince it. The text stream data is an independent system from the infotainment, and you said from, so
Pardon?
they're not.
Did you look at the infotainment raw data?
I did.
Okay. And did you find a timestamp on the infotainment raw data?
Yes.
Now, when you added 3 seconds, you were trying to, in addition to the infotainment data, you were adding on the 3 second delay that now you're saying might not even be accurate. Is that fair to say?
I don't think I've ever said it's not accurate. I said that in the exemplar testing, they documented this behavior of a 3 second delay. And that needs to be accounted for if you're going to correct the timestamps. However, the caveat I put on that was only with one exemplar vehicle. So it could be that this behavior, the 3 seconds, is unique to the exemplar and would not apply to other similar vehicles. And so that's why I did either nothing or the 3, because there's nothing to support something in between.
So you disagree that the clock stamp on the infotainment module begins the run. You believe that there's potentially 3 seconds before when the ignition goes on that should be added to that time.
I know from testing other Toyota systems that the key on timer happens almost at the identical time that the vehicle is turned on. That timer starts running basically immediately.
But on this case, you don't know anything firsthand because you didn't do the testing yourself.
I don't know if it would specifically apply to this Lexus. I know that from other Toyota testing, but
And
not
you're
this specific Lexus.
I'm sorry, finish.
No, just I'm clarifying. I do know that from other Toyota and VCH systems that key on timer is basically simultaneous with the key on. I have not tested it on this, and I don't believe that it was tested by Aperture when they had it either. They didn't document the accuracy of the run timer in their exemplar, so we don't know.
Well, you don't know that they didn't document that.
To be fair, if they did, it was not in their reports.
Right. So in this case, you said cars are different, and that's why you're hesitant to accept the fact that there's a 3-second delay. It's a yes or no question.
I'm saying we don't know. If had Aperture done testing with a separate vehicle, then we could establish, is the 3 seconds the same or is it unique? We don't know. The answer is we don't know.
And so when you are determining that 3-second variance, you don't have any assurance in your own mind whether or not this car, Ms. Reed's Lexus, has a 3-second variance. That's what you're trying to say.
That's correct. And that's why I run my calculations with and without it.
And the way you would determine that is to actually do testing or look at the data.
More testing, I think, is the only way that would be able to be determined.
Now, let's turn to slide 9. As part of your charts, could you enlarge left, please? As part of your charts, you took this chalk from Attorney Burgess's report and you made some assumptions about this, didn't you?
I'm not sure.
Okay.
I applied the numbers in his third column to the times. So, I mean, that's the extent of the analysis.
When you looked at the first 5 columns, 1:14, 13 a.m., 4:38, 16 a.m., 4:42:06 a.m., 4:45, 12 a.m., and 5:04, 28 a.m. You said on direct examination, oh boy.
Oh boy.
You said on direct examination that was matching infotainment to iPhone.
That's what it says on the chart. So
Okay.
that's probably what I said. I don't remember specifically, but that's what the chart says.
Is that your opinion that those first 5 columns are matching infotainment to iPhone?
The chart says infotainment call timestamp in column 1. It says O'Keefe iPhone call timestamps in column 2, and then it says offset. So I'm taking that at face value.
You're
That I
basing
don't
your later charts
know if I
on the
can
predicate
fully agree.
that these numbers, the first 5.
Is Brennan doing a good job in being a defense attorney right now? Yeah, of course. He is a defense attorney, so his crosses are going to be good. I don't know if it's necessarily strengthening the Commonwealth's case, because I think the jurors are going to sit there and say he wasn't testing anything. He didn't test anything. It's not even like he tested one thing and didn't forget and forgot to test another thing, or tested some things and didn't test other things, or purposefully left out things in his own report. I don't know if I could say that the Commonwealth's case is being strengthened necessarily by this cross-examination. I think he's doing a really good job of putting him in the hot seat and saying, "You sure? Are you sure? how sure are you? So I don't know if strengthening for me personally is right, but again, it's not over. Um, I think that I think the way that this witness is handling the questions is sort of reassuring the jury, like, you can't always make something specific down to an exact pinpoint. Um, that this, you may ask a yes or no question, but the answer is a little more. So I think he's doing a good job at not being defensive when it comes to having the cross happen. Like, we see a lot of witnesses become very defensive when the defense team comes up for cross examination. He's doing a really good job at just simply answering the questions, and he's making sure he's using words that not only Brennan will understand, he will understand, that make sense, but the jury will understand too. So strengthening the Commonwealth's case, I cannot fully agree with. Is Brennan doing a good cross? Yeah, I think he's doing a pretty good cross. Are there moments where 6 comments now and he has not been admonished by the court? I think is a little unfair. And he's going to be able to keep going and keep going until the court looks at him and says, no more comments. Just like she did to the other attorneys as well. But yeah, I can't fully agree with the strengthening the Commonwealth's case right now. But I'll have a better idea once the cross is over.
5 columns are infotainment compared to John O'Keefe's iPhone, aren't you?
Based on the chart, yes.
You didn't do any study on your own to determine the genesis of that information, did you?
I'm aware of the fact that these calls, the 5 you mentioned, were placed when the vehicle was in a keyed off state. I'm aware of that.
What I asked you specifically is, on those 5 columns, did you do any research or study to determine whether or not it was infotainment matched to John O'Keefe's iPhone or some other phone matched to John O'Keefe's iPhone? Did you do any independent studies about that?
No.
Because in your ultimate conclusions and all the charts you've given to the jury and shown the jury, it relies on the conclusion that the first 5 columns are a comparison between infotainment clock and John O'Keefe's iPhone. Isn't that fair to say?
That's exactly how the chart presents it, and that's how I present it.
Did you know that at 1:14:13 a.m., the defendant's Lexus was turned off?
Yes.
Did you know at 4:38:16 a.m. that the defendant's Lexus was turned off?
Yes.
And did you know for 4:42:06, 4:45:12, 5:04:28, did you know that her Lexus was turned off?
Yes.
Do you know that when you make phone calls, oh, by the way, do you know on those different times, the first 5 times, where that information is generated from?
Which column?
Left column, 1:14:13, all the way down to 5:04:28. Those 1, 2, 3, 4, 5 columns. Do you know where that information came from?
It came from the SD card from the infotainment.
Do you know where the genesis, the beginning, the source of that information? That matters, right? The source?
It would.
It would. Do you know where it came from?
The assumption, the assumption is if the vehicle has a timestamp and the phone wasn't connected, it would have been synchronized after the fact. But that wasn't tested. And Aperture didn't do any of that testing in their work to look at the behavior of a timestamp in the infotainment when a phone is synchronized after the fact.
Blaming Aperture is not going to get you out of answering the question. Did you know?
Sustained.
Sure.
That was like the 7th one that I've counted for comment. And I think Jackson is probably having that notice of, oh, okay. Let's see here. We can. Oh, that was really short. It was like 10 seconds.
Do you know the genesis, the source of those 4 numbers?
Definitively no.
your entire premise for your slides and values and ranges depends on knowing the genesis of those numbers, doesn't it?
I relied on Mr. Burgess's explanation that those times were synchronized after the fact.
Did you know that those are all phone calls from the defendant's phone to Mr. O'Keefe's phone?
Yes,
You did know that.
I know that they're phone calls
From who?
between. Sorry, can you maybe just state it more clearly? Because I'm not sure. I don't want to fumble through an answer if I don't understand the question. So
Do you know where those calls came from? The source.
a phone,
Whose?
Miss Reed's phone.
Now, I know you're not an expert on mobile devices, but
Do you know where these phone calls came from? Phone.
did you know when it's not a contemporaneous synchronization?
I think he's like, oh, you want to get a little snarky with me? I can get a little snarky with you. I think he's had enough of like being like the nothing can touch me. I think I think this witness has had enough of like nothing can touch me. So he's like, I can be a little snarky too. That was a little snarky.
Synchronization, you plug your phone in, it's going to register on the infotainment system, but come from the phone. Objection.
Sustained.
Do you know when someone plugs their phone in after they turn the car back on, how it synchronizes on the infotainment system?
I don't know if adjustments are made to those times during a synchronization or not. I think that's something that could be tested, and to my knowledge, was not tested.
If you don't know, then your conclusions and all your opinions to this jury is based on an assumption that you don't even know the predicate for. Isn't that fair to say?
My conclusions are based on all of the data that Mr. Burgess laid out. So he laid these out and went so far as to calculate the offsets himself. So there's something implied in his table by virtue of him calculating these that maybe he would decide to align them. And so, again, to provide the clarity on all the possible alignments, I included them.
But that's not what I asked. If you're making an improper assumption about the predicate, about these calls and the source of them, and you're wrong, that would change your entire analysis and conclusions and charts that we see in your later charts, wouldn't it?
Sure, if there was testing that showed that that is an invalid method on this specific Lexus and SD card, then of the 30 possibilities, some of them would end up being eliminated.
Did you know that when an iPhone is plugged into a car, it downloads the information from the iPhone on the infotainment system? You know that?
I don't know how the clocks are synchronized when you plug an iPhone into a car.
Well, if you don't know, how can you make conclusions based on a predicate you don't even know what it is?
The conclusions are based on the data in Mr. Burgess's report.
I know you're not an expert on mobile devices.
Objection.
I
So I'm going to strike that. Go ahead and ask your question.
apologize.
And tell him to stop making comments. Your Honor, come on. That's 8 now that I've counted.
If you have two different devices, a Lexus clock, the entertainment system, and an iPhone, you would agree that it's not unexpected to be variances, correct?
Correct.
When you're comparing two iPhones, do you have an opinion? Do you agree that you'd expect the variance to be very small, iPhone to iPhone?
I don't know.
Have you ever studied that before?
2 iPhones?
Yes.
No.
So if you sit there today, you don't have any expertise, any education, any knowledge about how closely 2 iPhones would sync with each other?
No.
Do you see in the first 5 columns the numbers are small, 22121?
Yes.
Would you agree iPhone to iPhone using the same source of time is generally going to be within 1 or 2 seconds of each other? Objection.
Sustained.
Do you have any opinion about whether iPhones to iPhones will generally be within 1 to 2 seconds of each other? Objection.
Can I ask if there's an opinion? Do you have an opinion on that?
No,
Next question.
If the first 5 calls are iPhone to iPhone rather than infotainment to iPhone, you agree all of your assumptions and conclusions are inaccurate.
they're not iPhone to iPhone in the sense that column 1 came from the infotainment. The values were read from the SD card. So there's an assumption baked into what you're saying, that when a phone is synchronized, the infotainment assumes the times of the phone, but we don't know whether the infotainment would adjust those times to its own clock or not.
You're speculating now, aren't you?
We don't know. It wasn't tested. I don't know is the
You
answer.
don't know.
I don't know.
You don't know.
I do not.
Okay. Don't say we don't know. You don't know.
Hey,
So-
come on. Hello?
iPhone
Hello?
to iPhone.
Hello. I would be this pissed too. Hello. Okay. This is absolutely out of hand. I like it when Judge Beverly Cannoni says, hello, no comments, ask your questions. I like it because it's not appropriate. Stop it. Hello, that's great. But do it for Brennan too. And this is why people say there is a bias. This is a perfect example of why people say there is a bias. This is a perfect example of why people say there is a bias. I try my best to sit on the fence. I try my absolute best, right? But this is now 9 that I have counted. 9 inappropriate comments made by Brennan, where Judge Beverly Cannoni has yet to say no comments. Jury, please disregard the comments. Questions only. This is the 9th time. Singular witness. And I am so cool when she says it to them. I am so cool when she says it to the defense. What do you mean you are not going to do? And this is why people say there is a bias. Right? And I do my best. I do my very, very best to sit on the fence and say, let me hear everything out. Let me just hear the evidence. I don't want to deal with the stupid drama of it all, the bias this, the bias that. I don't do your job. Just do your job, get it done. Show me the evidence. That's all I want to hear. Right? But this is why people are saying, hello, there is a bias and this is unfair. This is vindictive. This is why she has yet to say on the record. I don't care what she says on sidebar. I don't care. The jury's not hearing it. But you know what the jury does hear? Every time you ask the defense to hurry up, every time you ask the defense how much longer you have till blah, 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 every time you tell the defense no comments. But the jury isn't hearing a single word from you when it comes to the Commonwealth. And that is why people say there is a bias. Now, are the times when she's speaking to the defense about, hey, no comments, super fair? Absolutely. Because stop making comments, you stupid idiot. Just do your job. Stop making comments and just do your job. Right? But do the same with Brennan. Do the same with Lely. Do the same with the Commonwealth. Please, for the love of God. Please. That set me over the edge. Just tell the jury words. Give the jury words about it. Make it known that you hear it too. That it's not just bad when the defense does it, that it's also bad when the Commonwealth does it. Right? Like, just come on. I'm here for it. Court can get sassy. Court can get fiery. Court can get a little saucy and I'm here for it. But also deal with it the same way. Deal with it the same way. For wherever the sass is coming from. If there is sass, you deal with sass in this way. Deal with the sass in the same way you deal with sass from all the other places. That's all I want. I don't look what the hearings, the judgments, whatever, do whatever. I don't care. Like, at this point, it is what it is. But at least deal with the sass in front of the jury the same way. It's let's go back.
No,
Speculating now, aren't you?
we don't know. It wasn't tested. I don't know is the
You
answer.
don't know.
I don't know.
You don't know.
I do not.
Okay. Don't say we don't know. You don't know.
Sustained.
So this is iPhone to iPhone.
Nothing.
Then your
Crickets.
assumption on the first 5.
Crickets.
1, 2, 2, 1, 2, 1. If they're iPhone to iPhone, and you're wrong about the fact it's infotainment iPhone.
I want to be able to enjoy the zingers, and I will be able to enjoy the remarks if they are all treated the same, right? I can enjoy them if they're all treated the same. But once there's an imbalance with the sassiness, with the sauce of it all, with the little extra, the cayenne peppers, the here and there's, when there's an unevenness, I can't enjoy it. I cannot enjoy it. I cannot enjoy it because I want her to interrupt everything. I want her to say, cut it out. No question. No remarks. No comments. Ask your stupid questions. Ask your stupid questions. Let's get this shit done with. Like she wants to be. If there's anyone who wants this over with, it is Judge Beverly Cannoni. She would like to not be doing this anymore. So don't do this anymore in as fair a way as possible.
Your assumptions and conclusions are inaccurate, aren't they?
Unenthusiastic, yeah.
I'll allow this.
If the title of the first column had iPhone in it as well, then I would not have used it in my analysis.
But that's not the question. I appreciate that. My question is, if those first 5 calls were iPhone time to iPhone time, and you mistakenly analyze them as infotainment time to iPhone time, then the rest of your assumptions and charts would be inaccurate, wouldn't they?
Objection. Sustained.
At 5:21:36,
Welcome back.
do you know whether or
Welcome
not
Holy shit.
the defendant's Lexus was on?
I don't recall.
Sorry, I was
At
hollering.
5:21:36, do you know whether or not the defendant's Lexus was on?
I don't recall if that one was an on or an off point. I don't want to guess. I don't recall.
And so if you don't know if that was on or off, were you able to do an analysis whether this was phone to phone or infotainment to phone?
No.
5:30:31, do you know if the defendant's car was on?
That one I know the vehicle was on.
That's one timestamp on the infotainment system, 5:30:31, correct?
Correct.
And then in the O'Keefe iPhone call timestamps, there are 2 different numbers, 5:30:15, 5:30:52. Yes?
Yes.
Right. And do you appreciate that that is 2 separate calls, or do you think it's something different?
I'm going to paraphrase again Mr. Birch's report as I recall it, and that he stated during the testing they did with the exemplar, calls placed in close succession would not necessarily both be logged in the infotainment. So as I understand this chart, what he's trying to say here is there were 2 calls placed. There were 2 call logs in Mr. O'Keefe's phone, but only one timestamp in the infotainment, and he couldn't determine which it corresponded to because of that observed behavior from testing.
I'm asking if you know.
I don't.
Did you ever look at phone records for the defendant or for Mr. O'Keefe to make a determination whether these are 2 separate calls or not? Did you ever do that?
No.
If these are 2 separate calls, can you explain to us why there is one timestamp?
Again, as I stated, that was behavior that was observed. The exact behavior was observed during the exemplar testing by Aperture. I don't know why that happens. Why does the infotainment not log every call?
Yeah,
I don't. But I know that it was documented that that is a feature of this system.
This information was not taken from the exemplar.
Yes.
was it?
This table, no.
This information was taken from the infotainment system of the defendant's car. Isn't that true?
Yes.
And the phone calls were taken from Mr. O'Keefe's iPhone. Isn't that true?
Yes.
And so, you know why there would be 2 phone calls and only one timestamp?
Beyond the testing, the exemplar testing that showed an exemplar vehicle did that, no, I don't know why it happens.
Do you know that the infotainment system doesn't always capture all of the phone calls and the phone data in the download? Did you know that?
Yes.
Well, if you know that, can you conclude that even though there's 2 calls and only 1 timestamp, that's because how the infotainment system works?
I think that's the most logical assumption, that that's how it works.
So when you look at 5:30:15, right in the middle, and 5:30:52, it is impossible to tell which one relates to the 5:30:31 infotainment on the left. To compare, it's impossible, right?
Yes.
So there's 2 possibilities.
Yes.
One is that you have a difference, a disparity of 16 seconds.
Yes.
And the other one, going the opposite way, is a disparity of 21 seconds.
Correct.
And so when you add those disparities, you have 27 seconds disparity. Correct?
I'll allow that.
Is there a 27-second disparity when you compare the 2?
I'm not sure I understand the math.
5:30:31 is 16 seconds different than 5:30:15 on each phone. Yes?
Yes.
5:30:31 is 21 seconds different than the 5:30:52 phone call. Yes?
Yes.
And the difference is cut each way, one's minus, one's plus.
Correct.
So when you add those disparities,
Now that no strays, I can fully agree on. Alan Jackson versus Hank Brennan in cross. Let me clarify my agreement. I think Alan Jackson and Hank Brennan with Hank during the defense's case in chief with Hank Brennan in cross is like a heavyweight boxing match for law nerds. I can't necessarily say the same thing as Hank Brennan playing special prosecutor indirect, because there were a lot of times where I was sitting here going, I can't wait for cross-examination to help me clarify what the hell just happened, or the nitty-gritty of the expert witnesses. I don't think Hank Brennan has the knack that a lot of trained professional working for forever, I don't know how old they are because it doesn't make sense in time, prosecutors, when it comes to what is this? What is this? Can you tell me what this is? Can you tell me what this is? How does A and B work together? How does A, B, and C work together? How does B and C work together? So if you have A, B, and C together, does that make D? Yes. Like the clarity, like the teaching aspect, like teach the jury the expertise that the expert is witnessing or witnessing. They're witnessing on the witness stand, testifying to. I think Brennan lacks that ability to teach the jury about the expertise of the witness and then get into the details and the data and the research and the science and the testing, make us understand all of the things, give me all the character layout, and then get into the actions of the characters. I think Brennan lacks that a little bit. And so I knew, at least for me personally, he loses me. He loses me when he's trying to introduce new things. There's a lot of like backtracking that doesn't quite make sense. Like he forgot a question or he thought of another question. He's like, I'm just gonna go back real fast. Those types of things. It loses me. But I like Hank Brennan so far as a defense attorney, as in someone who is crossing someone harshly. I like it. And I could probably see Alan Jackson and Hank Brennan having a big, strong Massachusetts liquor once all this is done, shaking hands and saying, hey, keep in touch, man. Because they can see each other for what they are. And I will say the same, that if Alan Jackson had to step in and play special prosecutor, I don't know if it would be much different from Hank Brennan. I think the processes, the behind the scenes, the hearings, the pretrial stuff might be a little different, but I think he'd have a hard time too playing special prosecutor, bringing the initial case in chief and all of that. But yes, right now, head to head, I think very interesting. Very interesting.
27 seconds. Huh?
Objection.
I'm going to allow that.
No.
Okay. What do you get?
You're saying, if maybe so I can be clear what you're asking, if we have a negative 16 and we have a positive 21. How
Correct.
many seconds are in between there?
Exactly.
37?
And so you can see, did you know that the defense car was turned on at 5:07?
But I do have to say that Alan Jackson has a better time as speaking into the microphone.
Does that ring a bell?
I don't have any of those key-ons committed to memory.
So you can see between 5:21 and 5:30, the offset is different between them, which shows that variances change. They move.
That seems reasonable, yes.
But when I said it seems reasonable, do you have the experience and the knowledge to agree with me that variances move?
Yes, they do.
Okay. If those first 5 calls were iPhone to iPhone rather than infotainment to iPhone, would you agree they should not have been considered in your analysis?
Yes, with the caveat that because this is a novel analysis with this SD card and this infotainment, that it was demonstrated that that's the behavior. My opinions on things like that are based on testing and research and literature. And so when we have a brand new system with new data, we want to see some testing to prove it works the way we think it works. But under the assumption, then yes.
You would agree?
Yes.
If we turn to 10, please.
Are we gonna do it? Are we gonna get there?
Given, could you
Can we see it?
zoom in a little, please, on the left?
Can we see it? Hello? I think the cameraman fell asleep. And by cameraman, I mean
that these
cameraman.
data points come at 5 in the morning, or 1, 4, 4, 4, 5, 5, and 5:30.
I'd love to see it.
Did you consider whether they would be less reliable
Brother.
than comparing to the triggering event, the 3-point turn at 12:23 the night before? Did you consider that?
Yes.
When you said you reviewed and you're critiquing reports, did you read Mr. Burgess's report on May 8, 2025?
Yes.
Did you read in his report where he explains that this is a less reliable method to, it's a less reliable method because of the time distance between the actual event we're interested in, 1162 at 12:31, 43 to 48, than the 3-point turn?
Yes.
Okay. When he explains that the method
That was weird. Hold on.
is that the turn.
Yes.
What
When
happened
he
to his microphone?
explains that the method
Did his microphone just go out? No? Glitch? You pop?
of using 5:21 and 5:30 on January 29, 2022, he explains about how the information is stored in the infotainment system when it's powered back on, doesn't he?
I'm not sure.
Well, do you remember when you were reviewing his report that he explains the available call log correlation is restricted to a time frame between 5:21 and 5:30 a.m. on January 29, 2022, when the vehicle was powered on. All other calls stored in the infotainment module occurred while the vehicle was powered off, indicating those entries were synced from Ms. Reed's iPhone upon reconnecting to the system on the morning of January 29th. You considered that when you decided or formulated your critique, didn't you?
Yes.
This further indicated that the associated timestamps for those calls originated from Ms. Reed's iPhone. Did you read that?
Yes.
Relative to those first 5 columns, correct?
Yes.
This behavior was previously documented in the initial report, which is the January 30th report. Yes?
Yes.
You shrugged. I mean, I don't want you just to agree with me. Do you remember it was in the January 30th report?
I don't remember how he phrased it specifically. but I think there was somewhere around there where he noted that some calls were placed while the vehicle was off. I think that's basically what it said in the first one. I don't remember specifically.
Okay. Do you agree generally, or can I give you the report? You can look and remind yourself. I want to get your best memory on this.
Sure.
What would you like me to do?
If you'd like me to look at it, I'll look at it.
Sure.
Do-
Do you
do
have
you
a
have
copy,
the-
or would you like me to bring it
Do you
to
have the reports with you, sir?
not.
Okay. Do you have an extra copy for him, Mr. Brennan?
I want to know what the jury is feeling about it.
Copy.
Oops. What do you
Show
think?
you something that has my writing on it. Not that I care that you read it, but it's protocol. Okay. In discussing why this is not an effective
I don't wanna
way
read
of
your shit.
matching the time,
Anyway,
did you consider in his May 8, 2025 report when he's
I would also really love to see what is up on the projector. Does Miss Little? She probably does. She probably does, but she was not asked, and she is not going to interrupt. Nope, she's not. She's not going to do that. Should Brennan have an extra copy of like everything for a witness? Yes. Yes. Should the defense have an extra copy of everything for the witness? Yes. Yes, they should. They should have multiple trees worth of paper. And when we see whichever attorney is up at the podium, you can see that back room, which is clearly being used as like a storage room, and there's like a printer back there. There's a lot of paper. There's a lot of paper. There's a lot of paper. So yeah.
talking about this method, when he says, as a
so
result, this
done.
method yields a single
This man is so done. And like, I get it. He's so done. He so wants to be out of here. He's so over it.
reference
Sorry.
point to
I'll
consider
go back.
in his May 8, 2025 report when he's talking about this method, when he says, as a result, this method yields a single reference point for potential alignment.
Yes.
And when
Call
he's
logs
talking-
are discrete points.
I'm sorry?
The call logs are discrete points for alignment. Is that
As a result, this method yields a single reference point, is referring to the 530-31.
I don't know. It sounds like it, but I don't know.
From the 5:21 a.m. to the 5:30 a.m. window, a cluster of approximately -8 and -16 plus 21 seconds were observed between the Lexus clock and Mr. O'Keefe's iPhone clock. Did you consider that?
Yes.
This offset is measured approximately 5 hours after the time of the collision and cannot be assumed to apply to other time frames stated in the initial report. Objection.
I'm going to allow it unless, do you have, I'll see Counselor Tadmar.
I can hear my radio station playing in my store right now, and I love this song so much. You probably can't hear it, but I know what it is, and it's amazing.
Sir, going back to my question, so you read Mr. Burgess' report, the same report that you're critiquing, and you were aware of this information, weren't you?
Yes.
And so you were aware that Mr. Burgess in his May 8th report was identifying that the section in green was the only contemporaneous information for analysis. Did you know that?
Is that how he states it specifically?
I can read it again. I just read it to you.
If you don't mind.
Okay.
So let's give him a copy.
I'm sorry, Your Honor?
Let's give him a copy. Does he have the clean copy?
Again, do not take the lawyer's word for what the paper says. Do not just agree to it. And he has not directly said like like a Buchanan or Jen McCabe, like show it to me. He hasn't said that. He verbally says, you know, like if that if that's what it says, or I don't remember verbatim. You know, the summary that I remember is this way. And I think that he is being very clear with that to the jury. And I think it's definitely important to, if an attorney in trial is saying, is that what it said, and he just read words and you don't remember, you don't have a photographic memory, then you need to see it. You need to see it, because you now take the lawyer's word, because they could be like,
You can turn to page 3.
right?
What I read to you was where it says clock sync method 1. Do you see that?
Yes.
And this is, if you look at the second paragraph, I read that to you word for word. Do you see that?
Yes.
The 5:21 a.m. and 5.
You don't have to be mean about it, though. I read that word for word. Do you see that? No, I do. I wouldn't be able to tell you earlier if you did or not, because I don't have the words that you read word for word in front of me. So we went back to
And this is, if you look at the second paragraph, I read that to you word for word. Do you see that?
Yes.
The 5:21 a.m. and 5:30 a.m. are the only 2 data points when that car was on January 29, 2022. Is that fair to say?
Yes.
Okay. And if you look at the last paragraph, do you agree or disagree? As a result, this method yields a single reference point for potential alignment. Do you agree with that?
No.
Because you still are under the mistaken belief that
Sustain.
you still have the opinion that the first 5 rows are an infotainment to iPhone analysis.
It's presented as that way in his initial report, which is what my initial analysis was based on. And in the supplemental report, there's no further testing to say one way or the other. He just has a new opinion. So I stand by the initial analysis that I had, that those points should be included with all of the other points.
But that's not my question. My question is, you are taking the position those first 5 calls are an infotainment to iPhone analysis.
They could be, and so I include them. I'm not saying they definitively are or not, which is why I never say there is one way to do it. That's why I say there's a whole host of ways to do it.
So you're now saying that you're not assuming that's an infotainment to iPhone analysis. Are you now saying that?
It's stated that way, and I think it could be that way, but it might be iPhone to iPhone too, if those times are just copied over.
And if it was iPhone to iPhone, your analysis would be wrong.
Certain lines would go away. So if you want to call the whole analysis wrong because of that, it might be your characterization.
Okay.
It would change the total number of possibilities.
that was a very professional way of saying, I mean, you could try to be wrong like that, but I mean, like, if you want to like pinpoint every single thing on like this one little thing, then sure, but like that's up to you. And the jury heard that loud and clear. That was a very professional response. I have to give props to him for that. Have there been moments where I'm like, ooh, ooh, yikes. Okay, good job, Brennan. Good job, Brennan. You know, but
Wrong.
that was a very professional response.
Certain lines would go away. So if you want to call the whole analysis wrong because of that, it might be your characterization.
Okay.
It would change the total number of possibilities.
So if we put up chart 12, page 12, please.
I'm sorry, I'm pausing a lot. We're really not that far behind. I also think this is a great example of a witness who not only is not fighting, but is not demanding to explain. He's given the room to explain sometimes, and then there's been moments where he said, well, yes, you know, if I may explain the caveat to this, like, it's not a definitive. You're asking a yes or no question, but it's not a definitive. And he's not demanding it with body language or over talking. He's just continuing on. And I think Brennan does very well with, for the most part, definitely better than the defense team sometimes. That's terrible. at not talking over, or if it does happen, he says, please finish your, please finish your response. So I think that's very good. I like that from him, but I also like this from the witness, that he is clear. It's not when he says no, he says no. When he says yes, he says yes, and he is taking his time answering the questions. He is super duper clear, and he is making sure that the questions coming in are clear too. I really like, he may not be an expert at being an expert witness, but he is proving himself pretty solid, in my opinion, as a professional person. You can be up against someone who completely disagrees with your science or your analysis of the science, because that's what his job was. He was here to analyze the science done. And so you can be up against it, and the slow blinks and the, the behind the eyelid eye rolls, that's fine. Whatever. Everyone's allowed to be annoyed. But I think he's doing a really good job. Could he be a little bit better? Yeah, but like, like how it's the second time, it's a second time. But the jury knows it's the second time, but they are expecting the same level of professionalism, I would hope, from all expert witnesses, from all of the big suit wearers, like, you're wearing a tie. Don't be a jerk. Because these are people too, and they can get turned off. And if I don't like
If you were wrong,
if I don't like somebody, it takes a lot for me to actually like them again. If I don't like you because you grossed me out, you pissed me off, you made me annoyed, you were a jerk, you were mean to somebody, and I saw it, whatever the reason that I wouldn't like somebody, it's going to take a lot of work for me to like you again. So it does a lot of damage when you get into the jury's bad graces.
about the
Is it bad
infotainment to
graces?
iPhone analysis,
It's not bad graces, it's
and
good
those
graces.
first five should
Negative,
not be
opposite of good
considered,
graces.
which part of your chart would now be wrong?
Finally, we get to see it.
What do we have? 12 lines on the chart?
I'm sorry?
Yeah, we have 12 lines on the chart. If we decided to eliminate the lines that are based on the calls when the vehicle was off, we would be left with 4 lines on the chart.
And if we turn to 14, please. And if you could enlarge, well, I don't think you can enlarge it. If your analysis about infotainment to iPhone was wrong, you would agree those first 1, 2, 3, 4, 5, 6 columns should not be there, should they?
No, the positive 16 stays, the negative 21 stays, 1, 2, 8, and 20 would go away. So we'd lose 4 lines from this chart.
In the negative 16 line, that comes from information at 5:30 a.m. the next morning.
Correct.
And you would agree that that distance is not as accurate as queuing it from the 3-point turn event 11:62:1.
The 3-point turn is closer in time than the call at 5:32.
And thus more reliable, wouldn't you say?
Generally.
And the negative 21, that was from 5:30 and some seconds the next morning. Same idea, not as reliable as the 3-point turn information.
There's greater uncertainty the farther in time we get.
So when we turn to the 3-point turn information, you mentioned in Dr. Welcher's report that it was noted that the timestamp 154 was the end of the 3-point turn event, correct?
That's how he states it.
And then more information was provided when Mr. Burgess then broke down that 154 timestamp, correct?
Correct.
And when he broke down the 154 timestamp, he actually wrote a report about it, didn't he?
Yes.
He didn't just have it in his head. He put it on paper for all to see, yes?
Yes.
And in that report, not only does he break down the data, he also shows a visual of the actual data on a map, doesn't he?
He does.
Exhibit 192A. Okay, let's start with 192B, please. If you could open that up so we could see it a little better. When you look at the data he
Could we
actually
see it?
broke down,
Could we see it?
do you agree that instead of at the end of the three-point turn event as timestamp 154, that actually is at the beginning of the three-point turn? Do you agree with that?
I don't know if the points are numbered on here, so I can't tell which point he's referencing as 154.
Do you see the green circle?
Yes.
Do you see the black line?
Yes.
No.
Does that orient
Bye,
you
Vicky.
to
Catch me
the
later.
direction the car was traveling?
That appears to be what he's trying to convey with this chart.
And then the yellow is facing a different direction towards Fairview, correct?
It is.
And do you see the green square rectangle?
Yes.
You think that correlates to the green circle?
That seems to be what this graph implies.
And it notes that
Will do. Will do.
So ask it differently, Mr. Bowman.
does that heading note the start of the three-point turn of O'Keefe's phone is 12:23:59?
I'm going to allow it.
That's what Mr. Burgess states in the report.
And do you have any information to suggest that's not spot on accurate?
No, I didn't do an independent analysis of the three-point turn maneuver.
And then the heading of the change, end of three-point turn to O'Keefe's home, 12:24:07. You have any information to suggest that's not spot on accurate?
I did not analyze the three-point turn maneuver.
And so when you look at that and break down 154, did you determine or make an analysis that 154 that was generally accepted, because there is variances between items, when you break it down with more specificity, 154 is actually earlier than the three-point turn conclusion? Did you consider that?
I'm going to allow that, yeah.
I'm not sure I understand
Okay.
the question, if you don't mind.
You mentioned Dr. Welch's report said it relied on 154 as a
Good job,
timestamp
Brennan.
at the end of the three-point
Good job.
turn.
Yes.
Based on Mr. Burgess's May 8th report and based on the data, which you don't contest, you now agree that 154 was not the end of that three-point turn. It was at the beginning.
Based on how Mr. Burgess presents it, I didn't do an independent analysis. So I'm not on one side with Mr. Burgess or one side with Dr. Welcher. They present independent methods.
Are you suggesting in any way it's inaccurate? Are you suggesting it is in any way inaccurate?
I'm going to allow that.
I don't have any opinions as to the individual accuracy of the methods selected by either Mr. Burgess or Dr. Welcher.
Do you have any information you'd like to add or weigh in on to dispute the accuracy of those times?
Sustained.
And let's turn to the previous exhibit so we can actually see the data that's broken down. You could open that.
Really
The
chafing my
154
khakis.
timestamp, if you go to the left, please. Do you see that right above the green line?
Yes.
12:23:58. You see that?
Yes.
And then the green goes to the orange, and that's an 8-second difference, isn't it?
Yes.
And when you looked at this, you considered that this was a more detailed study of that timestamp by Mr. Burgess, right?
More detailed is, yes, that's correct.
And do you know why he did a more detailed analysis of this? Why it wasn't in the original PowerPoint?
No, I don't.
Well, you said that variances are generally accepted in the community, right?
Yes.
But then you wrote a report suggesting numbers and additions, and you submitted that report as part of the basis of your testimony, right?
I only submitted a PowerPoint. I have no
The
report.
PowerPoint. And after you submitted the PowerPoint, isn't it fair to say Mr. Burgess then analyzed this data to be more specific after you introduced your PowerPoint?
Yes.
So can you guess why he went through a more detailed analysis?
No.
Sustained. Strike it.
Good job,
in the
Brennan.
final exhibit? Let's go back to the data. You said that Mr. Burgess had an 8-second range, 21 to 29 seconds, remember?
Yes.
And you were suggesting that somehow there was some uncertainty. Do you remember that?
Yes.
Okay. Were you guessing about his state of mind, whether he was certain or not? Do you know why he gave an 8-second range?
Objection.
So ask it differently, Mr.
Okay. You suggested.
Yeah, okay.
the
Yeah,
reason
okay.
Why there's an 8-second range is that Mr. Burgess was uncertain. Remember saying that to this jury?
Not in those exact words, but that's what uncertainty is. Uncertainty is a range. If we don't know a specific value, we put a range around it. That's uncertainty. That's a
This data from the green, would you agree it indicates the beginning of the three-point turn, and then the orange is at the end of the car is already in motion at 11.2 miles per hour? Objection.
I'm going to allow it. Do you agree with that?
I see speed values there. I see some headings. I can't convert GPS in my head, so I don't know.
You could have analyzed this data yourself, right? Before you came in and gave it a minute,
I could have.
but you didn't.
I did not.
You have any reason to test the accuracy of this data that's converted? No objection.
I'm going to allow that.
No.
And so by giving the range of 8 seconds, you talked about looking at different values to be fair, wide range, right? Even though this analysis depends on the end of the three-point turn, would you agree it's kind of forgiving to give that 8-second range to give the benefit of the doubt by starting at the beginning of the three-point turn all the way to the end of it rather than just giving the end point?
As to that form, ask it differently, Mr. Green.
Does the 8-second range that is provided by Mr. Burgess coincide with the data and the 8-second range between the green and the orange?
That's where he comes up with the 8-second range, correct?
And so if Aperture's position is the matching times at the end of the event, like going back to the beginning, isn't that even more forgiving than the 8 scientific objection?
I'm going to allow it.
Yeah, I would call it a conservative approach to use a range of values.
Right. The opposite of cherry picking, right?
Sure.
He had to get it back in there.
Do you have an
Yeah,
opinion
go
to
back
a
in.
reasonable degree of forensic data certainty about whether text stream data provides data reflecting whether a collision actually occurred?
No.
In your opinion, to a reasonable degree
Not
of
more
forensic
flowers.
certainty is the text stream data would not reflect the collision, correct?
That's not what I said. I don't have an opinion.
And you know that there can be collisions or touching between vehicle, and it's not going to appear on the text stream data. You know that, right?
It's possible.
It's possible. Did you know that the defendant's vehicle at 5:07 a.m. on January 29, 2022 bumped into a different car?
Yes.
Do you see that reflected on the text stream data?
I'm thinking back to when I reviewed the raw text stream data, and I don't remember seeing an event from that.
I can't really hear
I don't
you.
remember seeing an event from that time in the text stream data.
Well, you don't remember seeing it. It's not there, is it?
I don't think it is. I don't remember seeing it. I don't think there's one.
You're not.
I was going to finish and say I don't have all of the events committed to memory. There's
You're-
19 of them.
I'm sorry.
There's 19 events. I don't have them all committed to memory.
You're not testifying or offering an opinion that there was no collision with this car that night, are you?
No.
Because if you were implying that or suggesting that or insinuating that, that would be misleading, wouldn't it?
It's not.
Sustained.
I have no further questions.
Okay.
All right, back to redirect. Do I think Brennan did a good job?
Yes.
Thank you. You were asked a number of questions.
Yeah, I think he did a great job at questioning every little detail of DeSogra and his PowerPoint. Yeah, he did a great job. I think he went in and he said, I'm going to question you about everything, and I'm going to throw scenarios at you. And if you're so good at analyzing, make it make sense. Make it make sense. Good job, Brennan. Do I think it strengthened the Commonwealth's case? I don't know if I would go that far. There are a lot of cross examinations from the defense that did not weaken the Commonwealth's case. So I don't know.
A few minutes ago by Mr. Brennan concerning your expertise. I'm just going to grab a pen if I could.
Do not steal one of Miss Little's pens, because I know you just stole Miss Little's pen. Leave Miss Little's pens alone.
Specifically, you were asked about your expertise regarding mobile data devices. Mobile devices and their data, correct?
Yes.
And were you being truthful when you indicated that you were not an expert in
Yes.
that field? Were you being truthful when you indicated that you have a certain expertise in EDR data?
Yes.
Were you being truthful when you indicated that you did review Mr. Burgess's data and Mr. Welcher's data as reflected in their reports and PowerPoints?
Yes.
Were you being truthful about your credentials?
Yes.
Have you ever lied about your credentials?
No.
You hold a back.
It's going back to Burgess was not truthful about his credentials, not 100% of the time. He did not make sure the company he worked for was truthful about his credentials. He did not make sure his LinkedIn account was truthful about his credentials. He did not make sure all of his CVs that he's ever used were truthful about his credentials. And those come and bite you in the butt when you are going to be an expert witness in a trial. So Jackson is going, okay, but you didn't lie. Burgess lied. That's what Jackson's getting at. Burgess lied.
Hold a bachelor's degree
Yes.
and you hold a master's degree.
I do.
You ever lied to anybody about that?
No.
Did you like school? Did you like it?
Mr.
Did you have
D'Souza,
fun?
what is the only reason
I didn't like
you
it.
amended your PowerPoint presentation from its original version to the one that you most recently amended it to?
To include the additional analysis and data points from Mr. Burgess's supplemental report,
So-
the May 8th report.
I'm sorry, I interrupted you. Go
The
ahead.
May 8th report.
So you amended yours because he amended his.
Correct.
You were asked just a second ago about all the text stream events that you noted on Ms. Reed's SUV, correct?
Yes.
Mr. Brennan asked you about a specific text stream event at or around 5:07 in the morning, and whether you had something like that committed to memory, correct?
Yes.
You said, I don't have them all committed to memory, right?
I don't.
What did you say after that? Because there's how many?
It was 19 events prior to 1162-2, 19 other events.
How about after 1162?
There were a number after 1162-2. I don't have the exact count in my head.
How about after 1162, just on January 29th, going into January 30th?
There were other events.
How many?
I don't recall the exact number.
Does 11 sound right?
That it sounds plausible. I recall seeing in the chart. I recall seeing a number of events after.
Would it refresh your recollection to look at a chart?
It would. Thank you. Yeah, there are a lot. I would have to really use my finger to count them all.
Okay, more than 8,
Total after 1162-2,
only on the 29th.
there aren't date stamps on these because this chart is the raw text stream data, which doesn't have timestamps.
Safe to say, there are many.
Well, oh, I wish Jackson played that. I wish Jackson landed on that heavier. I wish he landed on that heavier because that was a point that DeSogra was trying to make when Brennan was doing his cross, that the text stream lists do not just they come with a timestamp, sure, but the correct timestamp of when in truth, in reality, in real IRL time, those happened doesn't exist. It has to be like composed. Like you have to find it. And so I wish Jackson was like, right. So you have to find out the times. You have to figure that out. You have to do the science to figure that out. Like you were trying to say in cross-examination.
Extreme data, which doesn't have timestamps.
Safe to say, there are many, right?
Yes.
May I approach?
Yes.
Oh, I wish
And
he
again,
landed
this goes
harder
back to
on
the
it.
question that you were asked by Mr. Brennan. I want to follow up on,
Like, yes, don't
no
come with
instance
timestamps.
or any of
You have
those
to figure the
related
timestamps
to a
out.
collision,
True time.
to your knowledge, correct?
Objection.
Sustained.
Or any of those that you reviewed at any time, the lifetime of the vehicle, related to a collision.
None of them were
No.
triggered by a collision.
Thank you.
No.
I want to ask you a hypothetical, if I could, based on questioning by Mr. Brennan surrounding the 12/32/09 lock event. Do you remember him asking you about those questions, about that event?
Yes.
Your analysis was based on the time span. Let me rephrase that. Was your analysis based on Mr. Burgess's and Mr. Welcher's analyses together of a span of time between the 1162-2 text stream event or trigger event and the lock event at 12/32/09?
Objection.
So the question is that what he's considering?
Correct. In other words, was he basing his opinion or analysis on that time frame, at least in part?
So I'll let that question stand.
Thank you.
Yes.
Okay. If you were told,
Yeah, Burgess couldn't say there was a collision either. He's not denying there was a collision. Right. So no one's saying there's no data. The text stream doesn't say that. I don't think that's what the jury heard, to be fair. At least that's not what I heard. That when it comes to the collision and the data, there was no data. And I think that's what everyone's been saying. Has it not? I think that's everyone. There was no collision event triggered. Unless, I mean, I don't think I'm necessarily that confused. I don't think that was
that there was another
too much.
interaction.
So if Brennan got him to say that, it's going to be cleared up immediately, which is what Alan Jackson is doing. He literally just did. That no text stream data was triggered by a collision because text stream data doesn't get triggered by collisions. That's different data.
Phone event.
I think
on
he made
John
that.
Q's phone
In my
at
opinion, I think he made that pretty
12/32/16
clear.
in the form of steps taken, 36 steps over the course of 83 feet. Would that change your analysis or opinion in any way?
Objection.
I'll allow that in that form.
Yes.
In what way?
If the phone event moves from 12/32/09 to 12/32/16, then of the 30 possibilities I had in the chart, all of them would become positive. That would mean that interaction occurs after the end of the vehicle event every single time. Instead of, it was 25 for 30 in the original analysis, the hypothetical would change it to 30 for 30.
All of them, all 30 of them would occur at a point in time. Let me rephrase that. All of them would reflect a scenario in which the phone interaction took place after the trigger event. What's that?
That's correct.
Thank you. If you were told,
Now, a clarity that the jurors need to remember is that the trigger event is the reason the data starts being recorded to the SD card. Trigger event is the literal event, either the hard acceleration, the key on, key off, what have you, like whatever the trigger event is, that's the reason that you have the text stream. So I hope that they are able to go into deliberation knowing that. So when they see end of text stream and trigger event, they're not expecting those two things to be the same thing when they do their own sort of mathing of the math, if they even go about and do the
I'll give
math.
you another hypothetical. If you were told that there was a Doppler state event on the phone, pocket state event on the phone at 12:33:14,
Does he know what pocket state means?
would that impact your opinion in any way?
Objection.
Sustained.
You were asked several questions about what you believed Mr. Burgess may have gotten wrong in terms of his original report and one of his original analyses dealing with bits and bytes. Do you recall that?
Yes.
Did Mr. Burgess,
Hold on.
of course,
You need to, we have to turn the fans off.
and I'm not speaking loud enough.
Right.
I'm sorry. I'll raise my voice. I just don't want to scream over people, but I will raise my voice.
Let's try this for a few minutes.
May I start again?
That question, yes.
Thank you.
I really wish that maybe the courthouse, they have plenty of money. Apparently, they have money. Could they maybe invest into a cooling system that does not sound like a fighter jet taking off inside of the smallest room known to man? That could be really interesting if they did that, if they invested into something that could keep humans not sweltering, but also not be so loud that you can't hear shit. That would be super cool.
You were asked about whether or not you believed that Mr. Burgess was incorrect in terms of certain analyses he undertook or reflected in his original report back in January of 2025, correct?
Correct.
As it relates to the bits and bytes, did you find that Mr. Burgess was incorrect or correct about his analysis concerning the size of the data set collected based on bits versus bytes?
He was incorrect.
Explain that to the jurors very briefly.
These are just different units. A bit is a different size than a byte. And so if a size for something is listed in bits, for example, and you look at the data and assume it's in bytes, you will assume it's the wrong size.
Which Mr. Burgess did based on your review of his report, correct?
Correct.
I want to change gears and ask a different question or series of questions about the text stream data versus the infotainment system data, specifically the timestamps associated therewith. Is there a timestamp associated with text stream data?
In this case, no.
Okay. Is there a timestamp associated with infotainment system data?
Yes.
All right. The infotainment system data, well, let me see if I can ask it a different way. Where did the 3-second delay come from? Your analysis of Mr. Burgess's review of the text stream data or his review of the infotainment system data?
The 3 seconds came, well, fundamentally it came from the exemplar testing where he identified, and he was actually, well, Aperture collectively in that testing identified a difference between when the button was pushed and the time that showed up in the infotainment. But they didn't actually look at, as far as I know, or at least it wasn't provided if they did, how that specifically related to the key on timer itself. But they showed that the button is pushed, there's a 3-second delay, and then the time gets logged.
When that button is pushed for the infotainment system, I'm going to rephrase again, so I'm as clear as I can be. When that button is pushed for the on event, the key on event, is that like a stopwatch click? A stopwatch starts running? Timer?
In the VCH system, yes.
Okay. Separate and apart from the VCH system, is there an infotainment system that also has a timer or a clock on it?
Has a clock,
Are those two things independent of one another?
completely independent.
What were you doing with regard to the 3-second delay as it relates to the key on event and the infotainment system event to marry those two things together?
Right. I'm making the adjustment, or proposing that adjustment can be made, because the key on timer is going to start generally as soon as the vehicle powers on. But the infotainment, when you go and download the data, it will say, hey, I think I powered on at this time, and it turns out that time is actually 3 seconds off. So if you're going to then apply the infotainment time anywhere else to VCH data, you've got to realign the two. And that's where the 3 seconds comes from.
And all this really just makes me want to go get an old car. I don't want to drive a newer make and model car. I just want an old car again. I want an old car. I am so grateful that the car that we have has a key. I don't want a car that doesn't have a key. I don't want a car where you hit a button. I want a car with a key. I also want a car that doesn't have 18,000 SD cards in it. That's what I want. I don't want a car that has 18,000 SD cards in it. Not because I want to commit a crime, but like, stop tracking me. Stop gathering my data. Now, the only time the data is being used is something, for the most part, something like this, an accident, things like that. But stop gathering my data. Oh, good thing I paused, because my internet just decided to, I don't know, die. My internet just collapsed on itself. What the ever living hell is going on? It's actively against me. It's actively against me. The internet, SD cards, the infotainment in the internet, also hate me.
These are independent data sources.
Did Mr. Burgess, to your review of his, insofar as your review of his analysis, his report is concerned, did he align the two vis-a-vis the 3-second delay?
No, he did not.
Thank you. With the court's permission, may we have slide 10 of the PowerPoint of,
Okay.
and that is, we've talked a lot about PowerPoints of Mr. DeSogra's PowerPoint. Can you highlight the?
I know we've seen it probably like twice
table
now. I'd
on the
love to
left,
see it
Mr.
for
Thank
again.
you. Did you create this table?
No,
Was this table, I don't know if you call it cut and paste or if there's some better engineering term for it, was it basically pulled from Mr. Burgess's report?
it was. It was a
Did you type-
screenshot. It was a
Burgess-
screenshot.
Thank you.
Perfect place to
Screenshot.
copy and
Did you
paste
type
too.
a single word on this?
I did not. I added a green box.
Put a green box around it.
Yes,
You didn't type anything on this.
I did not.
You were asked a ton of questions just a few minutes ago about whether or not the column on the left and the center column were reflective of an infotainment timestamp versus an iPhone to iPhone timestamp, correct?
That's right.
Mr. Brennan asked you a bunch of questions about that left column being an iPhone timestamp, at least the top 5 rows of it. 1, 2, 3, 4, 5 rows of it. Remember that?
Yes.
Read the name that Mr. Burgess labeled that column.
Infotainment call timestamps.
So what, as an expert, what did you presume he, as an expert, was presuming?
Objection.
Sustained.
What did you presume that meant to you, just to you?
Call timestamps from the infotainment.
So if anything is wrong with your analysis, would it be based on Mr. Burgess being wrong in his analysis?
Objection.
Sustained.
Come on, Jackson. You got this.
May I have just a moment, Your Honor?
Sure. Do you need the light on?
I don't. And we can pull that down.
So you do want the
What
light on?
was your entire analysis predicated on?
He thought she said, do you need a light off?
What was it based on? The foundation of it, as you explained your analysis to this jury during the course of the day.
The testing by Aperture and the collective reports and PowerPoint presentations by Aperture. That would be an initial report by Mr. Burgess, an initial PowerPoint by Dr. Welcher, and a supplemental report by Mr. Burgess.
Did you change any of their data?
No,
Did you change any of their analyses?
no,
Did you explain their analyses?
yes.
Sustained. Ask it to.
Sure. What were you trying to do in terms of your presentation, in your PowerPoint, and your presentation to this jury?
There were a number of different methodologies presented across all of those reports and PowerPoints, and sort of all in different places. So my goal was to bring all of them into one place so we could look at the totality of the data.
I too want Alan Jackson to be in front of the microphone. I don't know why they started to be all walky around lawyers now. Oh, I know that they want to get close because the fan is on. That's why I do. Okay, I do know. They want to get a little closer to the court reporter because of the fan. They want to get a little closer to the witness because of the fan. They want to be heard. The microphone does not project them through the courtroom, which I think it should, because hello, I mean, if we have a fan that's projected through the courtroom, can we have them projected through the courtroom so we can hear them over the fan? But the tech is neither here nor there. But it still makes me want them to be in front of the microphone because I want to hear them, because I am greedy and I am selfish.
You were asked whether the genesis of your analysis relies on knowing the source of the calls, correct? You remember being asked that by Mr. Brennan?
Yes,
The actual genesis of your entire opinion is based on Mr. Burgess's and Mr. Welcher's analyses, correct?
that's correct.
You were also asked why you believed Mr. Burgess did a quote unquote more detailed report.
And are you friends after?
I'm sorry. Who the hell do you think you are? I was writing a note. I was taking notes. That was them. I don't remember where we were.
Burgess may have gotten wrong in terms of his original report and one of his original analyses dealing with bits and bytes. Do you recall that? Or a clock on.
As a clock.
Are those two things independent? Mr. Brennan asked you about Welcher's analyses, correct?
Here we are.
That's correct.
Also, one of the downsides of watching court when it is live, as it is still live, random wild things happen to the stream.
You were also asked
I hate that. It's so annoying.
why you believed Mr. Burgess did a quote unquote more detailed report in May versus January of 2025. Do you remember being asked that just a few minutes ago?
Yes,
When you presented your analysis, your math, based on Mr. Burgess's January 2025 report, how many of the scenarios indicated, based on his data and his analysis, that the lock event occurred after the
All of them.
Thank you. That's all I have, Your Honor.
All right, Mr. Brennan.
Recross. Brennan gets the last word now. Commonwealth gets the last
So,
word
Mr.
now.
DeSorga, this
defense chief.
demonstrates the danger.
What did he call
So,
him?
Mr. DeSorga, this
What did you say? DeSorga? Dude, I at this point, I think Brennan does it on purpose. Like I have to be on the Brennan does it on purpose, and he just keeps getting away with it. It's DeSogra. It's Alessi, not Alisi.
So, Mr. DeSorga, this demonstrates the danger or the difficulty.
Hold on.
This is a speech, not a
Start,
question.
start the
It's
question
cross-examination.
differently.
It is, it has to be a question.
Start. Go ahead, Mr. Brennan.
This
Ooh, they're
demonstrates
fighting.
the difficulty.
They're fighting. Did you hear it? Ah! Let's go back. Let's go back to DeSorga. Sorry, we went way back.
All of them.
Thank you. That's all I have, Your Honor.
All right, Mr. Brennan.
So, Mr. DeSorga, this demonstrates the danger or the difficulty.
Hold on.
This is a speech,
Start,
not a question.
start the
It's
question
cross-examination.
differently.
It is, it has to be a question.
Start. Go ahead, Mr. Brennan.
This demonstrates
Oh, Jackson is pissed. Jackson is pissed because he has seen every single comment that Brennan has made, and he has not been admonished in front of the jury. He is pissed. He's pissed. And now that Brennan gets to sort of play defense attorney, he's doing the cross. He can ask these direct questions. And he can ask these yes or no questions. He can get down and dirty. Jackson's like, we're equal now, motherfucker. Welcome to the baseball field, like welcome. By the way, this is my town. It ain't big. This city ain't big enough for the two of us type shit. And Alan Jackson's like, I just want to go back to LA. But whoa, they are literally bantering in front of the jury in open court with a witness, and Judge Beverly Cannoni was just like, guys, stop. I hate it when you fight. I hate it when you fight in front of me, Oh my God, stop. Guys, stop. Don't do that. What is even happening?
So, Mr. DeSorga, this demonstrates the danger or the difficulty.
Hold on.
This is a speech, not a
Start,
question.
start the
It's
question
cross-examination.
differently.
Alan Jackson said, objection. Brennan kept going, objection. She's saying, hold on. Jackson says, this is a speech, not a question. And Brennan says it's cross-examination.
It is, it has to be a question.
Start.
And then Jackson says, it is, but asking a question or ask a question, something of that sort.
Go ahead, Mr. Brennan.
This demonstrates the difficulty
He's
in giving
pissed.
opinions when you don't actually study the data itself. Isn't that fair to say?
What are you referring to with this?
Well, you're giving opinions, but you can't verify any of the data because you're not relying on your study of the data, are you?
I'm relying on expert reports.
You're criticizing somebody's report, but you yourself can't defend data that you haven't actually analyzed and broken down yourself.
I don't think that's true.
So is a surgeon, like this is maybe a terrible analogy, but it popped into my brain. So is a surgeon not allowed to do a surgery because they didn't discover the surgery? Like they weren't the first one to do it. They studied how to do it, and they have the history of being a surgeon. Is that that's
When
probably,
you're
it's probably
looking
terrible.
at-
Ignore it. Ignore it.
When you're looking at someone's report, you're guessing as to what they thought or presumed if you haven't spoken to them. Fair?
I would say I'm reading the words that are in front of me and interpreting them for what they say.
When someone plugs their iPhone into a car after it turns on, and the car reads data that's on the iPhone, that data then resides on the infotainment system, correct?
There's a transfer of data.
And
Yes.
so unless you actually do the study yourself, you had no way of knowing if that information, although on the iPhone, on the infotainment system, you had no idea whether it was from an
Can we
iPhone.
talk about phones and redirect?
Fair?
That's right. I don't think that's,
And so when you
No.
don't actually do the work yourself, and you just presume, or you guess, you could get it wrong, couldn't you?
if I had guessed, yes, but I didn't guess. I used the data in the reports and I referenced the testing that Aperture did. So I did not make a guess.
1 through 5, and you telling me right now, to a reasonable degree of data certainty, that that information is based on the infotainment clock, is that what you're saying?
I don't know.
You don't
I
know.
think Brennan is locking himself in a very narrow, small corner, trying to pin him against this specific stuff. I think it's a little too narrow for it. I think sticking to, you read all of the things. You didn't do anything. You pulled out your little calculator and used your little brain and you found alleged errors. Cool. I think that works. When it comes down to, well, let's come down to this one specific column in this one specific table that Hank Brennan, your guy, made, and said, what if it was something else? Everything could be wrong, right? I don't think that's a good look for you. I think there's too much opportunity. There's too much liability for you, Hank Brennan, and your expert witnesses when it comes to that. I think a broader, you didn't do shit, and now you're telling me the guys that did the shit are wrong. I think that is good. I think that is good. But I think narrowing it down and whittling it down to, well, if this is, I don't think the jury is going, I don't think it hits as hard. I think it hits bigger if it's like, but you didn't do anything other than pull out your little stupid calculator. I think a little too narrow is it's a little dangerous. I think it's risky. It's risky, and he seems to be willing to take that risk. And I think he might be willing to take that risk because of how messy, sloshy, sludgy, icky, hard, tough, sweaty, red, might not have a job anymore. Burgess happened on the stand, I think he's just ready to take that risk, but I don't think he should. I think it's too small. I think the broad is
But
good.
you
The broad is
actually
good.
did the analysis yourself rather than just Monday morning quarterback and somebody's report.
Objection.
So I'm going to strike it, ask it differently, Mr.
You
Brown.
actually did the
And
analysis.
admonish him. You would admonish Alan Jackson, Yannetti, Alessi. You would. Yes, you would. Alessi would take it like a champ and he'd be like, oh, of course, Your Honor. Oh, of course. Alan Jackson would be like, Your Honor. Blah, blah, blah. And Yannetti would be like, no, yeah, of course. Okay. It'd be like, sure, okay, whatever. I'll do what I want type of energy. That was a terrible Yannetti impression. Please forgive me. Let me just go back. I want
The
to hear.
analysis yourself rather than just Monday morning quarterback and somebody's report.
Objection.
So I'm going to strike it, ask it differently, Mr.
You
Brown.
actually did the analysis yourself. You wouldn't have to make a presumption that you'd be wrong, correct?
I don't think the analysis was possible in this case because the testing wasn't done in this case.
You don't know if the testing was done or not. You didn't do the
Objection,
testing.
Your Honor.
So I need to hear the question.
You don't know if the testing was done or not, do you?
I know it's in the reports. The testing wasn't in the reports.
Did you read Jessica Hyde's report?
No,
Did you read Ian Whitten's report?
no,
You don't know if that testing was done, do you?
I don't.
Objection, Your Honor.
I'm going to let that stand.
You don't
Next.
I do not, sir.
And so if you're wrong, your assumptions and product are then wrong.
Part of my conclusions would change. I wouldn't agree that I'm wholesale wrong.
Well, as a scientist, if they're not accurate, that would be wrong, wouldn't it?
Well,
That might be a nuanced answer.
well, Brennan, Burgess's answers aren't accurate. They fall in a range as well. So his high range, his low range, his mid range could all be wrong. It could fall in the mid high range. Like it could all be wrong.
Answer.
I'm
So
sorry?
I said that might be a nuanced answer. Frankly, I'm not sure how to give you a good answer to that
If you
question.
have the wrong data when you're doing your analysis, then the final analysis is going to be wrong. If you have using the wrong data, it's that simple.
Yes.
Right?
And then the jury is going to go, did Burgess and whatever the other guy's name is that I literally just forgot. I want to say Wolf, but it's not. My God, what is his name? Welcher. Did Burgess and Welcher use the wrong data? Because that's the power that this witness has. That's why Alan Jackson and Mr. Yannetti and Alessi did this with this witness. They said, I'm going to get somebody who is just going to analyze. They're not going to touch anything. They're not going to touch anything. Not going to touch anything. And Brennan's going to say, but you didn't do anything, but you didn't do anything. And all this could be wrong if you had this information wrong. And the jury's going to go, okay, but the information came from you, your guys. So was the information wrong? So that's like they're stuck in like a secular questioning. If it's not wrong, then how wrong is this guy? And then if he is that wrong, well, how is he that wrong? Because he's using the information that came from you. So it's like it's circular, it's cyclical.
You
I'm
don't
gonna
have to be a
pop that
scientist
too.
to figure that out.
Yes. That's
Okay.
Wow.
If we could have Mr. Welcher's 33.
He did not like that question. This guy, what Desogra, he's very much done. I would like you to watch his face. This is a fun thing. So we're only at 1.25 speed, but you can see the body language a little bit better and get like a real-time feel for body language, especially on the sound when we are actually fully live. So let's
Wrong.
just
If you have using the wrong data, it's that simple.
Yes.
Right? You don't have to be a scientist to figure that out.
Yes. That's
Okay. If we could have Mr. Welcher's 33.
this guy's like, I need a drink. This guy needs a drink. Desogra needs a drink. That facial, the eye turn, the exhale, oh my gosh, he is so over Brennan right now. He's so over Brennan. And he's like, I'm getting paid for this. I'm getting paid for this. Don't forget. Paycheck.
You could open that, please. You were asked about whether the window is within the time frame of 12/32/09, the last user interaction with the phone. When you look at this data, could you go to the top, please? You see on vehicle speed, the car is moving. You see that? Could you enlarge that a little bit, please? The beginning of that data capture, the car's already moving, correct?
I see vehicle speeds right in those first couple of lines. Yes.
Yes?
Yes, I see
Yes.
vehicle speed.
If you go to the bottom, at the end, the car is still moving. Yes?
I see vehicle speeds there as well.
2361. That would indicate, in your experience with text stream data, the car is still moving. Yes?
At the end of the record, there is a vehicle speed. The car is moving. That would be my assumption.
Okay. And so when you're making your conclusions that something's with or without, you're simply talking about the time of the 10 seconds of data. Yes?
Yeah, everything that I've done has been referencing the end of event 1162-2, which is exactly how it's been referenced in all of the other reports.
That 10-second window. Yes?
Not even the window, just the end. Everything in the Aperture reports talks about the end of event 1162-2. So that's what I used across everything.
And when you say end of event, you're referring just to data, not the actual real life event.
Yeah, absolutely. The end of the recording.
Okay.
Mhm.
And so after that window, 12/32/04 to 12/32/12, you were asked a question about what might have happened 4 seconds later, 12/32/16. Remember you were asked about that?
Yes.
Did you know at 12/32/16 that John O'Keefe's cell phone moved for the last time? Did you know that?
No.
In between 12/32/12, which is in the 10-second window, and 12/32/16, do you know what John O'Keefe was doing in that 4-second period?
No.
Do you know if he was walking?
No.
Do you know if he was crawling?
No.
Do you know if he was falling?
No,
You don't know.
I do not know.
I wish he got a snide remark in and was like, I don't know, do you? That would have been me. That would have been me. That's why I could never, I don't, nope, never put me on the stand. I will never be, I will not be, I will not, no. Because if I was this guy, if we had swapped bodies Freaky Friday style, I would have said, I don't, do you? And I probably would have gotten in trouble and I would have been okay with that. But that would have been really interesting. But this is how it ends.
Falling.
No,
You don't know.
I do not know.
Okay,
Oh,
12/32/16.
redirect, redirect.
I didn't review the phone data, so I don't know.
Did you review anything to indicate that steps were taken in the course of the review?
Objection.
so that's sustained.
You were asked just a second ago. What about the data? What's wrong? Then you'd be wrong, correct?
Generally, yes.
Garbage in, garbage out. Basic scientific postulate, correct?
Generally, yes.
You're relying on whose data?
Mr. Burgess's data and Dr. Welcher's data.
Thank you.
All right, Mr. DeSoger, you are all
Garbage
set,
in,
sir.
garbage
Step
out.
down. I'm going to see counsel for a minute. Jurors, feel free to stand up and stretch if you'd like.
And I think that is it's a great final sort of like stance that it really, I think this witness was good for both sides. I think this witness was better for the defense. I think there was some moments that may stick with the jury from Brennan's cross-examination, but I think in the grand finale of it all,
We did that to have me decide whether I'm going to let you go now or not, and I'm going to let you go. So that 5 minutes, that just means that you get to go home, because we know we'll be longer, we don't want to do this to you, okay? So we'll break for the day. I have to give you those same cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation about the case. Please disregard it and let us know. The additional caution will be a full day. And we'll see
just say Monday will
right
be.
around 9 on Monday morning. So we'll see you then. Have a great evening.
Please rise to the jury.
All right. They are going to do a voir dire. Do we want to watch it? I mean, we're here. It's only going to be like, because it jumped. I know that they're going to.
Do you mind, sir, if you just
Yeah, we're watching this. Oh, hell yeah, we're watching this. Oh, hell yeah, we're watching this. Come on. Golly.
You are unmuted.
All right. So what is a voir dire? A voir dire is time for questions of a witness. The jury is gone. The jury is not here. This is outside the jury's presence, meaning that this is really just for both sides, defense, prosecution, and Judge Cannoni to see what is admissible and what is inadmissible, where they want to go with these questions, where they want to go with this witness, how far they're willing to go, how far they are allowed to go. And so it's basically a test of waters. They get to skip a lot of the things and just kind of get down to the point of it.
So you gotta step up, take the question, raise your right hand.
You solemnly swear the evidence you give the court in the case now and hearing the truth, the whole truth, and nothing but the truth, so help you God. Thanks, you take the stand.
Thank you.
I know this is a really good opportunity. There is a witness outside.
Sure. Is she right outside the door?
Last time I checked.
Do you mind, sir? If you can stay right there.
Sure.
It'll just be a few minutes, okay? Ms. Gianetti, when do you need this witness back? Monday? Need her at a microphone. Do you have one on council table there? So the podium, or one of those back where Eugenia is. Thank you.
Thank you so much.
Hi, good afternoon.
Hello,
Could you tell me your name, please?
Kelly Dever.
And Ms. Dever, you've been summoned here. I think I saw you earlier. You've been here all day.
Yes,
All right. So we're not going to reach you today, unfortunately, but you were summoned to be here.
Yes.
All right, so that summons is still good until we reach you. So you're going to have to come back Monday morning, okay?
Yes, ma'am.
Do you agree to do so?
Yes, ma'am.
Okay, thank you very much. We'll see you Monday morning. Be here before 9, okay?
Will do.
All right, thank you very much.
Thank you, Your Honor.
Go ahead, Mr. Alessi. Oh, she's seen Eddie.
Oh,
That was a
she's like,
big compliment, Your Honor. Thank you. Good afternoon, sir. Would you please state your name and spell
wait, that
your
was
last name?
so sweet.
Go ahead, Mr. Alessi. Oh, she's seen Eddie.
That was a big compliment, Your Honor. Thank you.
So she said, okay, go whenever you're ready, Mr. Alessi. And he said, I'm Yannetti, actually. And then goes, that was a big compliment, Your Honor. And I swear there is so much love in between the defense. It's got to be absolutely insane. Like there's got to be so much. They love each other so much. But yes, let's listen to this. Let's listen to this voir dire. Once my internet decides to not hate me, I don't know what it is. Honestly, maybe I shouldn't stream for a week so this internet can figure out that it's not wrong to work. It's okay to work. It's fine. It's fine to work. Okay, looks like it's good now.
Good afternoon, sir. Would you please state your name and spell your last name?
Jonathan Diamandis, Diamandis.
You've also been here all day.
Yes,
Sorry for making you wait.
no problem.
Do you know former State Trooper Michael Proctor?
I do.
How do you know him?
I've known him since middle school, probably the 6th grade.
Grew up with him, essentially?
Grew up with him, been friends for 30 years.
Okay, and if you just keep your voice up,
Sure, yeah.
I'm sure other people can hear you, but this
So
old
can
guy.
we turn off the fans and the air conditioning? Are they all off? We're just going to do that so that we can get through this a little bit.
Absolutely, sure.
Much better, thank you. So you say you've known him since middle school, elementary school?
Yes,
Graduated high school with him?
yes,
And are you friends after high school as well?
yes,
Do you have his cell phone number in your phone?
I do.
Have you texted with him over the years?
I have.
In fact, were you on a group text chain with him that lasted a number of years?
Yes,
I would like to show you a document, sir, and I'm going to ask you to read it to yourself, familiarize yourself with it, and then when you're done, look up at me. Okay,
Okay.
may I approach?
Yes.
Oh. Hey, Aggie, what is going
Do you want
on?
this mark for identification first, Your Honor?
Yes.
We are currently in voir dire of Jonathan Diamandis, who appears to be a 30-year-long friend of Michael Proctor. So the jury's out. I mean, obviously, you know. Obviously, you know, of voir dire. So we just did the full day.
And for identification.
Jury has went home, and now we're doing this quick voir dire to end out the day. And I am
Thank you.
very interested to see what the heck is going on. He's looking right now at a group chat that he was a part of with Michael Proctor, and he's familiarizing himself with it. Ooh. I can understand why her face might be facing right now. It's been a wild day. Just skedaddle through him reading this. Lots of energy today, shall I? Lots of energy. Yeah. Oh. Okay. He's read
I think
it.
he's all set, Mr. Union.
Thank you, Your Honor. Sir, have you reviewed that entire document?
yes,
Does that look
Yes.
familiar to you?
yes.
Yes,
What
I
do you
did.
recognize it to be?
It looks to be a text chain with a group of my friends that I grew up with.
Okay. And so would
Text chain, not tech stream. This has been a problem for me since beginning, is the way Brennan says things. So during all of these expert witnesses, the last couple ones that we had, tech stream, not text stream. It very much sounds like text stream to the point where the closed captioning even says text stream. It's tech, TECH stream, and this here is a text chain, which I'm pretty sure Brennan will call an email.
all of those friends have been people that you went to high school with?
Not all the same high school, but the same time. Some of us went to different schools.
And you were friends during that era?
Yes.
And you've remained friends for how many years since then?
I mean, we've been friends for 30 plus years, probably.
Do you know precisely when that text chain started?
I do not know when the text chain started.
Months, years?
Years. Definitely years.
And that's a portion, in other words, there's a start time and an end time to that, but the text chain started before the start time that's listed on that document?
That's correct.
Now, I'd like to ask you about 5 different categories of information that allow you to identify the text chain. First of all, directing your attention to page 1. That is an unredacted version of this. Do you see your phone number on page 1?
I do.
And is that accurate in terms of your phone number?
It is.
Well, do you have a passcode on your phone?
On my phone, yes, I do.
All right, and have you had that for years?
Yes,
So as of January
six
2022,
digits?
you would have had a passcode to get into your phone, correct?
correct.
With regard to the
Make your passcodes more than 4
typing
digits.
of text messages, you didn't appear to be too active on this thread, is that correct?
Not from what I see here.
Did you see one entry that you actually did text?
Yes, one.
Okay, and I think these page numbers, they're all numbered. Could you direct us to the page where you actually chimed in?
One entry. You mean one text
And if I
message?
suggested to you, it might be 4 from the end. And you don't have to read the actual text, sir. I just want to.
Sure. I'm just trying to locate it. Yes, I see it.
Okay, and the time of that, a date and time of that text as it's reflected on this document?
February 2nd, 2022, 12:38 p.m.
Okay, and what you
So I
type.
have a different copy.
Oh, I'm sorry. It's for the record. It's on page.
What's the
Oh.
whole page numbers? The last 2 digits.
And for the record, reading what is typed there, does that sound consistent with something you might chime in a text message, a text chain of this sort?
I mean, it could be. I have no memory of actually typing it, but
Sure.
that's not something. I mean, it could have been something that I would say. Yeah.
At the very last line of that text, do you mention somebody's?
But we can admire this man's hairline. That ain't budging. That's a tight hairline. He's keeping that forever. He's keeping those hairs on his head for life. Because if it was gonna move, it would move by now. Congratulations, sir. You have to congratulate people sometimes. You know, you may not like them, you may love them, you may hate them, you may not even know them. But like, if you like something, say it out loud. Great hairline.
Nickname.
Yes.
And what nickname is that?
Chip.
And whom do you know as Chip?
Michael Proctor.
Gross.
Now, going back to the first page, there are a number of other phone numbers
Wait,
there.
is that gross? Wait, can we talk about nicknames? Do you guys have nicknames for people in your adult lives? I guess I do. I call Vicky Vic, but like that's just like that's just a shortened form of her name. I call Raylene Ray. There's just a shortened version of their name. Do you have like a nickname? Like if I was called Victoria, I can't think of anything. My brain just said Berm. I like Alessi. Sexiest brain ever. That's fair. That's fair. Who needs a hairline? Oh, he's got a great hairline. He's got a great hairline. I know. He's got a good hairline. It's not as good as this guy's though. We have to. All right. Let's continue. I gotta pee. Let's continue.
Have you checked your phone prior to taking the stand today to match those phone numbers with other friends of yours?
Yes.
And if you could, and hopefully you remember them all, can you list by first name only your friends who are included in this text chain?
Sure.
Yeah. So let's not, if he recognizes, I don't want to put names out.
Oh,
there.
I don't either, Judge. That's why I was saying first names. But if that's sufficient that he recognizes,
Why don't you refer to the last 2 digits in the phone?
sure.
Is that acceptable, Mr. Brennan?
It is.
Okay.
Okay. You see, I'll list the last 2 digits of the phone numbers that don't have a name associated with them. Okay?
Okay.
If I may just have a moment.
Great, Aggie. Now I want a cookie and to go be with my cat. I would love a cookie. I don't think would ever say no to a cookie.
Okay, starting
What's
with
your guys' favorite type of cookie?
the phone number that ends in 51. After you checked your contacts, is that a friend of yours
Yes, it is.
who was on the text chain?
Correct.
With regard to the phone number that ends in 68, same question. Is that a friend of yours who was on the text chain?
Correct.
And with regard to 4-5, which is the next one, again, a friend of yours who was on the text chain?
That's me.
Oh, I'm sorry, that is you,
Yeah.
of course. With regard to 9-5, is that a friend of yours who was on the text chain?
Yes, it is.
And with regard to 9-3, same question, friend of yours on the text chain?
Yes.
And then there are 3 numbers there, one that ends in 11, one that ends in 46, and one that ends in 82. Do you see that those particular numbers have a nickname associated with them?
Yes.
Those nicknames, do you recognize them as being also friends of yours who are on the text chain?
I do.
And then finally, there is somebody listed as local user. We'll get back to that one.
Okay.
With regard to the other ones that you've just identified, sir, have you texted
coconut,
back and forth
interesting.
with them on those phone numbers over the years?
Yes.
And also with regard to this particular text thread?
Yes.
All right.
I'm a big fan
Now-
of like an oatmeal raisin.
I'd also ask you, with regard to the content of these messages and who said what.
I want to know
and
what
particularly
I want to know what they're
focusing
about.
on the one that's identified as local user. Having read that text chain, were you able to determine who local user is?
Yes.
And who is that?
Michael Proctor.
And was that by the content of the messages that Michael Proctor typed that you recognized it?
Yes.
Because
And
he's the nastiest one out of all
with
of them.
regard to
Maybe.
whether this is a
Allegation?
complete, accurate record of what it purports to be, what is your testimony in that regard?
I believe this to be a record of our text chain for this period of time.
Appears to be accurate and complete.
It does.
If I may have a moment, Your Honor.
Okay.
I like Yannetti. Oatmeal is second fave. I love an oatmeal raisin. I like a molasses, like a deep spiced.
Does the text
full of
message
flavor
chain
cookie?
you read fairly and accurately represent the circumstances of the conversation that was going on?
Yes.
Nothing further.
Mr. Brennan?
Good morning.
Good morning. Good afternoon.
Do you have an independent memory of any of the text conversations in the package that you reviewed?
I do not have a memory of this happening.
Thank you.
Nothing on that.
All right, so sir, I'm going to ask you to, you're all set.
Okay.
I'm going to ask you to step down.
Okay. Thank you.
You're right, given that unfortunately this witness was not reached by the jury today, I would like him recognized as well.
He has counsel here with him, right? Does he have counsel here with him? All right, sir, you'll make sure your client is here when we need him?
I will do so, Your Honor.
All right, thank you.
My name is Thomas Campbell. My office is in Boston.
And I'll speak with Mr. Campbell in terms of an appropriate time of day. He's been very cooperative.
All right. So sir, you can leave,
Thank you.
all right? And thank you, Mr. Campbell. We'll see you. We'll let you know when we need you back. It's probably going to be Monday first thing.
Understood.
Thank you.
Sir, watch your step coming down.
This is very interesting. I love watching the
All right.
behind the scenes, and I really
Okay,
wish
so
that
you
a
guys-
lot more would be handled in open court than at sidebars, especially when the jury isn't present. I understand why it's not. Her acknowledgement of the cameras and audio at all times is fair, but I really would like to hear, especially someone who is super interested in the process. I would really love to hear some of these sidebars that are happening while the jury isn't there in open court. I want to hear them argue. I want that information. Now, here we don't really watch too much stuff that is outside of the jury's presence. There were a bunch of voir dires that I did not play. I went over because for the most part we just take in as a group, as a hangout. We take in what the jury's seeing. I want to go off of as much specifically like drawn down to what the jury knows, but it's impossible for me to not know more. But it is what it is. Stop, my mouth is watering now for a cookie and some milk, like some costly Santa here. So funny. I bet you would do better than Brennan's paralegal. She's sitting in the courtroom every day. Is that this person? Because I know that this is the longer, like blonde, lighter haired woman. I can never remember. McLaughlin? Is it? It's not McLaughlin. That was the paramedic. EMT firefighter, but I think it's her with the darker hair. I think that's Brennan's paralegal who probably works in the DA's office. I'm not sure. Maybe he might have brought over some assistance from his defense place. Oh God, it's about that time of day where the words don't work no more. Oh, she's behind Karen's parents. I bet you would do better than Brennan's paralegal. She's sitting in the courtroom every day. Now I need to know who. Now I need to know who. Now you know I need to know who. Who is Brennan's paralegal? His personal paralegal. That's very interesting. Oh, is it her right behind me? Oh, damn. Damn, Maggie. Yes, because Brennan has his own office. Right, this one. Oh, very interesting. That's very interesting that she's sitting right behind them. I wonder, I mean, they must know. That's very interesting. Because Brennan is playing special prosecutor. He is a defense attorney through and through. He has his own, what is it called when lawyers have their own thing? My brain stopped working. But he's a defense attorney. So, damn, Aggie is throwing the shade. Just batting practice, throwing the shade. And so he's being paid, I think it was like $250,000. I mean, he took almost like a full year from between trial number 1, trial number 2, all the time it takes to try the case. So I'm sure that he probably did take someone with him for assistance, because recognizing that the district attorney's office did not handle it quite well the first time, I'm sure he wanted, damn, Aggie, that's crazy.
Stephanie Downs.
Well, I'm going to have to do some digging now.
All right.
Let's
Okay,
see what
Mr.
they are arguing now.
I want to hear you as to why this is admissible.
Argue the admissibility of this witness. And I'm sure like the main point of admissibility is just going to be, hey, look, this goes to Proctor's longstanding character. I don't know what those text messages were, but I'm going to go out on a limb and say, it was not good. Proctor, to his work, his coworkers, to his peers, was nasty and depraved. I could only imagine how he speaks to and with his friends. And if this, let me make sure I say his name correctly, because he does deserve that. Brennan does not understand that concept. Diamandis, if Mr. Diamandis gets on the stand, I wonder how the friendship between him and Proctor has existed since last trial when he was fired. So this is all very interesting. Those are all just my assumptions before we get into this. I'm sure they're going to argue the lengthy history of Proctor's character. He has and will always be disgusting and bad and terrible. And now I want to know what those text messages said. Please let it be admissible, or I won't be able to sleep tonight. I want to know what those text messages said, because if it is admissible, if Judge Canoni allows this, witness and all the things, then we might find out what those text messages are, and I could sleep tonight. If we don't, I'm no sleep. Come on, Yanetti. You know Judge Bev. You know what she likes. She knows what she doesn't
Your Honor,
like.
with regard, I assume we're just dealing with authenticity at this point?
No, we're dealing with both. You're the proponent of the testimony, so let's deal with both.
Okay, all right. So regarding authenticity, Your Honor, there are several ways that are either independent or connected with each other by which or through which a party can authenticate text messages. The majority of the case law out there are defendants having appealed judges' decisions to admit text messages offered by the Commonwealth, and the majority of the the case law that exists affirm judges' allowance of text messages into evidence. The Commonwealth filed a memorandum in opposition to these text messages being admitted, and not one of the cases cited by the Commonwealth apply here or are appropriate. The case of Commonwealth versus Purdy, in that case, the Commonwealth introduced text messages from computers seized at a massage parlor. The defendant objected that there was no evidence that he had authored any of these actually were emails, not text messages, any of the emails that were admitted into evidence. Nobody saw him do it. Nobody saw him type it, and nobody discussed any of the emails with him. But the SJC cited a longstanding rule, including Rule of Evidence 901B1, evidence may be authenticated by direct or circumstantial evidence. And the circumstantial evidence is essentially what we covered here in court today: the appearance of the electronic communications, the content, the substance, internal patterns, or other distinctive characteristics. Commonwealth versus Welch. It was a murder case where a boyfriend killed his girlfriend, was charged with killing his girlfriend, was convicted. The Commonwealth sought to introduce text messages between them, and various text messages from the victim's cell phone were admitted into evidence because, for one reason, they referenced the defendant's distinctive nickname. And in this case, we have.
I know why, because she's doing like the runnings of the rounds. I think there's like a printer like back here. I think that's like kind of like a fair game sort of storage area, and there's a printer. So she's probably doing a little running around for all of the things. So that's probably why she's not sitting there. It's just not enough space also for the folks that like have to be there. And so she's probably like watching everything, getting everything. Right. Yeah. So she can't sit there, but I feel like there probably could have been a way. Like like, I feel like, okay, tell me if I'm wrong, because you would know. So I think my problem in my brain is that the layout of this courtroom is terrible. And so I don't like that she is sitting there and is directly next to the podium where all of the things are happening, all of the questions are happening. She's got, I think, can she just be in the back room? Then that's not me saying go away and be in the back room. I think she should be somewhere else. But I know why she's there, because of the terrible layout of the courtroom, because she needs to be there to go do the things, but I don't like that she's there, and I would like her to be closer to the prosecution's table, which is as far, let's say, downstage towards judge, if the judge is the audience, as close downstage as possible, near Karen Reed's family. That's where I would like her to be, but she can't be there because if she needs to get up and go do something, like get something printed, et cetera, or this thing is happening, I just sent you an email, text message, fix it, find it, where are they, type of task-a-rooney, she can't be there because she needs to be able to like slip in and out. I don't like that she's there. Not that I don't like her. I'm sure she's great. I just don't like that she's there. But I know that she can. I know there's just really nowhere else to be, because there's no other option on the other side, because that's for the jury. So how do we fix me now knowing that she's there and not liking it for the rest of the trial? I think that's the question. They can always just call Proctor. They can always just call Proctor, but it seems like the defense is scared of what he might reveal on cross. I'm going to have to disagree. No strays. I don't think they are scared about what's going to come out on cross at all. I don't think they're scared about what's going to come out on cross. No.
We have a text chain with three.
Because in the end, he was, let's give into the Commonwealth. He was case manager, and now he's not even a trooper because of this case. I think the really shitty things that Proctor did will always outweigh anything that anything Proctor would say on cross. I think Commonwealth is scared, or they would have called him. Why did the Commonwealth not call Proctor? Why did I feel like that's a bigger question. It is not up to the defense to prove anything. It is up to the Commonwealth. So why would the Commonwealth decide to not call the case manager? He was the case manager. According to Buchanan, he did not do over 50%, so he was not, but still, he was the case manager. His name is on almost everything about this case. And I'm telling you, there has to be some jurors sitting there going, this man's got to be dead. Proctor's got to be dead. Like, he's got to be deceased. Because what do you mean? We don't know. We haven't heard from him. What do you mean? What do you mean we didn't hear from Julie Nagel? Everyone says she came in and out of the house. What do you mean we didn't hear from Julie Nagel? What do we mean you didn't hear from Ricky, when I catch you, Ricky, who drove the goddamn car? What do we mean we still don't have a conclusive time of when Brian Higgins' Jeep was there and then poof, was not there in front of 34. So there's those things. It's not, I don't think it is a chess move. They got all his evidence without him. Now, if the defense wants to highlight his text, they got to call him. And I don't think the defense calling Proctor would just be to highlight a text. I think it would go way deeper, just like the defense went extreme deep on, hey, how many CVs did you say you had a bachelor's on? How many CVs did you say you were still working towards your bachelor's on? Let's look at this. Let's look at the defense. I know what I can understand your viewpoint, but I think it goes way, way deeper than him sending a text message calling Karen a couple of names. It goes so much deeper than that. And we already saw one bad cop taking the stand. I mean, Buchanan, we already had the Commonwealth already had one cop take the stand who didn't even go to the crime scene for 3 days. Like that type of energy. They didn't want to add another one. They didn't want to have the fight. I think that they were a little too overwhelmed with everything else, that adding Proctor in would have just been a little too much. And yeah, they may think it's a chess move, but I think to the defense and the way that they would approach it and the way that they would fight Proctor and the way that they would put him on the stand and just air him out to dry, I think they see Brennan's chess move as a checkers move, and they're playing chess. Because even right now, they don't know if they're going to call Proctor. They don't have to. If they did, it would be a big moment, but they don't have to. They might, but if they did, it could really, it all depends, right? It all depends. Just like, is Karen Reed going to testify? Brennan's attempting to play chess by playing these clips of Karen Reed. Now, don't get me wrong. Do I think it was super idiotic that Karen Reed did all these interviews? Hell yeah. Absolutely. She did multiple interviews. She did a full fucking documentary. I think that was the dumbest thing she probably could have done. I get it. I get that you want to speak. But dumb. And I think it was dumb for Alan Jackson. I think it was dumb for Yannetti. I think it was dumb for Alessi. Anyone who said yes to go do it. Hell, Jackson was sitting next to her for some of them. No. Brennan's using some of these clips, and he's using them in what he thinks to be a chess move to try to get her to testify. He's pushing and pushing and pushing for her to take the stand, right? That's the end goal with those clips. And maybe to solidify, at least they get a DUI out of it or something like that. I don't know. But again, it goes back to my opinion. If there is going to be a DUI, what happens to everybody else? Everyone else gets off scot-free. Say 1 and 3 done. DUI, yes. Throw 1 and 3 out the window for this moment. 1 and 3, nothing. DUI, yes. What about everyone fucking else? So everyone else can just be driving around, fucking drinking and driving. But her. I hate it. I get it. I get why we're here. I get what's going on. I get it, but I can still hate it. I don't think it's necessarily that strong of a chess move to not call Proctor as the Commonwealth, because you are leaving questions hanging for the jury. Like, why did we not hear from Proctor? We heard from all of these names. And then they testified, except for some of these people. Like, why did we hear Jen McCabe? And then Jen McCabe testified. And then what happened? We didn't really hear her name that much, right? But throughout the whole thing, we heard Proctor. Constantly. We heard Proctor, but we never saw Proctor. And I swear some people think that he's dead. I swear there's a juror out there who's like, because the dude's not alive, but he can't have that conversation with with the other jurors because they're not allowed to talk about the case. So I don't know. If they call Proctor, I think it would be a very strong move, but they have to do it right. Yes, they have to do it right. Because you'd have to do the direct examination properly. So what Brennan tried to do with Buchanan was to very, very detailed, pinpoint detailed this, and this when it came to his direct, so that he could have the fight of during cross, hey, that's beyond the scope of direct. But they were able to wiggle their way through and get as much out of Buchanan as they could. The defense would have to do that with Proctor. They would have to be so very pinpointed, direct with their direct that what they did not want out could not come out, because if it was even approached by Brennan, it would be far beyond the scope of direct. So there is challenge there. There is a challenge there. Is it so much easier to cross somebody? For sure. And like, you can see that. Chessmate. You could see that when, Ella Jackson comes up and just like, for sure. But it'll be tough. I think that they could do it? Sure. Do I think it would benefit the defense? Absolutely. I think it would be absolutely beneficial to the defense to have Michael Proctor take the stand and read all of the things out loud that he said, that he did, that he texted somebody, that he got thumbs up from Buchanan from. I think it would be absolutely beneficial. Could it go wrong enough to hurt them? I don't think so. Could it go wrong enough to be a little confusing as to why they called him? Quite possibly. I can see the pros and cons. I can see it in my head. I don't know what they're going to do. And I think if they do call Proctor, they just need to be absolutely so prepared, like beyond prepared, like ready to fight a war. Now when it comes to Karen testifying, I'm always against it. I'm always against it. Do not take the stand. What, are you crazy? You already did all these interviews. What, are you crazy? All right, let's finish this up because I want to hear this. Welcome everybody. Hi, my name is Lily. Please subscribe. Baby channel here. Thanks for being here. Welcome to
3 nicknames, all of whom the witness recognized as being his friends. We have more to authenticate this text chain than in any case I have seen, and also more than in any case the Commonwealth has cited. In this case, we have an identification of every phone number pursuant to the last 2 digits. We have an identification of Michael Proctor's message relating to the contents. We have evidence of the witness's cell phone requiring a passcode, meaning that in order for his phone to be active in this chain, he would have had to have unlocked the phone with the passcode. And he testified that what was in the content of the message that he identified as being his is consistent with something that he would have said. And not only that, but he adds a 4th nickname, that being Chip, that being Michael Proctor. The Commonwealth, with regard to Commonwealth versus
how that nickname
Welch
came about,
which is again cited in their memorandum, this opposition, Your Honor, they state what appeared to be rock solid black and white legal principles, but when you scratch below the surface and you actually read the case stands for nothing in terms of what they've represented it to be. They stated that in Welch, the court must find that each and every communication was authored by the individual member of the group. That's just plain false. The case doesn't say that at all. It's nowhere in that case. And in fact, the messages were let in again because of the circumstances and the content of the messages. Commonwealth versus Raposa, another case that they cite. The defense sought to call a neighbor to testify that he had seen the victim alive after the defendant had confessed to having shot him, another murder case. The problem was that the neighbor denied making the statement, so the defense wanted to call the neighbor for the sole purpose of impeaching him with his prior statement that he supposedly made to the police and use that statement as substantive evidence. So in that case, the defendant wanted to use an out-of-court statement for its truth. It was rank hearsay. That case had nothing to do with text messages or statements used to show state of mind or electronic communications. But somehow it makes its
Your
way into the
vein.
Commonwealth's memorandum.
Your vein is
Commonwealth versus
popping,
Rajiv R, which is
Unetti.
the second to last case that they cite. That dealt with a search warrant done at a juvenile's home. The police officer in that case was allowed to testify to what he was seeking, which was the goal of the search warrant, a firearm allegedly in the juvenile's possession. And he was also allowed to testify to what the juvenile's mother did during the execution of the search warrant, which is she directed the police to the juvenile's bedroom. The Commonwealth cited that case to say you can't use hearsay when trying to prove a Bowden defense or present a Bowden defense. That case had nothing to do with Bowden. The evidence was admitted to explain what the police were doing in the home. So it's a situation where, there are times when, the police stop somebody on the street or the police get a search warrant and then they show up at a home. And rather than just have them magically appear at the home with the warrant, the police are allowed to give some circumstances as to how they got there. Nothing to do with Bowden. It's just giving the jury a fuller picture. Yet it was represented to you by the Commonwealth that, geez, this is a Bowden issue and you can't use hearsay to present a Bowden defense. Commonwealth versus Sullivan, exact same situation. Testimony was admitted about DNA on evidence matching the defendant's DNA from a national database. The Commonwealth cites three principles. It's almost like they're setting a standard down that the court is supposed to follow with three factors. But again, none of the three principles that the Commonwealth cites is found in Sullivan at all. They're not even mentioned in the case. They're simply made up and put in a memo to ask this court to do something that the case does not support. And again, it has nothing to do with Bowden. So now we come to the arguments about the fact that the Commonwealth is claiming that these statements are hearsay. They're not. These statements contain insults of my client. I'll be kind and just mention the word.
So I read them.
Yes. Okay. Well, I mean, Your Honor, if you're going to allow this into evidence, I'll stop talking. Otherwise, I have to make my argument.
I understand what you mean by insults.
Okay.
He said, so you get it. So are we done here? So if you're going to allow us, I need to go no further, ma'am. Just, okay. So are we done? We're good. Awesome. I mean, I can do more. I have more. But I mean, if we're good, let's call it a day. We'd love to go home to get dinner started. You know what I'm saying? Just kidding. I'm sure they're eating out of like bags and just throwing, snacks in their mouth and getting right back to work all day, every day.
Okay. So I won't even mention them then. The Commonwealth is essentially arguing that we're offering these text messages to show that the insults were true. That's a silly argument. Obviously, we're not. Hearsay has three components. These are all statements out of court. None of them are offered for the truth of the matter asserted.
I like the
None of
nutty.
them. Even the statement when Michael Proctor says that the homeowner is not going to catch any grief because he's a Boston cop. We don't know if that's true or not true. It's offered to show that Michael Proctor believes it's true. He's the lead investigator in the case. He has input into the case. He can decide who's investigated or not investigated. At least that's our argument. It's all consistent with our defense. It's offered to show his
It's getting
state
hot
of mind.
in there.
Everything
They
that
turn
he
the air
says is offered to
conditioning
show his
off.
state of mind and to show
Getting
his
very
bias.
hot.
He, as the lead investigator, his bias in what he does or doesn't do. And in fact, Mr. Brennan said a sidebar earlier when we started this conversation that Bowden deals with what was done or what was not done. We're entitled to explore what was not done, and we're entitled to explore why. We have evidence of why. We have Michael Proctor's words about why he did or didn't interview people separately, why he waited, for instance, a year and a half to interview a plow driver who was out there on January 29th, why he treated some people with kid gloves and other people.
I want to hear his words.
Brass knuckles. He's
I do.
stating it in these text messages. She's going to go down for this. We're going to pin it on the girl. We're going to make sure that there are some serious charges. She's effed. Those are what he says about, those are the statements he makes about Karen Reed in the infancy of this investigation. And to the contrary, is anything going to happen to Brian Albert? Nope.
And I want to read all of them. And I want to read all of those messages because if I want to, so does the jury. But the thing is, I know they exist. The jury doesn't. So I want to read them because I want to know what those text messages say, because I want the jury to know what those text messages say, because I want them to know who they're working with. Crystalline says she wants Karen Reed to take the stand. Crystalline wants to see Karen Reed testify. That is very
He's a Boston
interesting.
cop too. These are all statements about Michael Proctor's state of mind.
So bad.
The prosecutor and I have been over the statements. I realize he's objecting to the admission of these statements. I don't think he has a legal argument that passes muster to do that, but should the court allow them in, we're agreed on everything except for 3 entries, which I think we could deal with pretty quickly. And unless the court has questions, I'd rest on that.
No, but I'd appreciate a copy of whatever you've agreed upon.
Okay.
So it's been a long day for staff, so I don't need to sit here and go through each one. Just get me a copy of what you've agreed to.
Okay. So this is the only marked copy. I'm happy to hand it to the court.
And you can take care of it and email it in.
We'll do that. Thank you, ma'am.
So, Mr. Brennan, I'd like to hear you on admissibility. I haven't decided admissibility, and I'll hear you on authentication.
On the first issue of authenticity,
Hmm.
this witness has no memory of any of the text.
Well, Proctor, if the argument is Proctor was biased, call him so he can explain. Can't use just his text. That's hearsay. Well, they're literally arguing that now. That's literally what they're arguing for Judge Cannoni to decide. She hasn't decided, yes or no. It's literally up. It's literally up for argument. So let's see what Judge Cannoni
The text messages.
decides.
I think it's fair to conclude he's on the text message string. He recognizes.
I would love to hear these text messages. I would love to hear these text messages. I mean, Buchanan liked the text message that came into his Apple Watch. And he was able to explain it. I would love to see Proctor on the stand. Don't get me wrong. Me saying all the pros and cons of calling Proctor. I want Proctor on the stand. I want to see that man sit there outside of being a trooper with the safety net of not existing. There's no trooper safety net. There's no state police safety net anymore. No one's going to catch him. The only reason they caught him the last time was because they needed to fire him. They needed to do some digging. And if Trooper Proctor takes the stand, what's the probability of some of the reasons extended from I got fired because I sent a text message comes out? It's way more than just a text message.
Recognizes the people on it.
Minimizing it, minimizing his actions, minimizing his bad policing down to a text message is disheartening. I think it's untrue and it's unfair to the actual situation. He went through many channels to not be a good cop. He made an effort to not be good at the job, and it bit him in the ass, and he no longer does that job because of how he carried himself, how he investigated, how he spoke to people, how he communicated, how he handled cases, how he managed cases. You know, it's way more than just a text message.
But there is no authenticity if he doesn't recognize them. The person that could best authenticate these text messages is Michael Proctor. This witness does nothing as far as identifying the individual text messages and whether they're reliable, whether there's been any additions, deletions, whether in sum and substance this is part of the conversation. Notably, I think, according to the questioning by Attorney Yannetti, he's made one comment at the end of the string that really has nothing whatsoever to do with the text messages that are at issue. So authenticity, I don't believe this witness reaches that conclusion for them. Regarding admissibility, I do not dispute that in the right context, these text messages are admissible. If there is an investigator in a case that makes derogatory remarks about an accused, I can't say that doesn't go to bias, nor do I reject the idea that it shows an unfairness or a motivation. But really, you need to put that in context. And I think Attorney Yannetti highlighted that. He says that this is not.
And he just told the internet why he did not call Proctor. He just told the internet why he did not call Proctor, because he didn't want these things to be determined of Proctor.
Authenticity, I don't believe this witness reaches that conclusion for them. Regarding admissibility, I do not dispute that in the right context, these text messages are admissible. If there is an investigator in a case that makes derogatory remarks about an accused, I can't say that doesn't go to bias, nor do I reject the idea that it shows an unfairness or a motivation. But really, you need to put that in context.
And 2, he's going to argue context, which is quite different, but that's why he did not call Proctor. He didn't want the case. He didn't want the case against Karen Reed. He didn't want this trial to be that, when in reality, it was. Because you can't have the case against Karen Reed without Michael Proctor. You can't have it. I say all the time, two things can be true at the same time. This one can't. This one can't. You can't have the case against Karen Reed without Michael Proctor.
And I think Attorney Annetti highlighted that. He says that this is not hearsay. It's how he thought, or whether it affected a particular part of the investigation. It may have, it may not have. Even if he denies that it affected his investigation, it's still an appropriate question to ask, just because that type of negative commentary, inappropriate commentary was made. But to explore the state of mind and put it in context, you need to ask the person that you're accusing of having the bias, because perhaps it did affect the bias. Perhaps the person was very biased and made decisions based on that animus. Or perhaps the person made negative comments but had nothing whatsoever to do with the investigation. It is surmised to say, because these comments were made, a witness was not investigated, or there was some other amorphous, undefined ill that happened. That's the whole reason why the witness who made the comments should be confronted with the comments they made, so the jury can fairly assess, is this relevant? Is it material? And what is the value of it? I am not opposed to the admission of bias against a witness, especially a police officer, but it should be against that witness, because they need to have the opportunity to admit, deny, define, accept, and explain. By putting these messages.
And I did not call him, so he shouldn't have that, is basically what Brennan's saying. Then call him. You know, like he's saying, I didn't call him, so he's not getting that from me. He's not getting the chance to explain these text messages. I didn't call him. You can call him. He's trying to play that chess move. You can call him. Go ahead, call him. Call Michael Proctor. Call Michael Proctor.
Messages in with sidestepping, calling Mr. Proctor. They are trying to gain the advantage of putting information in front of the jury that has no context, suggesting it has a value that has not.
Hold on. Let me go back. Did he just say sidestepping, calling Michael Proctor? Homeboy, you just put your entire case in chief.
Accept and explain.
Without Michael Proctor.
By putting these messages in with sidestepping, calling Mr. Proctor, they are trying to gain the advantage of putting information in front of the jury that has no context.
So, that's funny.
Suggesting it has a value that has not been defined. And then, as Mr. Annetti just did, making an argument that because the comment was merely made, that therefore there was a consequence, and specify a consequence where there's no factual basis to conclude. Because he made a derogatory comment, he didn't investigate or speak to a plow driver for a year and a half. That defeats the purpose of finding the value for which this is being admitted. I do have some issue that it's really not under the context of Bowden, because this doesn't have to do with the adequacy of a police investigation. It has to do with bias. And that purely is the state of mind of the person who made the comment. I would not get in the way of confronting the witness about their bias if they were called to this.
So what are you, Brennan, if you outbalance that bias by not even calling him? Are you somehow now biased in the opposite direction, but you still are prosecuting this case? You are if with okay, blah. The Commonwealth did not call Michael Proctor. So they are saying, hey jury, here's all the information. Here it is. While Brennan is over here acknowledging that bias exists. I don't know if this is great argument. I mean, I really hope Judge Cannone is actually listening. Like, listen to the words.
Police investigation. It has to do with bias. And that purely is the state of mind of the person who made the comment. I would not.
And does bias not directly affect the adequacy of the investigation if the investigator is a police officer and the police officer is biased?
Get in the way of confronting the witness about their bias if they were called to the stand. But to put it in this way invites speculation, it invites manipulation, and it invites a party on either side to portray this in a way that is not factually viable. It will be distracting, confusing to the jury, and it could be unfair for either side, because it will lead to our
kind of like calling two witnesses who were in a car about the maneuvers made by the car, but the two people that you called were not actually the ones driving the car and drunk.
It will lead to arguments about what it means without a factual basis. And so my position is, I don't necessarily disagree that it's relevant, but it should come through Michael Proctor. And if the defense wants the value, they should call Michael Proctor.
Mr. Annetti, do you want to respond?
I know we're making I won't belabor the points. I would state the following very succinctly as I can, which is, yes, it goes to bias, but it also goes to the adequacy of the evaluation. The two concepts are intertwined. If you're biased or exhibit bias, the defense should be able to argue that the investigation was not adequate. I would note Mr. Brennan is not.
Oh my God, should I be a lawyer? I'm just kidding. Stop. Ew. All right.
The following very succinctly as I can,
Sorry,
which is,
I just went back.
yes, it goes to bias, but it also goes to the adequacy of the evaluation. The two concepts are intertwined. If you're biased or exhibit bias, the defense should be able to argue that the investigation was not adequate. I would note Mr. Brennan is not sitting at defense counsel table in this case. We appreciate the offer to help us with strategy about which witness we should call, but that's solely the province of the defense to determine which witness we want to use to authenticate and admit text messages. That's our choice. And we should not be deprived of that choice because Mr. Brennan thinks there's a better witness that should have introduced the text messages. There is no rule. There's no best witness rule in this case. I believe my co-counsel has already made that argument in another circumstance. His arguments, Mr. Brennan's arguments, go to the weight, not the admissibility. He is fully entitled to cross-examine this witness about all of the points that he raises. And in conclusion, Your Honor, he complains that we have not called Michael Proctor. I think that's the whole impetus for this objection, so that we will call a witness that they do not have confidence in to call themselves. It's unheard of in a murder case that you don't call the lead investigator, but that's what's happened in this case. We should not be forced to call.
Unheard of. Unheard of is what if a jury was here they would hear, but it's not. But they're not here. We are here. We are us. This jury is here. The jury is not here. Unheard of. Unheard of. We are literally almost done. I'm going back 10 seconds. It's the last time, I promise.
So that we will call a witness that they do not have confidence in to call themselves. It's unheard of in a murder case that you don't call the lead investigator, but that's what's happened in this case. We should not be forced to call Michael Proctor so that Mr. Brennan can then cross-examine him and lead him through basically his entire closing argument. He is entitled to call Mr. Proctor in rebuttal. He has every right to call Mr. Proctor again. I would rest on that. Thank you.
Okay, and just the very last thing, there's Commonwealth's motion for reciprocal discovery. Is there any objection to that?
Yes, it's not in compliance with Rule 14.
Okay.
We don't have any communications with Endeavor, and they've asked for all communications to be reduced writing. We told her that's not.
All right, so you're saying two different things. So you don't, this information doesn't exist because she has not had communications with you, right?
Written communications do not exist unless scientific commands. Written communications do not exist. They also ask secondarily for all oral communications to be reduced writing. We would have all those.
All right, so I'll get a decision out on that before 4:30, and I'm going to do a little more research on the text messages. Want to be heard, Mr. Brennan?
I thought you were standing up, Your Honor. No.
Oh, no, okay. All right, I'll see everybody Monday morning.
Thank you.
Ew, ass kisser. Brown noser. So that last bit was about a motion filed by Hank Brennan about Ms. Stever, communications, all the things. Anywho, which I don't know, whatever. Deal with it, guys. Deal with it. Very interesting. I'm glad I caught that argument when it comes to the admissibility of these text messages that oh God, I have to get his name. He deserves for me to say his name right. I am not Brennan. Jonathan Diamandis. They want to bring text messages in from Proctor through Jonathan Diamandis, who is a longtime friend over 30 years, et cetera, et cetera. So we just heard the argument on that. And he made it very clear to Judge Cannoni that it is like it's unheard of for the lead investigator to not be called in the case in chief of a murder trial. It is quite interesting. It is a little bit on the groundbreaking side. Brennan has acknowledged his bias, but makes the claim that the adequacy of an investigation is not controlled or affected by a police officer's bias, which I would like to beg to differ. If you were a person of color and the police officer has a massive swastika tattoo on his wrist, I would say that there is a level of bias there that could probably put your life in a little more danger. Things not be handled properly as true, but it would have to come down to the investigation and looking at it, each detail. And that is what we are doing here, right? We are looking at every detail possible of the investigation. That's the point. That's the point of the trial. And if the jury is able to recognize the biases and connect that to the level of adequacy. How adequate was this investigation, even without Proctor, and seeing a level of inadequacy? Then maybe calling Proctor wasn't necessary to say, hey, look, this wasn't done quite right. Do you understand? I have a few friends that are cops. One arrested a guy who committed essay against a child, and off duty, he called the guy every name in the book. He wasn't being biased. He was just being human. Fair. You can do that. That's fine. But you run the risk of being in a situation where if you need to go to trial, your reputation is on the line. If that is in written form, text message, email, Twitter thread, then you are running the risk, human or not. You are doing a job, and you are putting the stability and the accuracy of that job at risk by just being human. You are always human. But if you sign up for the badge and you say, I am here to protect and serve, say those things to the wind on your way home. Roll your window down on the highway and say those things to the wind, because you are putting everything that you have worked for at risk for that. Because if it comes out and you're taking the stand and it's like, oh, well, did you call this guy this, and this, and this, and this, and this immediately after you made that arrest? Yes, I'm human. And it looks bad. I know. I'm sorry. I shouldn't have done it. Okay, but let's go back to another case. Let's go back to another case that you got. Let's go back to a case where you had to do some investigation before you made an arrest. Let's go back and go back and go back. And you, every time you have a case, you're calling someone this, and then you arrest that person. It's putting a lot at risk unnecessarily. Say it to the wind. Say it to the wind on your way home is my suggestion. I mean, I don't want to make a suggestion to the cops who are super cool leading into their bias, because I would like you to be caught and handled and dealt with Proctor style. That's it. That's all I have for today. It's been a wild day. We had a very interesting start to the defense's case in chief. If you are new here, please subscribe. That would be fantastic. It's nice to meet you all. My name is Lily. I'm the Chatty Juror, foreman of the jury. We chat a lot. So if you're not interested in the chatting and you just want to watch the trial, court TV, and law and crime, but I am here for the chatting. I am not a lawyer. I'm just a person who loves court. And I like having conversations. I'm sitting on the fence. Sometimes I lean one way, sometimes I lean the other. Ask questions. Let's have the conversations. Let's communicate like humans. And actually talk our thoughts out. And I love it so much. I love having a space to do that, especially with this case. It is absolutely absurd. So if you'd like to subscribe, feel free to subscribe. Make sure you like, that'd be great. And I will probably see you guys in maybe like a little shorter video in a day or two or something like that. I'm becoming super busy, which sucks. The timing of it all really sucks when it comes to this trial. I'm going to do my best to keep updated, and when I'm here, turn on notifications, because I cannot make a guarantee, but I'll probably pop in Monday afternoon to do a sort of where we're at on a Monday situation. Anything before I go? Anything we need to know? Anything we need to talk about, chat through? Happened on the stand? Happened not on the stand? IRL? What are we having for dinner type of thing? Anything we need to do before I go? Because if not, I'm going to head out. Breaking news, Hank Brennan won the motion. Did it come out? I will hear it from the judge's mouth. She said before 4:30. It's 5:00. Is it written? I'd like to see the either written motion, and I'm not going on Twitter. I'll find it on the website. And if so, all right, then call Proctor. It's online on the court website. Okay, cool. Call Proctor. They can handle it. There's 4 of them. Warner Brennan, I don't count Lally. Sorry. Is that mean? I can't count Lally. Like, there's 4 of them, Warner Brennan. I can't count Lally. They're doing that so loud over there. Okay, I gotta go. I'll see you guys next time. Thanks for being here. Thanks for watching. See you later. I'll play my intro as my outro because I did not play it as an intro. Catch you on the flip side. Law dorks. It's not, I didn't mean that to be mean. It's just a okay, bye. Love you.